Thank you, Farrell, for letting me know that I'm muted. Oh my goodness. Could I be any dumber? There's a button on my microphone here. And when I press it, it makes a clicking sound, but then I know when I talk that it says you are talking, but I can't hear myself. But if I use the one in front of me, then I can hear myself, but you can't hear me. So I'm sorry. So, what I was explaining, we won't need to go over. There's some really weird thing with Restream and it says upcoming, but then when I go live, it doesn't dump me in the upcoming live stream. So like June was sitting over there and I'm like, no, we're here. And then I deleted it quick. So now I'm going to go ahead and share it once we get started. So hello to everyone. Welcome back, Crime Spies. Who's ready for another cup of injustice? Yeah, I just have to remember to use the button. It's just so clunk, clunk. I wish I didn't do that. This episode is dedicated to ASL. Oh, I did not know that. Thank you for letting me know. Now we can. Hello, Moni G. Farrell. Lawkong Express. I cannot listen to Wrongful's final episode until we get to closing arguments. All right, so we will cut. See, and I don't know how to fix that either. You know, I'm ahead of the curve when it comes to certain things, and I'm behind the curve when it comes to other things. At least I've got the bot programmed, so if any people have wrenches, they can just come in, kick back and relax, and don't need to worry about. I'm trying to pay attention and see if there's any ones that I missed, and I will add them accordingly. I'd like this to be just a chillax, you know. I was tricked again. Oh, I know. Sorry, June. June, I don't know how to fix that. So, at least I didn't share the wrong link. Well, and maybe it's just something I'm doing wrong, but you'd think it would just lunchtime lurker. I read that on the other one, but I was muted. I don't know how to fix that, but I'm sure I'll figure it out one of these days. So from now on, when there's a live stream and I actually go live, I'll put the link to the one that it goes to in the one that's scheduled and delete it, just like I just did. I don't know how else to do it. And I don't want to go back to disconnecting the restream thing because then you're not getting the faster bit rates or kilobytes per second and or frames per second. If it's direct connected, I get much faster. You should be able to stream this in HD. Well, I'm only capable of doing it in whatever they're doing it in, so we don't have any other choice. But if it's in HD, you should be getting it in HD also. For those of you watching on Rumble, make sure to click the gearbox on the bottom and switch it to 4.5. 4.5, what is it, kilobytes per second? Farrell. Well, yeah, you started working last night when we were doing that Kaylee Anthony thing. Oh, and another thing I was just going to mention very quickly is there's that Gypsy Rose, what's it called? Mommy Dead and Dearest, I think, on HBO. And I might go hook up my MacBook to my other monitor and put that on Rumble because I've already seen it 2 times. But that way you could watch that. I thought it was really interesting because even Dee Dee's mother, even Dee Dee's dad in that one and her stepmother both said Dee Dee got what she deserved. Apparently there was some suspicion around Dee Dee's own mother dying in the care of Dee Dee. And I think her cousin also said the same thing. But I might do that either today or over the weekend. So it's streaming. You won't have me talking over it, but I can do I've done that before where I've had like I've had like a subcommittee and a trial going at the same time. So I hook up both. They're both going at the same time. So, all right, there's a couple of things I wanted to do. One is go over the witness list today. It looks like we're going to get a little bit more of our quote unquote lead detective, Vincent Correa, and then we're going to get Julianne Avila, crime scene response specialist, Nathan Hensley, Rosalio's neighbor, Jennifer Ziegler, Rosalio's neighbor, Kim, another one of Rosalio's hoes on the ho 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 ladder, um, James Kendall, financial crimes detective, and then Munch returns, the snitch, and it looks like we got another former cellmate. So that's for day 13. Then day 14 is, so today's 5 hours. Day 14 is 3 hours. Closing arguments is 3 hours. I'm assuming the verdict is then next, and then the sentencing is after that. So what I did is I just planned for 3 live streams to start like around the same time today, Saturday and Sunday, and then we'll just keep going till we get tired and see what happens. Like I said, all of you have already seen this trial. It's my understanding. So, you know, uh, if there's, I know Gypsy Rose trial is being rewatched. Although I tried to watch a little bit of it yesterday, and even though Vielhammer has like fixed the audio, it wasn't very good audio. I get a headache from that kind of stuff sometimes. Okay, so then another thing I wanted to do, if I can find it. Let's see if it did it right. And then we'll get going. Let's see. Alrighty. Let's see. Oh, I gotta fix the bottom. But other than the top line, it's pretty good. All right, so just a reminder for those of you on Rumble, if you feel that you would like to do a Rumble rant for the duration of this trial, and I would rather have you go to this GiveSendGo link underneath in the description box. This is, we're still at 47,000, so that's what we ended with yesterday. They're only $3,000 away from their ultimate goal of $50,000. I know times are tough. Yesterday I went to the grocery store to pick up my prescription. I needed coffee, and Folgers Black Silk Coffee, all Folgers brands actually, was $11.49. Not the big giant tall like double decker one like they have at Costco. Just, your regular old Folgers. $11.49. So, um, the one thing that I want to express is times are tough. We just got done with Christmas, what have you. They have non-monetary ways that you can contribute to this, meaning you can share it on your social medias. You can encourage people to come and watch it, watch the rewatch. Frankly, if I were you, I'd watch it on an attorney's rewatch because I'm an accountant. What do I know? But share it. Make sure people are watching like the Soloman Anderson interviews, and there's prayers too. God listens to your prayers, and answers them. I hope. One of mine is that Graveley gets disbarred, but we'll see if that happens. Karma sometimes takes a while. Let's see. And then, okay, so then we've got a link underneath for Vielhammer Media. If you have an opportunity, click on his playlist here. This link here says playlist that we're using. And if you could just copious free time, just like click the thumbs up, hit next, click the thumbs up, hit next. Make sure you're subscribed. He's got several great trials. I know the other day when I was on Detective John's chat, something totally unrelated, Eileen Warnes came up. And I'd love to watch that trial. He's got her testimony, 2 days of testimony. So, but he's got all kinds of things. So if you could do that, that helps. Then also we've got our free Zachariah Anderson website. I'm gonna try to as appropriate while we're listening to testimony. I started it earlier in the week, kind of pulling up a side-by-side screen as I find things. So I'm going to try to do that again today. Then the Wrongful podcast. Dum dum dum. Episode 6, the final episode dropped, and I can't listen to it. But here's their link tree, and then also here's a link to the podcast awards. I know they are eligible for, I think the end of February is when you can start voting. Actually, so it'll be the 19th one. But look at all these categories. So we got female hosted podcast. They would qualify for that one. And then also there's a true crime one. And they might actually be qualified in some of these other categories. So there's that. And I should change that to 19. Okay, and then here's the GiveSendGo again. We've got a link to Lawkong Express's channel that looks broken. I don't know how. Look at, see? And then Broken Baker. Here's the interview with Soloman. Here's David's interview with Soloman. What's a Denny motion? Where's this link? Steve Gosney's interview with Tiffany Roy. Our Christmas christenings. And the more broken channels. I'll fix it. I don't understand. So, now. Hi, Broken Baker. Your link is broke. Your Broken Baker broke it. You got a broken link in here. My copy and paste didn't work. I think YouTube intentionally just tries to make me look really dumb. And Broken Baker covered the Karen Reed hearing this morning. I was in there for a while in my usual disguise. Although you guys are getting so smart. I've been doxed, let's say. All right, here we go. Buckle up, buttercups.
Date. And let's continue with the...
Sorry, we must do two things. The first one is this. And second time, in case you were in Fraser Crane mode and you're like, I want to see that again. There. Just for all of you. Stray, I love that with the dance and the orange. I love that. I did want to also put up, we had to change this. Let's put it back in non-studio mode. It is now day 1327 that Zachariah Anderson has been incarcerated. I got the link again here. It's in the description box. Non-monetary contributions such as sharing and prayers. And it is $3,000 away. So we're so close. And we'll pop that up when we have breaks. All right, now we're ready to roll. We're on a roll, gang. Like my accounting teacher, I can never remember what his name was. We're on a roll, gang.
It's presentation. Be my guest.
That reminds me of that. What is it? Beauty and the Beast, that song.
Detective Correa,
Oh, Dingleberry, here he goes.
You were asked some questions by the defense.
I will say last night when we were watching that Kaylee Anthony thing, one of my loyal Rumble watchers, Dr. Pyrostein, he does claymation. And so I said, hey, if you ever have some free time, because I know he's like watched some of this on Rumble, and I said, in your copious free time, if you would like, you could do like a claymation of Mr. Dingleberry here, and then like kind of a la Indiana Jones, have like this big giant orange, like run him over and like splatter him. I think that would be funny. All right.
Defense about whether there were periods of times where any calls
chain of custody is in
missed,
freezer crane mode.
Specifically,
I appreciate you
by the defendant, specifically using the A&S phones. In other words, calls he did not answer. Do you recall that line of questioning?
Yes.
And do you recall that during the testimony in this case, the state's focus has been on a specific time period, which was May 17th in the evening hours from around 7:34 p.m. to about 11:19 p.m. Do you remember that time period is a period that we have focused on?
One more thing. So I don't know. Actually, I am monetized on Rumble, and I have a couple emojis, I think is what they're called. I've got one for Mr. Pitbull. I've got one for Representative Clay Higgins out of Louisiana, because I call him MFH, my future husband. I'm teasing. I mean, he has been married 4 times. It's possible. They don't come in very good resolution, but I do have on the list to make a Fraser Crane mode one for over there. So then it's just easy to put over here. I want to do a pause one too. Soup will be the default. Soup will be the default. Soup. I don't know what that. Oh, you know what I could do also as a sus bus one. Oh, we're going to be able to use the sus bus today because we've got Mr. Washington coming up. Whee! All right, here we go.
Correct.
And so as to that time period on May 17th, are you able to indicate, based on your review of all the materials, is that a time period where the defendant, just as the defense mentioned in the time periods they asked about, where there were no phone calls answered on that A&S phone? Is that also a time period where that was true?
Yes.
But did you further review to see if any calls during that same time period, around 7:34 p.m. to 11:19 p.m., did you find that there were also no calls?
Oh, I know what I did. What I was meaning to tell you. Just a moment. So I was dancing with the devil last night when we were watching, and just out of, pure curiosity, I plugged in just the, hour and a half-ish transcript of Detective Correa's testimony, and I saved it as a PDF. I might have uploaded it on that Discord thing, but I just wanted to show you it's on my X page. I thought it was interesting. Or not. Just a moment. Here. So what I did is I plugged in the transcript and said, like summarize questions and answers. And then I said, explain where the defense can have reasonable doubt. And actually, it wasn't bad. Limited search of vehicles. Witness mentions very brief search of Mr. Gutierrez's vehicle for tracking devices due to rain, etc. Aerial and foot searches. The lack of detailed analysis might be used to suggest important information could have been missed, and so on. I will go ahead and put this back on, or I don't know why I didn't plug on, attach. But I don't know if anybody who's really closely related to it, I mean, if that's something that could possibly be used as a tool, maybe. Sometimes when you look at things so many times, you don't see it with like a fresh set of eyes. Not saying ChatGPT is, because I think it's kind of Ouija boardish. That's the vibe I get. But I just thought maybe that was the one thing I could figure out, like from trying to copy and paste the transcripts in. I'm like, I wonder if you could. It's kind of time consuming because you can only do so much at a time. And each transcript I've downloaded is like 60 pages. But it would be, I don't know, it might be interesting or worth a try. I don't know. Dancing with the Devil. Dance with the Devil is ChatGPT. I used ChatGPT this past summer because Ian Runkle had AI generate hot sauce brand for him, and it was called She Fancy. So I had ChatGPT write a poem for him called She Fancy, How I Love Thee. Ode to She Fancy, How I Love Thee. Other than that, I haven't really used it, but like I said, it kind of freaks me out a little bit.
That were either made or answered on the Moto G6 phone during that period of time.
That's correct.
And did you also find during the time period we're speaking about that not only were no phone calls responded to on the ANS phone, but no phone calls were made on that phone as well during that time period?
Correct.
And then I'm going to ask you about texts. So as to any of the devices that you are aware of that the defendant possessed, were there any texts that the defendant answered or that his devices answered, or were there any texts sent out on those devices during that time period of 7:34 p.m. around to 11:19 p.m.?
There were not.
Now, were some texts received that were not answered during that time period?
On the ANS phone, yes.
Okay. And then finally, were some of the electronic devices, or at least one of the electronic devices the defendant had, ones that could be utilized for internet searches?
Yes.
And as to the devices we've talked about, was there any evidence of any internet searches done by the defendant, again, on May 17th from 7:34 p.m. to 11:19 p.m.?
No.
Okay.
Okay, it's on my X now. It's underneath yesterday's live stream, and it's a screenshot because apparently you can't upload PDFs. At least I think it is. Yeah. So you should be able to open it and read it. Like I said, I don't know if it's worthwhile, but for kicks, I thought it would be interesting. I'm a Virgo. Although I don't know what my moon sign is or which planets were rising, etc. I have a book downstairs. I'm a nerd. That's it. I'm a nerd.
So I'm going to ask those same kind of questions about not just the ANS phone and whether it missed calls, but about all those other ways that a person can show that they are aware, awake, involved, right? So I'm going to ask about all of those kind of devices as to, in response to what the defense asked you. So do you recall the defense asking you on May 5th from a time period that I think ended up being around 11:15 a.m. to 3:30 p.m. Do you remember that being brought up by the defense?
Yes.
Okay. And your testimony was, based on the exhibit you saw, that it did not appear that any ANS phone calls were answered during that period of time. Is that accurate about what you testified to previously?
Well, I believe there was
I'm saying
it
just
began and ended with calls, and then in between there were none.
Okay.
Correct.
And so that time period covered was 11:15 a.m. to 3:30 p.m. around, right?
I believe so, yes.
Okay. So I'm now going to show you what's been marked as State's Exhibit 350, and this is regarding the Moto G6 phone. You set up a sheet phone, put it there. Show you first, I'll start with the first page of State's Exhibit 350. Again, does this appear to be phone records regarding the Moto G6 phone, essentially the secondary phone of the defendant, covering the time period of that 11:15 a.m. to 3:30 p.m.?
Yes.
And during that 11:15 a.m. to 3:30 p.m., were any calls made on this Moto G6 phone of the defendants? Did that phone make any calls out?
Yes.
And when did that occur?
That was May 5th of 2020 at 12:08:45 p.m.
Okay. And then were any texts made from this phone during that time period?
There was.
Okay, and that again was on this same phone, the Moto G6?
Yes.
And so when did this phone text out during that time period that counsel was referring to?
12:17:22 p.m.
And then is there further a web history, meaning this phone was used to access the web during that same time period, between 11:15 a.m. and 3:30 p.m.?
Yes, there's a web history beginning at 12:25.
Okay, so if you review that page and then on to page 2, can you tell when that web history ends, as best you can tell from this exhibit?
Based on this exhibit at 12:34:13 p.m.
So that's, if we don't just ask about the ANS phone, if we ask about other devices, all of that was activity during that same time period. Is that correct?
Yes.
Okay. So let me, I think that you were also asked about a different time period, a May 10th time period. Do you recall being asked whether you saw any activity on specifically the ANS phone on May 10th from, I think it was around 3:48 a.m. to 1:30 p.m. Do you remember that time period being a time period you were asked to consider about whether phone calls had been answered?
I recall the times in the day. I don't recall the exact times, but I do recall being asked about that, yes.
And did you, but you weren't asked about whether, other than calls, whether there was any communication on any device. Is that right?
Correct.
Okay. So again, as to that ANS phone, did that phone also have the capacity to text out, at least on occasion?
The ANS phone?
Yep.
Yes.
So I'm going to show you now what's been, well, I'll just ask, did the ANS phone, I'll show. So I'm going to show you what's been marked as State's Exhibit 349.
Joe Giacalone.
Ask you if that
told him
appears to be a text on the ANS phone during that time period that you were asked about. Does that appear to be a text that went out on that phone?
Yes, there was a text message.
Hi, Scott.
2020 at
Welcome back to Crime Spice.
a.m.
Thank you. You were asked a question about
part of it.
A tip that had come in regarding a person in the proximity of Rosalio Gutierrez's patio on May 18th. Do you recall that?
Yes.
And what were any considerations you had about whether that should be followed up or whether it could be followed up?
There was no information to follow up with the person who had called on it. So we had really no direction as to who to follow up on. There are no video cameras located in that area of the apartments, or actually in the apartments at all. So there was nothing for us to follow up on that end either.
Based on the existence of a number of cigarette butts, was Rosalio Gutierrez's patio in close proximity to an area where a lot of cigarettes were being smoked outdoors?
Yes, directly adjacent to his patio.
And was it heavily raining on May 18th?
That whole period of time it was raining, I can't say specifically during the middle of the day that it was raining heavily, but throughout those 3 days it had rained heavily, yes.
And did Rosalio Gutierrez's porch area have some sort of a sheltering?
I object to relevant. That's where the final question is going.
Was there some sheltering over the patio area of Rosalio Gutierrez that would be within a few short steps of where people were smoking?
So above his patio would have been the deck area of the upper apartment, the upper unit.
And how many steps would you estimate that was from where the smoke?
Okay, so just one piece of the last night, Kaylee Anthony, the case of Kaylee Anthony thing. You know, they kept saying, you know, her body was found, although it disgusts me that, you know, let's say even she did die accidentally by drowning in the pool. That girl deserved a embalmment, a coffin, a proper funeral, not to have roots growing through her skull. It's so disgusting. But I thought this was interesting. Part of the defense for Casey Anthony was they could not determine how she died. Okay, well, they had a body. How in the Fulk did this go to trial? They have no body. They can't tell if Zachariah ever met this guy, let alone unalived him. How in the world did this happen? And you kind of like, if you apply that, like the judge that presided over Casey Anthony's trial, at the very end of it, he's like, you know, jurors always consider guilty or not guilty. They don't ever consider the third option of we just don't know. This is unbelievable. Unbelievable. There. Now you've seen me angry again. I said I wasn't going to be angry today, but it's just they've got nothing.
Location appeared to be.
And then yesterday when he's like, yeah, it was raining and, you know, we didn't really crawl underneath his van. Really? Have you ever heard of a tow truck, sir? Maybe like, you know, tow the vehicle into like somewhere where you can look. And another thing, like I think it was when they went to Zach's house, they're like, yeah, I wasn't there very long, like 25 minutes. Really? Huh. So you're on a time schedule when a man's life is in your hands? Idiot. There, no. That's the extent of, I'm going to try not to be angry today. It's very difficult.
His patio is directly adjacent
Josie's
to
here.
where the grass area is.
Nick is here.
You were asked about an area. I don't know if we ended up deciding whether it was 1 or 3 blocks, but a area that has a few trees. There were some trees that's in the close proximity to Wood Creek. Do you recall that question?
Yes.
During all the time since Rosalio Gutierrez's bloody apartment was found, has there been any bodies or body parts that have turned up in that location?
No.
Another thing I've observed, Josie says, why when Zach was navigating to Rosalio's, it counts and he was definitely there. But when Rosalio navigates to Zach's, we don't know if he went there. You know what? I find extremely, well, I mean, the list of frustration has no limits in this. But, this could have easily gone the other way, in my opinion. When Brandon and what's-his-face, Michael, showed up at Zachariah's house, you're telling me those guys didn't have heat in the car or on their person? Question mark. The text messages between Rosalio and Sadie about a broken leg. I mean, that shows premeditation towards Zachariah. And yet nothing happens. It's just so horrible. Korea seems to be absent on day 14. I think he's, like I asked Detective John when he stopped in over like Christmas, I think it was, as a former detective who actually, he was a responding officer on George Anthony's, when he was at the hotel and was going to unalive himself. Detective John was one of the responding officers for that. I thought that was super interesting. He's from Daytona. Anyway, but I asked him, doesn't it make a good detective like yourself disgusted when detectives don't do their due diligence? My opinion, same thing happened with that Kaylee Anthony. That the meter man was able to find that her body months before. 3 or 4 times. Karen Reed is another one. I'm not entirely sure where I waffle with that one. Detective John did a Dummy Dan demonstration. But the whole thing is, I'm getting the vibes with that too. Like, investigation wasn't done accurately or at all. And another thing that really chaps my hide, if you really want to know, when I was looking at this, Dingleberry the other day had mentioned something while the jury was there, like, we're ready to, be done with give you guys some relief, jurors, we're gonna be done here shortly. And then since then, he subsequently kind of keeps saying, like, okay, move along, defense. I mean, they should have just as much time. And just like in my head, I was like, here we are, day 13. If you add all this together, it's like 50 hours. And the defense gets what, 7? It's so unfair. And, actually, to be honest with you, because this was televised, how many millions of people watched this trial? And he sits in jail. I mean, there should be picketing peacefully. Squeaky wheel gets Squeaky wheel gets the grease. God. It's just. And another thing I've mentioned before, how many trials are not televised and have shoddy investigations, overeager prosecutors? It's just disgusting.
And You were asked some questions about the searches at the different locations, in this case, including a tree farm described by the defense as the Anderson Tree Farm. Were there work boots in any way associated with the grandfather that were found at that location?
No.
And also not at the lake house, the Belgium lake house from Ms. Brown Williamson?
They were not.
And then what about at the defendant's home? Were there a separate and distinct pair of work boots that would have been grandfather related?
There was one pair of work boots that was located.
And you were asked some questions about the missing persons database nationally and the ways that, that would be reflected officially, right? That you've kept that open. Is that correct?
Correct.
And if the police department has referred this as a homicide, made a decision this is a homicide, why would you keep that kind of database open? What would be your purpose in doing that?
The main purpose is that without a database, there would be no way to determine if remains were located, to compare those remains through DNA or whatever means to confirm that they may be related to, in this case, Mr. Gutierrez. So keeping that open, even though the case is going and has been referred, it gives the ability that at any point, at any time, if remains are located and there is a comparison made, that the police department as well as the family involved would be notified of that. So without that database, we wouldn't have that ability.
Judge, I have no further questions. Thank you.
Nothing, Judge.
You may step down.
Your Honor, the state has no further witnesses in its case in chief. We have to move in a couple of additional exhibits. So just in terms of the testimony just now, I'd move admission of State's Exhibit 349 and 350. And do we have any other outstanding exhibits, counsel?
I still think it's weird that he's sitting at the prosecution table. How is that permitted?
So we would just ask the court to reserve the right to move in additional exhibits, Judge, if in this massive amount of exhibits, and now with a second clerk, just to make sure that we have the ability to reserve that right if that becomes necessary in the future. But if the court allows us that privilege, then the state at this point rests.
All right. Any objection to the exhibits which are offered?
No, aren't they
No
supposed
objection to the exhibits. The defense, prior to making argument, also have several exhibits we'd like to move in. That would be.
Now, aren't they supposed to say, like, have some kind of objection saying, all right, well, the defense, basically says the state at this point has not proved one iota of evidence and that the case should be dismissed, ? I know it's kind of mostly a formality, and I know the judge with the head trauma would deny it if he even comprehends what that is. Okay, for those of you who are attorneys, I have a question. This popped up in that Kaylee Anthony thing we watched last night that I had never heard of before, and it comes along the lines of when the prosecutors hand over evidence to the defense, then it becomes public record and can be, requested via FOIA, ? Now, I don't know if that was just back then in 2011 in Florida, or if that's one of those things that, like, it differs by state. In my mind, I thought everything is supposed to be, anything the prosecutor has is supposed to go to the defense. And then the defense decides out of that pile of things, you know, what's relevant to defending their client or not. If that is the case, if the prosecutor does not have to hand over everything that they've assembled to the defense for reasons of A, preventing it from being public record, or B, thinking it's not going to matter, so they're just going to keep it. Why is it up to them to decide what's shareable and not? That is really concerning. I don't know if I said that accurately. Again, I'm an accountant. I talk taxes and numbers. I don't talk law. Discovery can be under seal. It's handled in motions from either party under the judge's scrutiny. Full disclosure is a myth. That's really concerning. Lead detective often sits with the prosecution after they're done. He was sitting there beforehand. Okay. All right. Let's continue.
Defense exhibit 335,
That's worrisome. This whole
336, 337. And then these were photos. It's going to be defense exhibits. And Madam Clerk, if I have multiple numbers, would you just like me to say like 57 through 60? Okay. Defense exhibits 57 through 60, 62 through 72, 74 to 76, 106 to 108, 127 to 129, 131, 133 through 136, 140 through 141, 143 and 144, 145 through 162, 177, 227, 229. And then I had noted when I received an exhibit list that defense exhibits 248, 250, 252, and 253 had not been marked as received. However, those were the documents that Attorney Birdsall had used on his cross-examination of Marquand Washington, and he had moved them in and they were accepted. So I just want the record to reflect that those had been previously received. I also have notes that exhibit 262 and 319 were supposed to be received.
pause. Okay, so we're 17 minutes into day 13. So 4 hours, 45 minutes, plus almost 3 hours, and then they go to closing arguments. So not even 8 hours of defense compared to, I'm pretty sure I estimated it's around 50 hours. I'll have to add up for reals.
As well, but those were not marked. So I'd be asking that those markings be made and then the exhibits I had mentioned be admitted.
You said some of them had not been numbered?
No, they had been numbered. So defense exhibits 252, 253, 250, and 248, those had been already received.
Right, that I heard.
But it wasn't marked.
It wasn't marked that they had been received?
Correct.
Okay, I thought you meant they hadn't been numbered.
Sorry for the confusion.
Okay, not a problem. Any objection to receipt of the foregoing?
So, Council, are any of those the items that were marked but objected to? So
No.
not admitted?
No.
So I noticed that a couple of those were met. There were 2 times that you approached witnesses. We did not have the exhibit go in, but I
I
think you
hate him
maintained
so
them, I
much.
assume, for purposes of making sure the
I
court
don't know,
had
for
them.
those of you
Are
who
we
watch
moving
Dan
those
Bungie
into
know,
evidence as well, or
he
not
doesn't do
those?
the
No, not
family-friendly
Okay.
middle
All
finger
right. So
anymore.
upon the assurances of the defense that the 2 exhibits I
He just
recall that
does
were
the
not
regular
allowed to be
double-barreled
presented,
one, but
Judge,
in
were
case you
not.
don't know, this is
Yep,
the
that's what I meant.
family-friendly middle finger. and
Upon their
you two point your
representations that those
fingers
are
at
not
the
included in
TV.
their list, I have no objection.
Feel free to use it
All right,
liberally.
received.
And then Attorney Aubert will be making argument.
Reserve.
I'll put it down to normal
May
speed when
reserve.
we get back in the...
To a later point in the morning. Pardon me?
We have a motion on set versus
The typical
state's case.
post-resting motion?
Yes.
Yeah.
It can rest for a
Double
while.
barrel straight. Got to
it's
do
reserved.
both of them. Double barrel.
Do
Family-friendly middle finger.
you wish to present a defense?
Yes, Judge.
You may proceed.
Thank you. The
Okay, I'll
defense
put
will
it back
call
on
its first
normal.
witness, Julianne Avila.
So now is a good time to remind you that The GiveSendGo is $3,000 away from their goal as of right now, or as of half an hour. Yes, there you go,
You
straight.
solemnly swear the testimony you are about to give in this matter will
Family-friendly
be the
double barrel
truth, the
middle
whole truth,
finger. I
and
need to get
nothing
my
but the
nails
truth, so help you God. Please be seated.
All right. And also today is day number 1,327.
Good morning. Could you please state and
that
spell your
Zachariah
name
has
for
been
the record?
incarcerated.
Oh, do you want to check if, see if the mic's on?
Is the green bar up?
There you go.
That's much more appropriate for the day.
My name is Julianne Avila, Julianne
And how are you currently employed?
I'm a crime scene response specialist with the Wisconsin State Crime Lab out of Milwaukee.
And can you explain to the jury what that occupation entails?
So we respond to homicides, other investigations for maybe smaller departments that need help, officer-involved shootings, or any other major event that a submitter or an agency in Wisconsin may need help with.
And what kind of qualifications do you need for your job?
There are 4 of us who are full-time in crime scene response, and then we have a program chief. So for the crime lab, what we did was we have forensic scientists who had a major discipline, some of us DNA, firearms, latent prints. And then what we do is we go through training to learn how to approach a crime scene, how to respond, how to go through it, how to look for evidence that may be appropriate for the scene that we're called to, how to do proper collection techniques, documentation with photographs and video, and then eventually write a report. And so we bring our bench knowledge to the scene as forensic scientists to kind of try to get the best evidence that we can.
And how long have you been working as a crime scene response specialist?
So I've been a crime scene response specialist since January of 2020, but I've been involved with the crime scene response team since 2015.
And prior to 2015, were you still working in the field?
Yes.
And what type of education background do you have that assists you in your position?
So my degrees are in criminal justice and a minor in biology, and I have a master's degree in forensic science. And then we had our other specialized training within the laboratory to become crime scene response specialists with the training director at the laboratory.
And so you had noted that you had been working in crime scene response since 2015. Was that with the Wisconsin State Crime Lab, or was that elsewhere?
That was with the Wisconsin State Crime Lab.
So since 2015, you've been employed with the Wisconsin State Crime Lab.
I've actually been with the crime lab since 2002. I was a latent print and footwear examiner.
So just focusing on your work as a crime scene response analyst, do you have to prepare reports for the things you do? Is that a normal duty in your job?
Yes, it is.
And can you explain that for the jury?
So the reports we generate explain who called us, who responded to the scene, what their duties were at the scene, what we did, what we eventually collected that may have been of importance. And then we also, before we leave a scene, we give over all the evidence that we've collected. So we may also make mention of what was given to the officers at the scene. And then we tell them, you know, that how many photos have been taken, where they can get those, and just kind of the overall documentation of what we did at the scene.
And during your time span of employment, approximately how many of these reports have you written?
Oh, I'd say
Something else that just hit me in my brain, since Josie's in the chat, in the episode 5 of your podcast, I can't listen to episode 6 until I listen to closing arguments, and until we're finished here. But I am hoping that the defense kept hammering, there's no body. We don't know how he died, if he died. because in the her opening arguments, it wasn't like no body, no crime, but it was kind of along that line. So in my head, I'm hoping like that was hammered home. I don't know. This is just so troublesome. Oh, and also, Pixie last night had said that she had gotten a letter back from Zachariah. It was a drawing of like a snowman. So make sure you're sending letters. They get color photocopied, and then he gets the color photocopies. But she's all the way in Australia. And also, I don't know, for those of you who have written to him, can you send him like a self-addressed stamped envelope back so that he doesn't have to spend any money sending anything back if he chooses? Oh, he went to go visit today. Another thing I want to do is I want to do a live stream and read through all of his journal entries, because I've only read through a couple and I keep forgetting to do that.
Probably maybe 75 to 100.
And I want to direct your attention to 2020. Do you remember doing work on a case regarding Zachariah Anderson?
Yes.
I'm going to show you what's previously marked as State's Exhibit 43. Judge, may I approach the witness?
Go ahead.
Is that a report that you prepared in this case?
Yes.
And how do you know that it's a report you prepared for this specific case?
It has my name and my signature
Gary
on
is
it. I
back.
see Lisa Treffinger's initials on it, as she was the peer reviewer of this case,
Hello, John
with our
Gary.
laboratory case number on it and our seal on it.
And the case number correlates to
John Gary says, I think the defense would have risked losing all credibility with the jury if they pounded no body, no crime. RG's blood was all over the apartment, and he was never seen or heard from again. I think it's pretty safe to assume that that something happened to him. But how in the world can they prove? They can't even prove. How can they? Well, again, if you missed the Kaylee Anthony case thing we watched last night with Casey Anthony, you know, they couldn't. The part of the reason that the jury acquitted her is because they couldn't tell manner of death. All right. Well, we don't even know. Like how he died. There's those little splinters of wood that they found. Does that mean like someone used a baseball bat? I would also like to see, like, well, and I don't know because I haven't watched, now the defense just started, but do they have someone who can demonstrate how a person of approximately the same size can lift dead weight of approximately the same size and not show any type of drag marks, etc.? And exactly how he was killed is not necessary to prove he was murdered. Really. It was clear that he was violently killed and somebody disposed of. Okay, well. Yeah. I mean, here. John Gary. Do you follow me on X, formerly Twitter? I posted something yesterday that was kind of interesting. I don't know. I don't know how you can surmise that Zachariah Anderson was the one that murdered him when, there's reasonable doubt. We don't know how he was murdered. We're not sure who murdered him. So,
Maybe
you should watch that thing, that Kaylee Anthony thing. It was really interesting. Well, how do we know he was murdered? I mean, it's pretty safe to assume, but you know what they say about assuming? You make an ass out of you and me. Can't prove something beyond a reasonable doubt if you don't know. You know what I mean, Jelly Bean?
perhaps any and all work that the crime lab had done as it relates to the investigation.
Yes.
And what is that case number?
R20-1497.
And looking through the report and the date on that is September 3rd, 2020.
Correct.
Looking through the report, is it a accurate depiction of the report you prepared without any modifications?
Yes, it appears it is.
Judge, I'd like to admit Exhibit 43 and publish to jury.
Is there objection?
Publishing the report?
Just
Hand
gonna,
it to them?
no, I'm just going to put it on the.
Here.
Even the
Go ahead.
judge and the prosecutor has said the missing Rosalio.
Okay, so while this is up, if you could explain to the jury what this report is about.
So we received a Dodge Caravan into the laboratory that I was to look.
One thing I was actually just thinking, reading Scott's in the Karen Reed, just the opposite, nearly no blood where the decedent was found, which doesn't jive with his injuries, which shows he was murdered elsewhere. My whole thing is, if there's one maybe, like maybe he was hit by a car. Maybe she ran over him. Maybe he was, beaten up in the house and left outside. If there's one maybe, it's not guilty. It's reasonable doubt. Period. Full stop. End of story. That's my observation. Again, I do numbers. And taxes are coming up. Yippee! I should do one to give you some tips on making your tax picture. Although their new form is pretty easy.
Look for any kind of possible blood evidence in the van. So I'm just explaining that both myself and Lisa Treffinger actually looked at the van. I took the photographs of the van. And then I talk about some testing that I did on stains that I observed in the van and the condition of the van, and eventually what it was that I collected out of the van.
Okay, and so item A is the van.
Correct.
Sarah Schwartzberg, nice to see you again. No, they weren't sure how Kaylee died. They claim chlorophyll, that she was suffocated by the tape, but there is no way to know. Also, the floor mat in the back of her car, the documentary thing we watched last night, the glue that holds down the floor mat contains chlorophyll, like basically the elements of chlorophyll. So they couldn't say. And then also there was a part on it where they were talking about like the mom's search for chlorophyll, and the guy that wrote the software for that did some kind of test, But then, like, he was watching the trial from home, and then there was like an expert witness testifying, like how many times it showed up, like 84 times or something, 80 something times. And he actually called and said, I didn't realize until I was watching the testimony our software has a glitch on it. So then a couple days later, they had to tell the jurors, okay, you know, the guy that said it was searched 80 some times, that's not true. There was a software issue, so just disregard it. I thought that was interesting too. I think we can all agree that Casey Anthony's a piece of shit and she's a liar. Farrell said it best. She's a lying liar that lies. And that baby deserved a casket. You know, even if she did die by accidentally drowning, she didn't deserve to get tossed in the woods. Somebody that lived at that house tossed her in the woods. I'm not sure who. Yeah, I know. The little ones are hard too. I don't know. It fuels my anger, I think. Okay, let's continue. There's something else I was going to say. Now I forget. I'm old. Stray last night. Kaylee Anthony was born August 9th, 2005, and the triplets were born August 9th, 2006. So exactly 1 year later. I did not know that. I think it's safe to say that the detectives in that case bungled as well. Had they done their job, they probably would have figured out what happened, how that little girl died. Plus, on top of it, if she did drown, why not call the paramedic? Just for that, they should be in prison for quite a spell, in my opinion.
Reviewing the van, processing the van, created a little chart.
I did.
Iris is here. Hello. Welcome back. I'm trying not to be
Okay, and
crabby.
can you
Okay,
what does this chart depict generally?
Record, say what the
Sure, sorry.
Oh, shut up, Dingleberry.
Defense Exhibit 351.
I created this chart just for my own personal notes, just to see where I tested stains in the van. I did not collect these stains,
Iris, that's so
but I just wanted to make note of where I had done some testing. I noted where there was carpet missing from the van, and that's generally what this is, just for my notes.
And so wherever, let's start with the steering wheel. You had made a note for the steering wheel. What did that note indicate, if you remember?
There was a stain, a darker stain on the steering wheel that I observed, and that was just something that I tested.
And then, if maybe you could just walk through each of the items that you noted and what you did.
Okay, what are the dimensions?
Sure. So they don't have specific. Some.
I was going to do that. I was going to see because my son and Truman are both, I think Truman's like 6 foot or 6'1". My son is like 6'1", 6'2". And I was going to see like what the dimensions are in the back of this 2005 Caravan and see if they could see like how much carpet is picked up. I mean, in my view, just in eyeballing it, there's no way a curled up dead man could fit in that little tiny area with no carpet. I mean, it's just impossible. Think about it. Ugh. Oh yeah, the kids thing gets me. The Shanann Watts and her unborn baby and those two little girls. I can't shake that. And also that Susan Powell, her murder, and then the dad and the two boys when the social worker lady dropped the boys off for visitation and he locks the door, kills both of the boys, and then lights the house on fire while she's calling 911. It's another one I can't shake. People are horrible.
Some of them have numbers of kind of just what areas I tested.
How
What I
much?
did was I used
Oh.
something called phenolphthalein.
Scott says, how much and where was the blood found in the vehicle? There was one dot the size of a pinhead. And they used the sample. I'm going to screw this up, I'm sure. They couldn't confirm it was Rosalio. No. Yeah, it wasn't confirmed. It was such a teeny tiny sample, they couldn't run all the tests they're supposed to determine if it was blood and Rosalio's and something else. So using like a word salad kind of thing, it was implanted that there was actually blood found in the vehicle. So basically none. Are you skipping any days? You seem really far. Oh no. We are not skipping days. We've had a couple 12-hour live streams over the course of the last couple weeks. You know, it's what we do. We go until we're tired. Yeah. So the crime scene, Scott McGinnis, you can see there's blood everywhere. It's all over the door. It's in the door jamb. It's all over the dining room, splattered all over the artwork, the kids' artwork and Easter stuff. There's an area on the couch in the living room. So they went somehow from the front door. Well, I don't know the order of it. I don't know if it started and then he tried to escape and open the door and then he got hit again. I don't know. But it's all over the place. Yet, there's nothing found. And apparently, according to the state's theory in this case, he was, laying dead in the back of this minivan while Zachariah Anderson went to Walmart, did some shopping, meandered around in his flip-flops. So and all they found was this piece of carpet that's missing, which the lady that he was working at her house on said, yeah, that carpet's been missing for a while. But again, it's not found in the floor underneath in the metal in the cracks, the crevices. It was raining. He's known to wear flip-flops. They didn't test the flip-flops. I mean, they didn't do jack squat, in my opinion. Just said, oh, it's him, according to Sadie, who was probably covering her own ass. And yesterday, I'd said, did they talk to the person that called Crime Stoppers and reported a dark-haired woman outside of his apartment and get like a sketch? My guess is no.
Which is a presumptive test for blood. It's not a determining factor. It just is. It could possibly be. And so I tested the steering wheel. I tested the running board along the.
Here I go again. Those little wood chips also are sticking in my head that they found at the crime scene. He was a baseball player. Were those little wood chips? Could that have been from like a bat? Breaking apart. They didn't find any bats. They didn't find any baseballs. They didn't find any shoes. Did they test that little piece of wood? Does it come from like a wooden bat that he's known to use? I'm sure there's plenty of pictures. So decedent was allegedly transported in his van whilst he shopped at Yes. And here's another thing, Scott McGinnis. Zachariah, when he was arrested, 6'1", 216 pounds. Bad back. Bad back. Injured. Awful back. Rosalio Gutierrez, I've read 6 foot, I've read 6'2". So let's split the difference, 6'1", same height. Rosalio, I've heard 270, I've heard 280. And then his mother and I think Sadie or somebody also had said, oh, he'd lost quite a bit of weight. Incidentally, they put him down like in the low 230s, 220s. Regardless, Rosalio, even if you believe that, was still heavier than Zachariah Anderson. Salvador, that comes into the chat once in a while, was talking about his 85-pound German Shepherd that had died and how he couldn't move the 85-pound German Shepherd, and he's around the same size as Zach. So I'd like to know how in the world a guy who's known to wear flip-flops and white shirts, there's pictures of his hands and in the evidence with all that front door, dining room, whatever, bad back, carries dead weight out to the truck and there's nothing. It's just makes no sense. And it's raining. They'd had rain for days. Don't you think the rain might have, added to the blood leaking all over the place? I don't recall a lot of evidence that ZA had crippling back problem. Okay, John Gary, I've had just about enough of you. If you've gotten this far and you still are waffling, you cannot be helped. I thought maybe you were turning a corner. Now I'm not so sure. Backed up by, yeah. Jeez.
The side of the driver's side of the vehicle. There was an area behind the front passenger seat, the seat belt, the carpet, and then the seats were all missing out of the van. So I tested a few areas of the carpet. I also tested it if, like sometimes in the back of those vans, they have like cup holders where the seats would be. There were some reddish stains there that I tested. I tested areas on the metal parts, which is the bottom part that had no carpet. I tested along there with phenolphthalein, and they were all negative.
And when you say they were all negative, what does that mean?
There was no indication of blood using phenolphthalein as the presumptive test.
Did you do any other tests? Strike that. There are other types of tests that can be employed to determine the presence of, are there any tests that can be employed to determine the presence of blood?
Yes, so usually when we start out looking for blood, we're using basically just a high intensity flashlight looking for any signs that appear to be reddish brown stains, as blood usually appears to look. After that, if something that you can't see with your eye, we might employ luminol, which you may have seen on TV. If you spray it in the dark, instead of giving a color change, it gives a change of light. It emits like a light. So once I was done testing with phenolphthalein, I used luminol and sprayed the van with that. And I saw one area that had a little bit of a glow, and I collected that stain.
And that stain, though, wasn't further tested?
I believe it was tested, but that would have been by the DNA unit. I didn't test it with any kind of presumptive test.
Was that A2?
Yes.
Okay. That wasn't A1?
Correct.
And can you explain to the jury if luminol reacts to any other substances or things other than blood?
It does. It's just a presumptive test, like phenolphthalein. It'll react to rust, bleach, and some other kind of cleaning products.
So it does react to bleach?
It can react to bleach, yes.
You had noted that there were some bleach stains in the vehicle, or did you?
I did. They appeared to have the consistency of what bleach might look like.
When you did the luminol testing, did it react to those areas?
No.
And then you had noted that another thing that luminol can react to is rust. Did you observe any areas of rust in and around the vehicle?
Yes, the car did have rust.
What was your overall impression of the state of the vehicle?
The vehicle was had a significant amount of wear and tear to it. As I said, the carpet was missing. The carpet was dirty. There was a lot of clutter in it.
And was it very dirty in the inside?
It was.
You had also taken some pictures.
Yes.
I'm going to go through them. It's a packet of pictures that were taken, marked as Defense Exhibit 352. Show you the first picture in that packet. It looks like a big dark screen, but can you explain perhaps what this photo was?
I don't remember what that.
Do you take photos when you're doing the luminol processing?
I do. And usually, usually what we do is luminol, because it has to be taken in the dark. Sometimes your exposures will be a little too dark. It's hard for that luminol to show up. It has to be like sometimes maybe a minute or a minute and a half exposure to try to capture it. And because the luminol was so faint, it doesn't really show up very well on this photograph.
Okay. The next picture.
I believe that is the area behind the driver's seat in the back. So in the back area where there would possibly be bench seats, there were some compartments back there and cup holders.
Okay.
These are just the items that were inside.
And was this one of, we can see a
Oh my
reddish
God.
stain in this
Are
photo?
those
Yep.
Rosalio's
Was that one of the stains that you
keys?
tested?
I
Just watch.
don't
I'm
know
waiting.
for sure. I had
There they are,
marked
right in front of our
them with like
face.
Post-it notes and stuff, so I'm not sure if that was one of the ones I tested or not.
I'm going to skip forward and then we'll go back to this photo. I might have to hand it to you just because of how
Yeah.
make it brighter.
Okay.
Oh, it's terrible.
Look at that little tiny, teeny tiny
Yep.
piece of carpet.
Okay. So now looking back at,
You're telling me a 200 and some odd pound, 6 foot tall man fit, this is the wheel well here, fit basically a half a tire back to the back in this little itty bitty spot. Give me a break. Sideways.
this previous photo.
I know his
Yes.
keys were never found. I'm
Does
just
that
saying.
help?
Yes.
I'm just
Okay.
waiting for someone to go.
So was
There they
that
are.
was
Maybe
an
those are
area
the
that
keys.
was
Again, one
tested
maybe
Yes, it
equals
was.
reasonable
and
doubt.
what came back negative?
Correct.
And why did you want to test these stains?
Well, because of the color, of the appearance of them being a reddish brown stain, I was testing whatever I saw that could.
Another thing brought up by Detective John the other day is blood is really slippery. It's viscous. And, you know, I just don't see how one man could lift dead weight of his same size, and there's nothing.
Possibly be blood.
This photo area.
So this is a mid-range photo of the footwell of the driver compartment.
And did you observe anything of interest in that area?
No.
All right, and again, does this car look like it's been cleaned? Does it to me? I had asked the other day, does the outside of the car look like the van look like it's been cleaned? I mean, granted, it was raining. This doesn't look like a cleanup job. if you just unalived someone in flip-flops or shoes, do these petals here, do they look like they've been cleaned? Unless he, did like Dexter and, wrapped everything in saran wrap. God. I don't know.
And did that area appear to have been cleaned?
Cleaned? No. This is the step area going into the cargo area or the passenger area behind the driver's seat.
Okay, and so this is the step threshold area that you tested?
Yes.
And I'm going to show you another picture of that. This is just a close-up.
Yes.
And why did you test that area?
Again, there was a reddish stain there that I was interested in.
Because it possibly could have been
Blood.
blood?
Yes.
And what was the result of that specific test?
That's
It was
a work
negative.
van. Who cleans their work van? I wouldn't. It's a work van. It's just going to get dirty again. I think it's pretty obvious he didn't try to clean up the van.
Can you
I think-
describe what this is?
It's
This
reasonable
is the
to
back area, the very
assume.
back area of the van by the lift back tailgate of the van. This is the metal part. You can kind of see a little bit of the carpet in the upper right-hand corner. And so this was just the bare metal.
And the bare metal, was there a lot of dirt and debris on top of it?
It was dusty. It was kind of dirty.
It was dusty?
Yeah.
Dusty,
Okay.
huh?
And
Boy,
there's
those
also
bleach
arrows
wipes,
in this
I'm sure,
photo.
Yes.
didn't do their job.
And are those arrows depicting areas that you tested in that area?
Yes.
And
That in itself, the jurors should have just completely thrown out the whole thing with the bleach. It smelled like bleach. He used bleach, which wasn't bleach. It was just a brand Clorox. It's pretty clear here that this was not cleaned with bleach or Lysol wipes or a Kleenex. Oh my gosh.
the test for presence of blood.
Yes.
And what were the results of
I have to
those
go light
tests?
some incense.
They were all negative.
Namaste, my friends.
Okay.
Drag marks. I don't
What
even.
is this besides the obvious?
The steering wheel in the van, I have an arrow pointing to what looked like a reddish brown stain on the wheel.
And again, why did you want to test that stain?
Another thing that Detective John had mentioned is blood coagulates. So even if it is a blood stain, usually it'll kind of, as it dries, kind of leaves like an edge to it. Like you can see it on the front door pictures of Rosalia's apartment. The little tails, the blood starts to dry at the end and kind of pools there in like a clump.
Because of the appearance, I wanted to test it with phenolphthalein,
And the appearance of it.
being like a reddish brown stain.
Sarah says, and they didn't prove anything. They didn't even explain the DNA testing as to how much of a profile they actually got and the statistical likelihood it was a match, which was shady as hell. Okay, so that's another thing I noticed from the Wrongful podcast is that was brought up. I think it was episode 5 that just got released on Wednesday. We're so used to hearing this and saying, it's a 1 in 80 quadrillion probability that it's, this person. They didn't even have that. Oi.
Okay. And the result of that test?
Was negative.
Do you remember this?
I do.
This is the stain on plastic. This is the stain.
I believe this is the stain on the headliner above the cargo door area. It would have been on the driver's side. So as you lift the door, it would have been right up here at the top.
Okay. And that was tested,
It was.
and that was negative.
Yes.
John Gary, I think it's pretty established that you believe the verdict is correct. You can continue to
There's this picture.
sprinkle your opinions in
Is
the
there a reason
chat.
you took this?
Just documenting the overall condition of
And I
the
think
van
at
and what
this
was
point, I
inside.
think it's fair
Okay.
to agree
So in
to
this case, the
disagree.
clutter.
Yes.
We can explain to you till we're purple that what you heard is not what you think you heard.
In this picture, was there any significance or just another overall?
Again, just documenting the overall condition of the van.
Okay, and in this picture, I'm going to point to it on here, we see this container. Were you able to determine what that container was?
I don't remember offhand what that is.
Do you remember finding any sort of cleaning wipes or any wipes in the van?
I think there were,
Pixie's
and
here.
that could be it. There
Good
were
day,
bleach
mate.
wipes, perhaps.
I need to go fill my cup of injustice with my egg coffee. I'll be in Fraser Crane mode for
Judge, I'd like to move
5-ish
into
minutes.
evidence defense exhibit
Talk
352.
amongst yourselves.
No objection?
No objection.
Received.
Just watch as soon as I go downstairs. It always happens that they have a break.
I have no further questions for this witness.
See? All right, maybe I'll just wait a minute. I got to figure out how I can add a second camera to OBS. I'm pretty sure it's possible. Then you can come in the kitchen with me and I can show you how to make egg coffee
Okay,
while we
so
listen to this.
we talked, I think, about A2, Ms. Avila. We haven't talked about sample A1, have we?
No.
Okay, so I'm going to show you what's been marked as State's Exhibit. State's Exhibit 1, 313.
Oh. So for those of you who are just joining us, I'm not sure how many of you listen to Dan Bongino, but he always does the family-friendly middle finger double barrel, which is 2 pointer fingers. So feel free to use that liberally towards your screen if necessary. You can use the regular double barrel middle finger, but he always does the family-friendly one. Well, he used to. Now he doesn't. Now he's just double barrel. Okay, I'll be right back.
So again, this is State's Exhibit 1, 313. It's going to show up on the screen up there on the
Where's my
television.
Fraser? I haven't seen Sadie yet either. Good, I don't need to prepare my eye bleach today. Not yet, at least.
Is that a picture that you took from back in the time of this van review?
Yes.
Do you
Jamie's
recall
here.
what
Hi, Jamie.
day you and Ms. Treppinger did this process with the van? It appears to be prior to June.
Okay, so for those of you who have minivans, so this, I would assume, here's the thing. So the hat, what did they call that? The thing in the back that goes down would attach here. And from here to here, this is the wheel well. So half a tire to here. This area. Explain to me how a 6 foot tall, 200 and some odd pound man can fit in this little teeny tiny area. Feel free to go into your own minivan or SUV of comparable size, rolled up in a rug, laying sideways, and see. Iris says, I wouldn't be caught dead in a minivan. Please tell any potential unalivers of me to have a truck. No minivan, I refuse. Okay, so when the triplets were born, obviously I had to go from like a sedan to a truck or to a, larger vehicle. And my ex-husband's dad is a car dealer. And so we usually would go to the auction and pick them up. I mean, we bought new cars too, but usually we'd pick them up at the auction. And so he's, I had this beautiful brand new BMW that I had bought a couple years before and ordered, like took a couple months to come in. And, you know, they didn't really have one that was large enough. So, so I had to suck it up and sell my favorite little car for, you know, a bigger vehicle. And I shook him by the shoulders. I said, if you come home with a minivan, I will never speak to you again. It was no minivan. It was just a big giant. What was it? No, it was a Denali. Oh no, it was like a Yukon XL Denali, like the big giant gas guzzler car. Oh God. But yeah, I'm the same way with minivans. Can't do it.
Or prior to late June at least. Do you remember when this was?
I don't remember the specific date, but I believe.
Okay, John Gary, now you're just being ridiculous. If a body is wrapped fairly well, very little blood would get in the van. But oh yeah. We'll have story time on the triplets sometime.
It was in May.
So if I indicated to you the photograph is dated 5/21, is that an excellent way to figure out when you did this?
Yes.
And so if you look up at the exhibit, does it have a time and date of the photograph? Yeah. So are these the photographs? Is your photography in this, if it says it started on 5/21, does that refresh your memory about when this happened?
Yes.
Okay, so just for purposes then of the record, when do you believe, based on your memory being refreshed, that these photographs and this testing is completed or done?
I took these photographs on 5/21, it appears.
Okay, of 2020.
Yes.
So you were asked briefly about the condition of the back of the van. Does this accurately reflect what you saw on May 21st?
Yes.
So when you saw it, the items that would normally anchor in the carpet or be anchored in by the carpet were situated off as they are in this, or have you manipulated that in some way at this point?
I pulled those off myself.
You did? Okay.
Yes.
So previously, were they in the location they would normally be if the carpet was still remaining?
Yes.
Okay. And you looked at a number of items where there was a red brownish thing in appearance, and you felt like you needed to do what you called what did you call it? A preliminary test?
Presumptive.
Presumptive test. Okay. And so you did that at a number of locations on this vehicle, correct?
Yeah, that's correct.
And that includes on A2 that was brought up to you that was a area on the lower plastic molding in the rear cargo area. Is that correct?
Luminol would be a presumptive, yes.
Okay. So could you smell the bleach when you reviewed this particular vehicle? Do you remember?
I don't remember smelling bleach, no.
Could you see some clear stains, some of which are depicted on this?
Yes.
Did they appear to be consistent with bleach stains based on your observations?
They did.
So if bleach sometimes reacts with luminol, and if you're seeing a bleach stain, why doesn't the luminol do anything in this case if you know?
I don't know why it didn't react.
Okay. But you maintain that your physical observation is that appeared to be bleach stains?
Yes.
All right. Does luminol always react to bleach, or is that something where it is not always happening?
I would say it probably doesn't always happen.
Okay. So for you, it is an indicator, but it is not definitive in your experience.
Right.
So how many times have you, during your employment, been an individual who was observing stains and having to make at least the most preliminary thought process about whether something is blood?
How many times?
Yeah, how many times do you think you've done this on behalf of the state crime lab?
Well over 100 times.
And in that time period, then part of that is because you're trying to figure out, is this going to be tested further, DNA unit, et cetera, correct?
Correct.
Okay. So when you came across A1, is A1 depicted on the exhibit that's up right now?
Yes, it is.
And if the judge
Easy
gave you a
swept.
pointer, would you be able? Remember those pointers from the old days?
Another thing I was thinking, C-Swap just says, or it was discolored by the gas that was spilled in the carpet. Or maybe it was, I don't know, this Rimmel, kind of reddish brown colored lipstick. Maybe, or lip gloss. Or, doesn't matter. If there's a maybe or an or, it's reasonable doubt equals not guilty. There. That's it. It's easy.
Yes.
If he gave you one of those old traditional pointers, could you point out where A1 is on this particular exhibit?
Sure.
X-Comer, hello to you too. And the luminol does illuminate.
Okay, so you can go
to
back. Thank you. So that you're at a
iron.
microphone.
Thank you.
So are you the one who placed the sticker on A1 then?
Yes.
So this would be another one of those things that needed consideration for yourself and for Ms. Treffinger, correct?
Correct.
And this was a team approach. You and Ms. Treffinger were trying to
Also, now there's more discussion about the bleach. Again, does that van look like it was cleaned? I mean, a 3-year-old could have cleaned the van better, in my opinion. I'm ignoring John. If he says something logical or, whatever, then I will reconsider, but I'm not going to hold my breath. None of us know. Oh, yeah. It's just something else, isn't it?
consult at times where either of you felt the other's expertise would be helpful?
Yes.
So as to this A1, did you and Ms. Treffinger have any kind of discussion about whether any of the presumptive testing should be utilized on A1?
Yes, we did.
Okay, and why would you need to do that? If the other places you put little tabs were either sprayed or had a presumptive test applied, why would this one be one where you need to discuss it?
This was a very small stain. As Lisa and I were standing at the back of that van, I was on the passenger side, she was on the driver's side. We were looking in, and we have a height difference. And as I looked, I could see on that molding just this very, very small stain. And as we talked about it, we decided that it was best to just collect the stain so we had all of it, as opposed to trying to take a little bit of it for a presumptive test. It was just very small.
You didn't want to compromise your ability to have the whole amount there to be sure you had the most accurate ability to test.
Correct.
So did you have an opinion, seeing that item at that location, about whether it appeared to you to be blood?
I did think it was possible that it was blood, yes.
And then, and what did you base that on?
Just my past experience as a crime scene person and what I've seen with blood over the years of working crime scenes. This just had the appearance of it.
So I guess I need to ask you, as to the other stains that you saw or the other spots you saw, did any of the others appear to you to also be blood, or was this the one that stood out to you?
Give me a wing, Dingleberry.
I thought the others possibly could be because they had a dark reddish color, but this one did stand out to me.
Okay.
Yeah, he does have creepishly small hands.
What about it stood out to you? So why, based on your experience, did you say, you know what, these others might be blood, but this one stands out?
Just the appearance of it. There was a little bit more, if I remember right, a little bit more to it. It was a little thicker, but it was so small, and just had the appearance.
In my opinion, with regards to the blood that wasn't blood, or the bleach that wasn't bleach, or the burner phone that wasn't a burner phone. How in the world are these, what do you say, misrepresentations allowed? Shouldn't it just be nipped right in the beginning? Objection, objection, objection. I don't know.
Appearance of just a spot of blood.
So let me just show you a close-up of this same picture if I can.
This is states 1-315.
And I'm going to bring this even closer if we can magnify this a bit. Okay, so again,
He has
looking
4
at this, is
kids.
that consistent with what you're discussing?
Yes.
All right. Who has children in the car and they get a bloody nose or they cut their finger or something happens? How is all of this, if it's not determined to be related to the victim, how in the world are they allowed to litter this, not even evidence, these details all over these trials? Is kind of, it's really troubling.
Okay. And having been a crime scene analyst, you said you've done this particular profession for 5 years, correct?
More than 5, yes.
At that point, right?
Uh-huh.
Are you still doing it now?
Yes.
So you have an additional 3 years of experience at this since then, correct?
Correct.
Do you have an opinion as to whether the characteristics of what we see on the screen is consistent with items that have been transferred to that location as opposed to have fallen or splashed or something else at that location?
When we talk about transfer stains, we talk about something that may have either been on your hand and you touch an item and it's left behind. Or if blood is already on something and you put your hand through it, that's a wipe. The other one would be called a swipe. To me, this just looks like a very small speck of possible blood that was just possibly came off of something. It just got just a little bit of a drip or a splash, but it's not what I would call a transfer stain.
So in your experience,
Okay, so for those of you who are attorneys, yeah, someone smacked a mosquito. Why in the world do we spend so much time pointing at things that end up being nothing related to the victim? That's what I want to know. Aren't you supposed to introduce evidence in a trial that has to pertain to the victim, the charges? Oh, that's interesting. Lawkong Express, who likes to sprinkle, let's just say, breadcrumbs in the chat. What are the odds the sample they destroyed wasn't Rosalio's DNA? I'd say highly likely. What a mess. This is a mess.
professional experience, it's not consistent with a transfer, with somebody deliberately applying it.
It does not appear to be, at least in that fashion.
Unless that little speck that they're showing on the screen pertains to Rosalio, the victim, I don't want to see it. Why are we even talking about it? Hello, Vielhammer Media.
Nothing else?
Can you please take down that?
Apologies. So the stage is focused on A1, but like you said, there were several other areas in the car that you thought could possibly be blood.
Yes.
And there were other stains that had a similar appearance as well.
Yes.
Or are we speaking Spanish?
A similar appearance as item A1.
Hola, buenas tardes. ¿Cómo está?
No further
Me
questions.
llamo Crabass.
Nothing else?
The defense will be calling Nathan Hensley to the stand next.
Me llamo Senora Crabass. There's my new name. ¿Cómo se dice Crabass en español, por favor? What a nightmare. I keep thinking if that was any of us sitting there, looking in astonishment at this shit show. Oh, I wonder if YouTube censors Spanish. We could always start talking in another
You solemnly swear the
language.
testimony you're about to give in
I
this
wish I
matter
was
will be
better
the
at
truth,
Pig Latin.
the whole truth, and nothing
Or
but the truth, so help
Klingon,
you God.
let's just say.
Please be seated.
The good dingleberry.
Good morning.
Lauren.
Can you please state and spell
Department
your
1A
name for the
tenant.
record?
Nathan Hensley, Nathanhensley.
Yes, I'm Queen Crabass today. Queen. I'm gonna look that up. Who's yeah, apartment 1A tenant, so across the hall. It's terrible.
And Mr. Hensley, are you currently employed?
Yes, I am.
What is it that you do?
I work in concrete. I'm a concrete finisher.
Very nice. I'm going to just jump right into it. Do you remember talking to law enforcement back in May of 2020?
I do remember, yes.
During that time, where were you residing?
I lived in Wood Creek Apartments,
Do you remember the address?
3709 15th Street, apartment 1A.
Okay, and you said apartment 1A. If you can just explain to the jury kind of the layout of that apartment building.
If you were to walk in the front, it would be the back right corner.
Okay, so did you know where apartment 1B was located?
I believe the front right corner.
So would have been the unit right next to yours.
Yes.
And look, thinking back to, I know it's a long time ago, but do you remember on May 19th, 2020, speaking with a detective?
I remember one came to our door, yes.
And do you remember being asked whether you were at home on May 17th, 2020?
I don't remember.
Okay. Do you remember providing a written statement?
A written statement?
Yeah.
No, I don't remember that either.
If I was to show you something, would that help refresh your recollection?
Possibly, yeah.
I'm good.
The contents of it, do you remember saying that?
Yes, possibly. Yeah.
And was that, so now that you've reviewed that, Do you remember what you told law enforcement about your observations on May 17th, 2020?
I believe I told him I didn't hear anything or see anything.
And was that in regards to the time frame that the detectives were interested in?
Yeah,
And you were home at that time?
I believe so, yes.
And you're saying during that time, so evening hours of May 17th, 2020, you didn't see or hear anything?
Not that I am aware of or remember.
I have nothing further for Mr. Hensley.
Have you take a look at it, just tell me if you wrote it, or if you signed it. So it's not exhibit 1, it's exhibit 353. Okay, then I'm going to show you. Can you take a look at that? Exhibit 353. What I want you to hone in on is the signature and tell me, does it look like that's your signature?
That is my signature.
Okay. Now, is the writing yours in the middle, or did somebody fill that out for you?
That doesn't look like my writing, no.
Okay. But when you signed it, you were saying, best I know, it's accurate, correct?
Yeah.
Okay. So let's first talk about the date that you gave that statement. I assume that the statement you signed was at the same time the cop talked to you. There weren't 2 different visits, were there?
Not that I believe, no.
So you believe it was just one time you saw the police?
Yes.
Did they come to your place, if you remember?
Yeah, I'm pretty sure they came from my door.
Okay. So if I'm correct, it says it's May 25th, right? Is that the date that's on the statement down by where you signed it?
Oh, yes. Yes, it is.
So that would be the date that you talked to the police, right?
Mm-hmm.
Yes? You got to say yes or no.
Yes, I'm
Okay.
sorry.
And they're asking you about, if you look at the top, it says on May 17th. Do you see that?
Yes.
So they're asking you about something that happened 8 days earlier. Is that true?
Yes.
So my guess is that you weren't keeping a diary or keeping track of exactly what you were doing on any given day 8 days earlier. Is that accurate?
Yes.
Okay. Now, it does say it was a Sunday. That helps remind you, okay, so where would I have been on a Sunday evening? Correct?
Yes.
You didn't, at that time, were you working on Sundays?
No.
So that'd be a day off?
Yes.
Okay. And so it says 2000 hours, right? It's kind of military time. Does it say 2000?
Yes.
So they were asking you about 8 p.m. Is that how you took that?
Yes.
So nobody asked you about what happened at 9:30 p.m.?
No, not that I.
No one asked you what happened at 10 p.m.?
No.
So if something happened an hour and a half or 2 hours later, that you're not talking about that in this particular statement?
No.
Okay. So I guess I'll ask, did you hear anything later in the night either that you remember?
I don't remember.
You don't remember. Fair. So were you living with somebody back in Wood Creek there?
Yes, my girlfriend.
Your girlfriend. Okay. So tell me what a Sunday night would have looked like. TV, music, computers. Were you guys gamers? What do you think? What would be your best help for us on what you would have been doing at 10 p.m. on a Sunday back in 2020?
Either TV or movie or sleeping. Yeah.
All right. Sleeping was in the picture even at 10?
Yes. Yeah.
All right. If you were asleep, you wouldn't hear anything. That's fair? Or unless it could wake you up, but otherwise you wouldn't.
No, it wouldn't wake me up. No.
What?
I'm a heavy sleeper. So,
Oh, you are?
Yeah, no.
I think I'm going to end with that. Thanks very much.
Nothing further.
No, sir.
I guess I'm going to move admission to the exhibit. Right?
No, I would.
You don't want it in? Okay.
No, I don't
Then
think
I
it's
will.
appropriate.
Yeah, you can have it. Thank you. Guess we keep it as part of the record.
The defense will call Jennifer Ziegler to the stand.
solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be seated.
Good morning, Miss. Is it Ziegler?
Ziegler, yes.
Ziegler. Can you please state and spell your name for Madam Court Reporter?
Yes. Jennifer Ziegler, Jennafer, Ziegler.
And are you in a relationship or residing with an individual named Nathan Hensley?
Yes.
And for approximately how long have you resided with Mr. Hensley?
A little over 4 years.
So back in 2020, were you residing with him?
Yes.
And I'm going to give you a specific time frame. In May of 2020, do you remember where you were living?
Yes.
And where was that?
Wood Creek Apartments.
And do you remember your specific address?
I think it was 3709. I don't know. I don't remember the street. Sorry.
If I said 15th Street, does that sound right?
Yes.
And do you remember your apartment number?
1A, I believe.
And so in Wood Creek Apartments, while you were living there, did you know an individual named Mr. Gutierrez?
No, not personally. I knew him after everything kind of happened. I guess I heard of him.
Okay.
Yeah.
And do you know where apartment 1B was located in relation to your apartment?
Yes.
And where was that?
So it would be right next to us, basically. Yeah, to our left.
Okay. So I want to jump back to May of 2020. May 17th of 2020. It was a Sunday. Do you have a recollection now? I know it was a while ago. About what you were doing on that date?
If it was a Sunday, I probably would have just been at home, or maybe I was with my parents away at their house, so it would be either or.
Okay. Do you remember speaking with detectives in this case?
Yes.
And you spoke with detectives on 2 separate occasions. Was one when the first time that you spoke to a detective, was that because they came to your house or your apartment, or did you go to the police department? Do you remember where that conversation happened?
Yes, they came to my apartment.
And was that the day where there was a lot of law enforcement there?
Yes.
Okay. And you remember seeing all of that?
Yes, I do. Yeah.
Okay. And do you remember what the detective asked you?
I think he kind of asked me like if I seen or heard anything.
And would that have been for that Sunday, May 17th?
Yes.
And what did you tell the detective?
I'm pretty sure I told the detective that I did not hear or see anything.
And was that accurate?
Yes. Yeah.
And were you then home on May 17th, 2020?
Yes.
And for that entire evening?
Yes, I would have been, yeah.
And that entire time, you didn't hear anything?
No.
Or see anything?
No.
And now, thinking back to when you were living in Wood Creek Apartments, if there was a very loud noise or someone screaming or yelling, would you think you'd be able to hear it?
Objection seems like it would call for speculation.
Kind of sounds that way.
It's from when she lived there, her own observations, if she could hear things that were loud.
Everyone's.
If you can't hear, then you don't know that you're not hearing.
Okay. Do- Have you heard people arguing or screaming before in Wood Creek Apartments?
Arguing and screaming, no. I heard footsteps. I hear footsteps and stuff like that, like doors shutting and stuff like that, yeah.
And so, thinking back to May 19th, when you were giving this statement, if you even heard things like that, you would have told law enforcement?
Yes, yes.
And you didn't hear anything of that sort?
No.
And I have nothing further. Thank you.
Any redirect?
Ms. Ziegler, so Ms. Ziegler, you believe that at first somebody spoke to you while the cops were still around?
Yes.
So were you not working during the day?
I worked Monday, Wednesday, Friday. So Tuesday and Thursday I was off. So I'm assuming it was on one of those days.
And so you were home when they came and asked?
Yes.
All right. And were they, to your mind, were they asking about something that had happened the night before, or did they, I'm talking about the first time they talked to you,
Yeah.
or were they talking about a specific different day?
It was a different day. It wouldn't have been like that day.
Okay.
Yeah.
So if the cops were still there and they were asking you, how do you have any idea how they would know which day to ask you about at that point?
I'm going to object. Calls for speculation.
Yeah.
She knows. If she
Yeah, I
knows.
don't know.
Okay. So, but then at some point you also were asked to give a written statement, correct? Yes? You
I
got to
think
say
so.
yes or no for the record. You can't just say.
Yes, sorry. Yes.
And at that time you were again asked, and they asked you about a specific day that time, didn't they?
Yes.
Okay. So I'm going to show you. First, I got to get it marked.
Yeah.
So I'm going to show you what's been marked States Exhibit 354. And the first thing I want you to do is look at the bottom of this and just tell me if you recognize your signature. And you can hold.
Okay. Yes.
Okay, so is that your signature?
Yes.
Okay. So when you signed that, were you trying to report everything you knew based on what people were asking?
Yes.
Okay. So is there a date by where your signature is that says when they were asking you about that? So you know what date they were asking? In the area where your signature is.
Yes. I see a date right under.
And so what is that date?
5/25/2020.
Okay. And and then in terms of what time they were asking about, date and time, is that at the top of the document where it says on May 17th, 2020?
Yes.
So that'd be 8 days difference, right, in terms of this statement?
Yes.
Okay. And on Sundays, you didn't work?
Yes.
Okay. And were they asking you, based on the military time they wrote down, did it look like they were focusing on 8 p.m. on the evening of May 17th?
Yes.
Based on military time. It says 20, right?
Yes.
00, which would be 8 p.m.?
Yes.
Okay. So I want to actually ask you about a couple hours later on a Sunday, okay? And whether people maybe were headed for bed and things like that a little later. So by 10
Objection
p.m.
calls for speculation.
on a Sunday,
Freaking Dingleberry.
do you remember whether you guys would be in bed yet?
Yes. I go to bed early, so.
Okay. And so if I told you it was at 10 p.m., would you expect to hear things out in the
I'm going to
hallway?
object to speculation.
Well, I didn't hear the whole question. It sounds that way.
Yeah, well,
But you use
How's
the
that?
word
How's that
expect,
grab
so
you,
yeah.
Dingleberry?
What's your question? But you're on borrowed time.
not the first time.
There goes the wing.
And the court has allowed me to pay up on those borrowing a couple of times. So my question is,
Oh, look
if
at
it
his
was
tie.
at 10 p.m. on this Sunday, what, if anything, can you tell us about how that would impact your ability to hear things in either the hall or the neighboring apartment?
Yes, because we sleep with a box fan, so we wouldn't be able to hear.
I think I'm going to end there, Judge.
I do have some redirect, Judge. Thank you. You talked to law enforcement twice.
Yes.
So the statement that Attorney Graveley was just going through with you, that would have been the second time you talked with law enforcement?
Yes.
And thinking back, if they were detectives asking you about that entire evening of May 17th, 2020.
Yes.
And if you were sleeping and you knew you were sleeping at that time, would you have told law enforcement that?
Yes. Yeah.
Nothing further.
Well, you're saying that if you went to bed sometime on the evening of May 17th, you would have told the officers I went to bed?
No, sorry, no.
Okay.
No.
Anything else?
very, very limited. You told them you didn't see or hear anything.
Yes.
And it wasn't because you were sleeping. Let me rephrase that. If you had been sleeping, would you have told law enforcement, I was sleeping, so would not have been able to hear or see anything?
I just told them I just didn't hear or see anything just because they just asked if I heard or saw anything that day.
And thinking now, can you remember if you were sleeping or not?
No, it was 3 years ago.
Okay.
But I would be sleeping because I go to bed at 9 p.m.
At 9 p.m.?
Yes.
Okay.
And I've been going to bed at 9 p.m. because I wake up at 5.
Nothing further.
Nothing.
You may step down. You give it to the district attorney when you walk by. Would please.
The defense would call Kim Lavora to the stand.
As a reminder for those of you who are joining us, today is day 1327 that Zachariah Anderson has been incarcerated. That is 3 years, 7.5 months roughly.
Raise your right hand, please. You solemnly swear the
good.
testimony you're about to give in
swear
this matter
this
will be
witness
the
into.
truth, the whole truth,
He's
and
been
nothing
doing
but the
much
truth,
better
so
at
help God.
remembering.
Please be seated.
Good morning.
Good morning.
Could you please state and spell your name for the court reporter?
Sure, Kim, K-I-M, Lavora,
Oh, it's warm here. It's
L-A-V-O-R-A.
32 degrees.
And Miss Lavora, is there another first name that you also have?
Yes,
Could you please state and spell that also?
sure, E-U-M-D-E-U-N, Umdian.
And is it okay if I just refer to you as Miss
Yeah.
Lavora? Okay. Miss Lavora, are you currently employed?
Yes,
And what is it that you do?
I'm an accountant
Oh,
Where?
I like
at
her.
Wackernusen.
Okay. And how long have you been employed there?
It will be,
Do you guys know those candy nerds? You know, the little crunchy bits of sugar? I have a shirt somewhere around here that says "Talk nerdy to me," and it's got the nerd guy on it. One of those little cartoon things. You know, I love the maths. She speaks
10
my
months.
love language.
Very nice.
sorry.
No, you're fine. I want to kind of jump back in time to May of 2020.
Sure.
And during that time frame and before, did you know an individual named Rosalio Gutierrez?
I only know him through text.
Can you explain how you know him in as much detail as possible?
Oh, sure. I was on a Facebook dating site, and then he
Oh no.
liked me, and we started conversating through text
Hey,
only.
Sal.
Had a few texts. I felt like
You think she'd be smarter than that?
I felt nervous. I never met him. We talked every day. We text every day. He told me personal things about him, his daughter, his business. Moving forward on to May, he told me that he was going to Menards and picking up his daughter. And then the
Menards.
following days when it happened.
So I want to go back a little bit. When did you first, if you remember, when did you first start talking to Mr. Gutierrez on Facebook dating?
maybe February, because it was really short. It was only for a few months.
And from the time that you started talking to him to about May, let's say 18th, 2020, what was the frequency of your communication?
Texting. We would text frequently every day. When I got off of work, I would give him a phone call. We would talk about an hour or two, and then I didn't talk to him for the rest of the night. And then it would continue the next day.
So not only just texting, but also phone calls.
Correct. He wanted me to meet up with him in Kenosha, and I said, no, not today. No, it's not today. I didn't, my God told me no, so I never met him.
And when you're talking about all this talking and calling, what was the nature of the relationship? Was it just friendship, or was it more of a romantic relationship?
No, for me, it was just friendship. He wanted probably to take a step further, but I wasn't comfortable with that. So that was it. For me, it was strictly just friendship.
But you're saying for him,
yeah,
it seemed that he wanted more?
Yeah, that is correct.
Okay. And jumping to May 17th, 2020, do you remember having a phone call with Mr. Gutierrez?
If that was a Sunday, yes.
It was a Sunday. I'm going to show you what's been marked as Defense Exhibit 75. So it's just going to pop up on the screen. Okay, I'm going to zoom in here. The highlighted portion. Does that appear to be the phone call you remember having?
Around
that says 8:49 p.m.?
Yeah. I know. It was night. I know it was night. It was dark out.
Okay. And that's your phone number?
Correct. Mm-hmm.
So that's 414-334-1158?
Correct. Correct.
Oh, sorry.
Oh.
That's your number, this date, and it says that phone call was about 17 minutes. Is that how long you remembered it being?
Yeah, because he was saying he had to run errands, go to Menards, pick up his daughter. He's like, when I get home, I'll give you a call. And he never returned. He never called me back. And then when I called him, probably a couple hours later, the phone just kept ringing and ringing and ringing and ringing and ringing.
So after you get off the phone, after the 17-minute conversation, you said he told you what he was going to be doing the rest of that evening?
Yeah.
And can you say what that was?
Oh, and hold on for a second. Objection, it's hearsay.
Oh, Dingleberry.
What he told her on the phone.
I'm not sure what you would know, considering you don't even know how to tie a tie.
Why would it not be?
I would just argue that it was just the impression on Miss Lavora about what she thought he was doing, not offering it for the truth of the matter asserted.
What difference would make what she thought?
That's the defense's position. I have nothing further, Judge.
Do you have any other questions?
No, I am objecting to that hearsay.
Well, I have to say the sound is so bad in here.
Yeah.
I thought that is the defense's position, nothing further, Judge, which I thought was the end of your examination.
Maybe it was.
Maybe you just didn't want to haggle.
Nothing further on our position on the objection.
Okay. Let's take a break. Please don't talk about the case during the break. Read, watch, or listen to any account.
Oh,
And
it's my
10
understanding
to 15.
the judge didn't follow his own instructions. Now is a perfect time for us to pause and do this. And for those of you in Fraser Crane mode, let's try it again. Oh, that puts me in a happy place. If the sound is so bad, what the hell are we doing in this courtroom? Exactly. And Judge, if your ears are that bad, maybe you better see a hearing specialist. FFS. Isn't it orangha? Is an orange? I forget. It's been many, many, many years since we did the Spanish. All right, so let's see here. Oops, wrong mode. Today, day 1327, Zachariah Anderson has been incarcerated. Naranja. There we go. See? Gracias. I should brush up on my Spanish. When my daughters were taking Spanish in school, I'd knock on their door. What? And I'd say, es tu madre, abierta la puerta, por favor. What does that mean? Okay, so when we looked earlier today, the GiveSendGo is short of their $50,000 goal by $3,000. If you can contribute, please consider doing so. It's very close. Also, considering, as I mentioned earlier, coffee, Folgers coffee to the regular size was $11.49 yesterday when I went to the grocery store. So, in our economic bullshittery as it is, if you will, for those of you who are stuck in this cluster economy and would rather please share the link, and also prayers for the family and for justice. I'm sure John Gary will not. Well, John Gary did have that very, very generous $250 donation the other day, which also makes me wonder, why in the world does he come in here and continue on with his naysaying, let's just say. Oh, yeah, see, Costco usually sells, I don't know if it's Folgers, but, it's the ground, cheaper version, not the fancy, but it's in like a big giant thing. Nope, this is just like regular old can of Folgers. And it was $11.49. I about fainted. I do like tea, Earl Grey tea with French vanilla coffee creamer, and it's just delightful. All right. So, there. Thank you, John Gary. That's the nicest thing you have said. I will pray for justice for Zach. If he's really innocent, I hope he gets released ASAP. God bless you, sir, for your prayers. See? It doesn't take much, does it? All right.
Thank you. Ms. Lavora, you indicated that approximately when did you start speaking with Mr. Gutierrez?
For a few months, probably estimate maybe February.
And you consider this a friendship, is that accurate?
Yes.
And is one of the things you bonded over how close you both are to your respective children?
I think it was just more of common daily activities, I guess, children, food.
But did he speak to you a lot about his children?
Objection, relevance.
He said he had.
Hold on a minute. That's just good. What's relevant?
One of the things the state has to prove here is Mr. Gutierrez is gone through this witness in terms of their conversations about what is important to them. It's just seeking if that was something that was important to him. It'll be brief. Thank you. Did he speak a lot about his children and their activities?
Generally, not specifically, no.
Sea swept. I think that's the color my daughter was doing in her hair last year. God. That's funny. She's going back to her normal hair color now.
Did he explain about how active a role he took in baseball with his son or gymnastics with his daughter?
Gymnastics, yes, and softball, baseball, correct, yes.
No, hers was a little oranger. A little more orange. More naranja.
And you indicated that through May 17th of 2020, you guys were in communication daily, multiple times a day?
Correct.
And after your phone call with him on May 17th of 2020, did you ever hear from Mr. Gutierrez again?
After that phone call, no.
And after you didn't hear from him when he was supposed to call you later that night, did you then try to reach out to him multiple times to?
Correct, yes.
And were any of those ever answered?
No.
Did his phone start going directly to voicemail?
It started ringing continuously, a couple times, and then it went dead. So.
And during your friendship with Mr. Gutierrez, was it unusual for him not to get back to you in a timely fashion, given how often you guys spoke?
Often.
Yeah, that was very strange.
Objection.
And ultimately, because you were someone that was in Mr. Gutierrez's phone when that scene was found, did you speak to law enforcement about your friendship with Mr. Gutierrez?
Yes.
And did you offer to them all the information you had regarding anything you knew about him?
Yes, I did.
And in fact, during your time of talking via the phone for those couple of months, there were times you were actually in Kenosha physically and you two did not meet up, correct?
I was never in Kenosha.
Oh, you never met up in Kenosha?
No.
Okay. So you and Mr. Gutierrez never had any plans to meet up as of May 17th, 2020?
He wanted to meet up, but I never went.
I have nothing further. Thank you.
Cross?
Nothing further on redirect. Nothing further, Judge. Thank you.
You may step down, ma'am.
Oh, okay. Thank you.
Ew.
Judge, at this time, the defense would like to make argument. We have witnesses. There was a development where the state had talked to an individual today, sure. So we don't have witnesses ready now because of the development until the afternoon. So we're hoping to take this time to make the arguments that we would have made earlier and to instruct the court on where we're going to be moving forward.
Would it be convenient to break until 12:30? I get wagging of the head. Is that, or wouldn't be, or? What did you say? Ah, bless you. You have no idea how wonderful you people have been.
At this point, they're sort of captains, Judge.
Well, I know it, but they could be owly too, and they're not. I mean, I've had cases where the jurors just glared at me. Nah. Anyway, let's break and come back at 12:30. Please don't read, watch, or listen to any account of the trial. Don't talk to anybody, including fellow jurors or household members, about anything about the case. And 12:30.
Now what's happening? I sure hope their defense gets a little bit better. I would like to see a demonstration in the back of the van. Why am I getting the feeling that that's not going to happen?
The defense to reserve motions at the close of the state's case. So I think, Mr. O'Berry, you're on the floor.
Thank you.
Oh, now the jury's gone. They're going to be arguing. Is that what 3 witnesses disappeared today?
Your Honor, at the close of the state's case, it's required under appellate case law and for the defense to make a motion generally as it relates to whether or not the state has presented enough evidence that any reasonable jury could find the defendant guilty. And what I want to do is talk in particular about, and I'll start with count 2, because there is a failure of proof with regard to that charge. That is the stalking, where Rosalio Gutierrez Jr. is the victim of that. And as the court is well aware, when we look at the jury instructions for stalking, it is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to either suffer serious emotional distress or to fear bodily injury or death to himself or herself, or a member of his or her family or household. And that would cause a reasonable person to, again, either suffer serious emotional distress or to fear bodily injury or death to him or herself or a member of his or her family or household. And where the actor knows or should have known that the conduct would cause that person to suffer serious emotional distress or to place the person in reasonable fear of bodily injury or death to himself, herself, a member of his or her family or household. So the state has presented no evidence at all concerning Mr. Gutierrez either perceiving such a serious, and again, it's not just any emotional distress, but serious emotional distress, and or anything about bodily injury or death, any apprehension of that. Of course, another way that that can be brought in is if it would have, well, a second element actually is that it would have caused a reasonable person to have those same beliefs. The only evidence that has been introduced at all regarding the effect of these activities on Mr. Gutierrez himself was specifically that he was not afraid of Mr. Anderson in any way. In fact, there was some, we might call, jousting, not afraid of this guy type stuff. And there hasn't been any evidence presented by the state that would fit those elements as it relates to Mr. Gutierrez at all. So the fact that there's no proof on that element that's been introduced by the state, that should be a directed verdict of not guilty. Now, I want to talk about count 1, because there was some evidence that was received relating to Ms. Beecham's apprehension of emotional distress. There was one.
Lawkong Express. How many eyeglasses were found in Rosalio's apartment? I'm pretty sure none. I also asked the other day, how they found that little tiny little tiny chunk or a couple little tiny chunks of wood, and I had said, was that tested to see if perhaps it had similarities to perhaps like a wooden bat that might have gotten broken. But you would think if he, being a visually impaired person, as many of us are, that there'd be like maybe even broken glasses. Like, did his glasses break if he was being beaten? Did they find any broken glass? Did they even look for any broken glass? Questioning. I gotta find a different colored paws. I don't like this attorney. I don't like his style, and I think he did a poor job overall. Like I said, you'd think this guy would have like this part memorized and have a little bit of confidence. Boombastic, if you will. All right, continue.
Point where she testified that she was, quote, fearful. There was also evidence introduced surrounding.
Personally, if this was me, I'd pick the biggest jackass attorney, annoying, as long as he got his point across, versus being timid, if that makes sense.
All of the other circumstances, how she felt in response to it, what her reaction was, and things she did in response to them. Now, it's important to note that when we have, and I'm going to make an analogy here to the law that we understand as it relates to simple disorderly conduct, and you'll see why in a second. Because as we know, there's activity that we as a society are willing to tolerate within the bounds of normal and sometimes difficult interactions between human beings. And the court's well aware disorderly conduct is an example of that because it has to rise to a level where it's outside the scope of what we would consider to be tolerable activities, given the fact that people do have difficulties in life and sometimes do express themselves in ways that don't rise to that criminal level. So,
boombastic, if you will.
Complications and arguments and some jousting going back and forth, some argumentation going back and forth, practically all of which was in the context of the children, but also what could probably be characterized as just normal friction that goes on when there's the ending of a relationship. The fact that Ms. Beecham had, and as she testified in the stand, at one point she did use the word fearful, but there was no evidence that this was serious or severe emotional distress, and no evidence that she was fearful for her actual safety or life. So, taking the evidence as a whole, there is not, in our opinion, sufficient evidence that any reasonable jury could find Mr. Anderson guilty on count one either. And again, I acknowledge that there was one statement where then she used the word fearful. That was all she said. Now, the most complicated aspect of this case, of course, is the fact that the state has charged in count 3 first-degree intentional homicide. And, of course, that relates to causing the death of Rosalio Gutierrez Jr. with intent to kill that person as a Class A felony. The state has established, I think it's reasonable to state.
Okay, not even factoring in the fact that they never found him, where is there evidence that anything was premeditated? You'd think in his cell phone data or computer or what have you, they'd be able to muster up something to show premeditation. They didn't muster up anything. If anything, it's the opposite. There's plenty of premeditation that Rosalio and all his, homies had. Well, for sure, Rosalio ran it past Sadie to, break his legs, injure him in some way. How in the world can you charge a man with premeditation when there's no premeditation? There's nothing. This is just disgusting.
And a reasonable jury could conclude that he is at least missing, and it's not an illogical step for the state to argue that he is in fact dead under the circumstances. So we acknowledge that. But the fact that and Mr. Graveley himself put on a great deal of evidence about how extensive the investigation, all the different places that they looked, and one would have to believe that with all of those resources at the state's disposal, that something more would have come up. So I know this is very difficult to quantify in any particular way. There's no mathematical formula here, but the state would ask, the defense would ask the court to determine if the state has met that threshold as to whether or not the state has produced sufficient evidence that would enable a reasonable jury to render a guilty verdict at that point. And the same argument really goes for count 4, because acknowledging that there is evidence that could be perceived as somebody removing a corpse if the person was dead from the apartment and then doing something with it. The only real evidence of...
Please tell me that there's a demonstration of someone moving dead weight of approximately the same size in the defense's case. I'd like to see that too, into the back of a minivan. Oh, bye, Stray. Thank you for joining us. No demonstration. You'll have to wait and see. Oh, man. Have a beautiful day, Stray. Stay warm. It's warm here, 32 degrees. Shorts weather.
That is the missing rug, the amount of blood, and arguably this other spot that was in the car. And assuming, of course, that the cutting out of the rug is something that the state believes that they've established timeline-wise. So again, hiding a corpse, there isn't a corpse. And it's, again, one of those complicated situations that the defense would ask the court to determine if a reasonable jury would be able to find the defendant guilty of that count. So with regard to counts 3 and 4, I think those are pretty much traditional arguments that the defense makes at these types of situations. But I, again, on count 2, would emphasize there's been a complete failure of proof on the elements of causing Mr. Gutierrez to suffer either serious emotional distress or to fear bodily injury or death. And then again, with regard to count 1, relating to Sadie Beecham, that with the exception of her use of the word fearful, which we'd argue doesn't rise to the level of serious emotional distress, there's been a failure of proof with regard to that as well. And we'd ask the court to direct a verdict with regard to that as well. So we're asking for directed verdicts on count 1 and 2. We're asking the court to dismiss counts 3 and 4 on the basis that the state hasn't produced sufficient evidence to enable a reasonable jury to come to the conclusion.
Thank you. State?
Judge, I'm looking at the stalking instruction. I'd like to start with that. So I'm looking at the jury instruction itself. Page 2 of the jury instruction defines suffer serious emotional distress. It does include what counsel mentioned, which is to feel terrified, threatened. Those things are included, but unfortunately for the defense argument, it also includes harassed in that definition. So again, that's the bracketed definition of suffer serious emotional distress in jury instruction 1284, which is the official jury instruction for Wisconsin for the court to read for stalking. So in this case, certainly both of the charged persons who are victims, alleged victims in this particular scenario, would have reason to feel harassed by a series of incidents. And as the court knows, in terms of a venue statute, if any one of the requisite acts occur in your county, then you may use other counties' acts as a portion of that venue. And in this case, the course of conduct required by stalking is at least 2 acts. We have alleged and have now abundant evidence from the state's perspective that on April 25th, the defendant at the home of Sadie Beecham. So that's not in Kenosha, but would be in terms of the course of conduct, something that meets the venue statute. That he peeped in a window, observing both Sadie Beecham and Rosalio Gutierrez, and that he broke into and took items from the truck of Rosalio Gutierrez. I think the court has heard the evidence of that, including that documents that are consistent with that were brought up to Sadie Beecham, that there's on the defendant's phone, there's a picture that can only really be explained by his removal of an item from Rosalio Gutierrez's truck. And the defendant himself has admitted to various parties that he peeped in the window. That was even brought up. He admitted that.
Okay, so the daughter seemed to have a hard time wrapping her brain around the fact that her mom was moving on. Thus, not saying that this was the right way to go about doing it, but that's what led Zachariah to, put her in the car and drive her over there and peek through the window. Now, was that smart? No, but I guess I don't recall that they've established that it was him who got into Rosalio's vehicle. And the daughter, didn't we talk about the other day that the daughter with the phone, and they thought the phone was taken by the daughter and put in the car? ? Something to do with that? Did they find his fingerprints in the truck? Huh. No. Oye drove herself to Kenosha and broke into the truck? No, but she could have, I don't know. He had photos of the stolen document on his computer. I don't know where I was going with that thought, but she had access to the computer. And remember she said the other day that she came home from school and went into the computer, but like everybody knows that nobody was in school during that time frame until the fall. And even then,
to law enforcement and observe those two persons. So that certainly would cause any individual to feel harassed at the very least. The defendant then on May 8th plants a phone in the car of Sadie Beecham. That car comes down to the Kenosha address of Rosalio Gutierrez. Again, that's done for purposes of essentially harassment and monitoring, which is again.
Actually, the VIN number, Timothy Bleefnick, I don't know who watched that trial, but Tim Bleefnick, he had written down the VIN number of his estranged wife's boyfriend and looked that up. And I had mentioned the other day that, when there's little kids involved, like I wouldn't do it because that's just not my personality. But, there are people that, want to find out information about people that may be involved in their children's lives. And especially with these people going on all these websites trying to find love interests. I mean, who knows who's on there? Just don't do it. Go walk around. Go meet people. Get out.
Again, harassing, and that's harassing to both of the two individuals. And then on May 13th, we provide evidence that the defendant is again eavesdropping at this time in Kenosha at the home of Rosalio Gutierrez. Not only does his phone place him in Kenosha at that time, but it's the very same phone that is using to text Sadie Beecham. So she's literally inside the house of Rosalio Gutierrez in Kenosha. The phone of the defendant is in Kenosha, based on the evidence the court's heard from FBI agent Hannah Judd. From that same device, he is texting the exact words that Rosalio Gutierrez has just uttered. Again, this is communicated to Sadie Beecham, so this is the defendant wishing that to be communicated. And so, again, is a second incident.
Just considering the fact that the daughter was so distraught about her mom moving on and was in disbelief over it. I mean, has it really been established that Zachariah was the one that was doing that? Or, is it possible that the daughter had the phone and was doing that? Question mark. I don't remember. Pardon me for not remembering, but again, if there's even one sort of maybe, it's reasonable doubt.
Of eavesdropping, not at Sadie Beecham's home, but at an individual's home in Kenosha. The court heard both of these individuals.
See, like what Jamie said, how do you know OA didn't have the phone and hid it herself to not get caught with it? That's the whole thing. If it's one or the other, then that's reasonable doubt. We don't know. I mean, I'm not sure they've established that she couldn't. I mean, come on now. Who doesn't have, let's see, what was she, 12, 11, 12? And a cell phone? Like, that's more, if you had $100 bill and a cell phone and, put them both next to each other on the counter and walked away, I can guarantee an 11-year-old girl would pick up the friggin' cell phone versus a $100 bill. It's like crack cocaine for those kids and the friggin' phones.
Express distress in various ways. Again, it's a reasonable person standard. Would a reasonable person who has had a phone placed in their car and who has been peeped on twice in a 3-week period feel harassed? Would that be what a reasonable person would believe? And I think there's a simple answer to that, what a person of ordinary intelligence and prudence would consider about that. And in fact, the defendant only has to intend directly to broadcast one of those, per the stalking jury instruction. As the jury instruction ends, it says that the defendant knew or should have known at least one of these acts constitute a course of conduct, again, that would cause someone to feel harassed based on what I have just described to the court. Well, each of these would be something that a reasonable person would believe would cause someone to feel harassed. So again, I think we've met the stalking statute as to both. And again,
C-SWEP, the point is that it is just one possibility out of 3 and not one of them has been proven. Exactly. Like I said, I mean, there's been so much and many situations where there could be multiple reasons why. The phone also we talked about could have been, a dad taking the kids in and out of a car when the parents were exchanging the children and it just fell out of his pocket or his, flannel shirt. It's not just one possibility and only one, right? They'd never established if it was or wasn't in some of these instances. FFS. One thing I am certain of, though, is Rosalio had the intention of harming Zachariah Anderson in some fashion. That's established with the text messages between him and Sadie. And what also I have noticed is Sadie seems to have a trigger temper or a short fuse, if you will.
Again, Rosalio Gutierrez mentions to at least one friend that's in evidence, hey, this is happening to me. Certainly there are a number of texts between himself and Sadie Beecham where they express significant concern about what's happening. Rosalio Gutierrez even talks about, having a confrontation with this individual. This was abundantly presented in cross-examination in this case. And that is a sign of an individual.
Dingleberry actually points out things. If you listen closely, which I know it's difficult after a while, he actually brings out things. What do they say? Within every lie is a nugget of truth. He does sprinkle in some truth on occasion. They were watching TV right next to the patio.
dealing with feeling harassed in a situation. It's a very logical reaction to feeling like some person you don't know is harassing you. So that I think that there's abundant evidence of stalking as to both of those two per the presentation I've just made. As to the homicide, I'll go right to the element of causing the death. The court has now heard 3 members of the Wisconsin State Crime Lab.
Actually, the more I think about it too, couldn't they have put Sadie on the hook for colluding, if you will, to harm Zachariah with those text messages between her and Rosalio and the broken legs? Question mark.
I think I count over 40 total years of experience in crime scene investigation and blood evidence from those 3 individuals. The court knows the State Crime Lab have many of the preeminent experts in this area in our state. They have all offered the opinion that this particular thing located in the defendant's van, simultaneous with seeing that shortly before, per the evidence in this case so far, his van has a cutout section that would be an area sufficient to store the body of Rosalio Gutierrez.
Prove it, Dingleberry. Prove it. No one's proved it. The defense should have proved it or disproven it. You should have proved it or disproven it. No way.
At least for a short period of time. There is blood found in that van, and that blood is in fact the DNA of Rosalio Gutierrez. So to transport the blood of Rosalio Gutierrez away with the strong evidence of motive, with all of the other things that we've talked about happening on April 25th, the 8th, and the 13th, and then with the significant deception that the defendant engages in his interaction with law enforcement on May 19th, combined with the rest of the evidence we've presented in terms of circumstantial pieces, from the state's perspective, we have provided sufficient evidence for any reasonable jury to conclude a homicide has occurred. Thank you.
Thank you.
Just briefly, very quickly, Judge. The argument that Mr. Graveley just made with regard to the reasonable person aspect of stalking only relates to element 2.
Reasonable person would know to tie your tie right
would
if
have
you're going
caused
to
a
be in
reasonable
a
person to either suffer serious emotional distress or to fear bodily injury, etc. But the important thing here is element 3 is that the defendant's acts did cause that person to actually suffer serious emotional distress, induce fear of bodily injury or death. So that's what we're missing here, is that there's been no evidence of that.
Blood.
Well, again, the definition of suffer serious emotional distress, which is located in 2 and 3, is the same, which is harassed, which includes the subsection harass.
And again, just briefly.
Well, no, that's your point. You're combining the act with the cause with the effect. You're merging them into one concept. That's a great band,
by the way, cause and effect.
But the definition remains the same.
Oh, I'm not arguing that.
So yeah, you both have to, the conduct and the result, but the result is the result of the words suffer serious emotional distress can include that the individual involved feels harassed.
How about maybe just a broken leg?
But that still doesn't cover both elements that we're talking about.
Where does that fit
2
in
and 3. Really, well, the reason, logically speaking, the reason why element 2 exists is that we're adding a reasonable person standard on top of the actual causation that's represented in element 3. So presumably there could be a situation where somebody is overly sensitive and wouldn't be that reasonable person standard, which is why the state has to prove that additional aspect of it. But also, I think it's a leap to say that eavesdropping on somebody is harassment. And that's essentially what the state is saying. But checking in on the mother of your children and see what she's doing that doesn't rise to harassment necessarily.
No, I don't know about that. But I'm not having such trouble, but I guess I think there's a step being skipped here. In merging the cause and the effect. The cause is
my head's big enough.
Harassing behavior by the defendant, And I think that there's evidence there from which the jury could conclude that that element is present. The
I have to go try my hat on. BRB.
defendant's argument, as I understand it, is that where's the evidence that the defendant's acts had the effect of inflicting the
one of the subsections in 3 is caused Rosalio Gutierrez to suffer serious emotional distress.
right.
So yes. So the second element here is what would a reasonable person be feeling out of this, right? That's the second element. The third element is what did the named victim feel out of this? But the definition remains the same, that when you opt for to suffer serious emotional distress, whether you're speaking about the reasonable person or you're speaking about the victim themselves, right? It's still the same definition of suffer serious emotional distress. It's just all that happens in those change of elements is what would a reasonable person feel? And then what did the purported victim feel? In this case, the way you do that, you can't read the mind of individuals, right? We know this, right? And in all instructions, it's from the acts and circumstances, particularly when you have a deceased person, right? So, otherwise you would never be able to stalk a person if you managed to murder them. You'd never be able to do it, right? So the third element here is what impact did this have on Rosalio Gutierrez? And within the definition of suffer serious emotional distress, one of the options is, did he feel harassed? Okay. So what is the element? What are the pieces of evidence he felt harassed? Well,
Dingleberry, show me where Zachariah harassed him. Other than when he brought OA there. To say, look, see, she's, with Booger.
Well, he told.
And also the broken leg thing. I mean, it was Rosalio that said maybe just a broken leg.
Told an individual that he felt that this person was a problem, and if the court remembers, the court limited that evidence on various times. We described it. We were wanting friends of Rosalio Gutierrez to talk about how he had identified an individual who was a problem for him. But we did manage to get one individual to be able to say that, and in their text messages back and forth, which were covered extensively, Judge. It's clear that Mr. Gutierrez is feeling harassed, and I told you I think the most clear answer about that is the way he is planning on solving the issues that are related specifically. Is he's thinking I will go over there. He does as much as collect the address of this individual, and I think that's the most rational and logical way that one would respond. So elements 2 and 3, the only change is. What is a reasonable person going to be impacted? And then element 3 is how about the victim himself? But it's the same definition of suffer serious emotional distress. So certainly a reasonable jury could say, based on the facts we heard, Rosalio Gutierrez is someone specifically who would feel harassed here.
If I may.
Well, they didn't. The legislature did not use, or at least. Yeah, this is the legislature. This language is taken from the law itself, not just a pattern instruction from the committee. But they didn't use the word annoyed.
Didn't use what word?
They didn't use the word annoyed.
No, they didn't. They chose harassed.
They chose intimidated, threatened, terrified, harassed, or tormented. Now, we had a case in here a couple of years ago. Not you,
was
but
feeling when Brandon and Michael showed up.
A couple of people from your office, And
I'm sure he was tickled pink. They were probably coming over to play canasta.
The prosecutor, well, all of our names who were involved in the case, our addresses were published on the internet. My children's names were published on the internet. What the goofball thought were my children's addresses were put on the internet. All wrong. So I was annoyed.
You know what annoys me?
Cautioned my family.
His stories.
I made them aware of the situation, but
and Graveley's inability
in the case
to tie
of
a tie.
At least one of your assistants, the correct information was published, and you know what he went through.
Stupid face. What else?
I don't know. I don't actually know what his reaction was. I know what a reasonable person would have felt. Terrified.
I don't know what a reasonable
intimidated,
person be feel terrified to have two
tormented,
show up in the middle of the night and ask them where their buddy was.
That's what the reasonable person would have felt. And if you told me that he was any of those, I would say it makes sense to me.
Which, come to think of it, could have just been part of the cover-up.
And I think the significant difference is that in my case, I knew the information was faulty,
Irish?
so I was still very annoyed.
That hat
but
day
I would
started
not
last
qualify myself as having fit into those
night. It's
categories.
too big. It'll go in the too big for my head pile.
It depends somewhat on the nature of the provocative behavior.
I think this would look
And
good
the
on
question
Jamie.
is not whether, there's.
She looks nice and
I won't
pink.
talk about your assistant, or I won't talk about myself. But there are people who would react to that by searching the person out and beating the living daylights out of them.
Kind of like
Happens
with
all the
Brandon and
time.
Michael
That's our
showing up
business.
at Zachariah's
That we
house,
deal
maybe,
with
huh?
these types of cases on a daily basis. So I'm not sure. Terrified, intimidated, threatened, maybe harassed, tormented.
This person was.
You're talking about now. We're not talking about the reasonable person. We're talking
I
about
understand.
Mr. Gutierrez, and
We're not talking about.
so if
the
that element were written
reasonable person, we're
as
talking
being
about Mr.
annoyed,
Gutierrez. Isn't that
I
what he
would
just
quickly dispose of this motion.
He's peeped on twice. So within 3 weeks, he is inside the privacy of someone's home, their castle. Okay.
Who remembers the Susie and the
And a
Banshees
person
song?
who does not have a right
Peekaboo.
to look in the window, make observations, and then taunt individuals outside does those things, Judge. That's the allegation here. 2 separate times in 2 locations, he is eavesdropping on private conversations inside the home. This is I would say to you, that's the definition of harassing someone. That is the definition of harassing someone. If somebody was outside your or my window when we were in the privacy of our own home,
Isn't it
and they
community
were
property
then
outside an
communicating
apartment?
to people that we were close to and saying, here's what I am observing in there. Here's what you just said inside your house.
Yeah, that would prove what a reasonable person's reaction would be.
But this is a deceased individual. So how, I mean, so the court knows that those things occur.
I can't presuppose that, by the way. I'm not the jury.
We cannot look into the mind of an individual in this situation. We cannot do that. So except what I've told you already, what I've already shared with you, which is we've shared extensive email information back and forth where he and Sadie talk about how the stress of this particular experience, right? They're communicating about this. And Rosalio Gutierrez's reaction, shared with the jury, is, I think I'm going to take care of it. I think I'm going to go find this guy. I'm going to deal with him. And they even have a conversation revealed in the text messages about the address. And, you know, so the court indicated, well, you know, if someone shares your information on the internet, that might be your same situation. Yes. But the added information the court has is that what Rosalio Gutierrez knew at the time was that his information was he had been literally peeped on twice in private residences, where then the information obtained in that peeping on him was being used to taunt people. And I'm not even talking about breaking in his vehicle, which of course is something that is a worry as well. Private information, right? So, for instance, what happens is a letter is taken from his vehicle, and that letter is utilized to try to indicate that Sadie should be watching out because he's actually in some other relationship.
Pause. Josie just says, keep up with Zach. New journal entries have been added to the website. I just said earlier, I would like to do just like a separate live stream reading his journal, because I've read a couple. You know, I need a clone, really. Jamie, do you like this hat? Would you like me to send it to you? Pink. It's called, what's it called? Mix Up Yarn. It's like different textures. It's really cool. And it's super soft. It has like Angora in it. No. It's very soft. Angora-like. But I think that would be good to have like pink is your favorite. I thought so. I think you should have that. I think I'll, just so you know, it'll probably be sent. Send me your address on one of the ways you can get in touch with me. Oh no, did I just break my nail snipper thing? Sigh. I'll probably send it in like an Amazon thing, because I don't I'll tape it inside a reused Amazon package. But it's very soft and it'll keep you warm. Alrighty. But wouldn't that be a nice thing to do, is have like a separate thing just going over all of his journal entries, and then that's something that you could share with your friends. You know, there's no evidence he was peeped on. It's only hearsay from Sadie. Angora adjacent. Yes, it's very soft. Okay, I'll put that aside. Okay, let's let the dingleberry continue here.
In a way to try to harm Mr. Gutierrez.
The statute deals with effect, not cause. You're talking about cause.
Again, cause and
You're
effect.
talking about effect on a reasonable person.
Okay, so for those of you who grew up in the 90s, Cause and Effect was like one of the most underrated awesome bands ever. Actually, their keyboard player was here at Glam Slam, which was Prince's nightclub downtown, Glam Slam. And they were here for a concert. I don't remember who they were opening for. I think they were opening for Information Society. And their keyboard player died. Crazy. Well, anyway, so those of you who know how much I love Ian Runkle, I swear in their video, you think you know her, that video by Cause and Effect, it looks just like a younger Ian Runkle, in my opinion. Okay, there. I may have played it a few times for my Rumble audience and said, doesn't this look like Ian Runkle when he was younger? Okay.
And the motion, as I understand it, is
I want to know. Yeah, that's
the
another one.
effect on Mr. Gutierrez.
Oh, that's
He's
Information
dying to talk
Society.
again, so I'm gonna let him.
And I'm being so patient, Judge, because I didn't want to interrupt Mr. Gravely. But
I think
I'll
more people
quote
need to interrupt
from
Mr. Gravely because he's a
a very
dingleberry.
significant text from Mr. Gutierrez. I'm not worried about it. It's exactly what he said. And the argument that one is guilty of stalking and the most compelling proof of that is the fact that Mr. Gutierrez wanted to beat down Mr. Anderson. That's stalking. I mean, so that he had a reaction like, I want to take care of this, I want to deal with it, and simultaneously saying, I'm not really worried about it. You know, I think the court's right. It may be something that one gets annoyed by, which is why I had the discussion about for something to rise to the level where it's criminal conduct, this type of criminal conduct, that it needs to be, you know, an actual effective harassment. And the most, I get a bunch of fancy arguments here about how, and again, he's focusing on reasonable persons, but we have evidence that it didn't bother Mr. Gutierrez from his own words. And in fact, you know, one could glean that he almost found it amusing that he was going to break his legs or do, you know, call somebody up to do something to him. But that you can't prove that one's harassed because they want to beat you up, you know.
Well, I think that
according to that definition, Zachariah Anderson was harassed
I
too.
think this is the appropriate test. I can't exclude the possibility that the jurors will see it as Mr. Graveley does, and that a reasonable jury could come to that conclusion. When you use the word terrified, as the statute does, that kind of shoves aside a reaction like, I'm going to go confront the guy and I'll take care of this. That to me is more the reaction of an annoyed person rather than a terrified one. But it's not, I'm not so sure of that I would grab the issue away from the jury. So I'm going to deny your motion.
Right. And just so the court, you know, the subsection says or. So terrified is one. Thank you.
Yeah.
Thank you.
I just think it, you know, the court denies my motion, but he still has to add anything to
well,
it. We're done.
Now, come on now, let's play nice. And your other motion with respect to the fourth count, did you make some comment on that?
With the hiding corpse?
Yeah.
Very simply that, you know, we don't have a corpse, and I know we don't have to have one, but the evidence of, again, the aspects of that, similar to count 3, I simply asked the court to analyze the evidence as to what evidence there is that a reasonable jury could find that Mr. Anderson himself, as opposed to anybody else, hit a corpse with the intent to avoid apprehension for a crime. And I acknowledge that there was, if there is a corpse, if there is a death, which I know that the state has to prove that as part of this, but even supposing that, I'd ask the court to make that determination. I'm required to make the motion in any event.
Well, if the jury is satisfied of the state's proof on count 3, then there was a body and it's gone. And there's evidence from which the jury could conclude that it was the act of the defendant that led to the removal of the body. So motion is denied. What else?
That the defense wanted to just inform the court of where we are witness-wise for the remainder of the day. There was a development where the state had talked to an individual, and that nixed the necessity of 3 witnesses we had lined up for this afternoon. So now, instead of having 6 witnesses for this afternoon, the defense only has available 3. However, we believe that those 3 will take up this, if not the whole afternoon, the majority of the afternoon. So that's the 2 witnesses who are in custody, Marquand Washington and Nicholas McAtee. And then we have an officer witness available to testify after that. As far as the other witnesses, due to their commitments and availability, we have them all lined up for Monday. And we have a remainder of, I believe it will be 8 or 9 witnesses for Monday. And so given that the majority of these witnesses are short, we would expect to rest on Monday afternoon.
Well, do you have comment, by the way?
Of course he does.
I appreciate that counsel have tried to keep me appraised of our developments. So, and that is why we were able to remove 3 witnesses. So, I mean, I guess I want to tell the court, I think that development was a positive one. When we interacted, we were able to check some things that I think allowed them to not need to call those witnesses. So, no, I think that is the current schedule, and I defer to them about.
Mimsy says, no body, no blood, but inferred, lied. There was all throughout. I mean, I don't know. Again, I'm an accountant, but some of these trials I've watched, I just don't know. I mean, I don't recall ever hearing the prosecutor infer, if you will, things that didn't exist without an objection. Isn't that what, like, facts not in evidence is? That one? Gravely sitting there like he didn't know what happened to these 3 witnesses. Are you inferring witness tampering, maybe? Since I don't know what I'm going to expect to see here. The jury decides matters of fact, not the judge. Oh. Witness tampering. Interesting. I still would like to go down the rabbit hole of Rosalio's mother and Facebook girl. I have a hard time buying the fact that they didn't know who each other was. Number 1. That'd be an interesting little... He's the gatekeeper. The judge said he did not think that there was enough evidence of stalking against Rosalio. It is his responsibility to then drop the charge, not hand it to the jury.
About how many more witnesses they have or where they think the
This
schedule will
doesn't
take
make
us in
you
terms of money.
sweating,
The,
like sweat bullets. I'm not sure
well,
what
first
will.
off, the last word spoken in this courtroom this afternoon will be at 4:30.
Dingleberry?
That is the last word in this courtroom this afternoon.
Meaning we're not going past that is what I think the court
You
said.
are so right.
But that doesn't think about what happens if we're done at 4 and they have no further witnesses.
You know what? I'm not going to go to the complaint department if you
Very
want.
good.
Here we go.
But just
Here
so
we
you know,
go.
you're not.
Nothing past
Again
4:30.
with let's just rush through now that the defense
muzzle will
finally
go on
has
at
the
4:30.
microphone.
Gotcha. That's number 1. Number 2, no matter how many witnesses there are on Monday, and you tell me that you consistently refer to short witnesses, and we've had a few. I think you mean brief. No matter how brief they may be ready for instruction, and I do instruct first. Be ready for instruction on Monday, which is why any requests that you have on verdicts or instructions will be due at what did I say when we were talking?
At 5 o'clock Sunday.
5 p.m. on Sunday. 5 p.m. on Sunday. Send it to my email that you've gotten on prior communications, and of course send copy to the other side. And you can list the instructions by number unless you have changes. If you have changes, you need to set forth the full change you want. And highlight the differences between the standard and what you want. Sometime before noon tomorrow, I hope, this is not for sure, but I will hope to send you a preliminary draft of the boilerplate stuff.
And if the boilerplate stuff is what we anticipate, then we do not need to communicate with you at 5. If we have no different,
Hi, Sean Bird.
You're comfortable with everything.
Very good. So you still would like us to communicate and say something. Got it.
Recommend.
And just so I make sure I'm understanding everything, if we're just asking for the standard instruction, we can just simply include the number. It's only if we're asking for a change to include that and the difference.
That is correct. And I did mention when you were up here before that the statute I think is a little difficult to work with in terms of making a fully intelligible statement to the jury of what exactly needs to be proved. So while I'm not demanding it of you, the form that was in the preliminary instructions, which I will repeat in the ones that are sent to you over the weekend. That follows the what's in the information, and I think it's awkward. But if if both sides are comfortable with that, far be it for me to jazz around with your case. Was there something else? I don't think so. Anything else from you folks?
Back at 12:30.
Well,
Please.
can we have lunch? I mean, we can't go get lunch and be back by 12:30. It's impossible.
Well, there is fast food available. Yes, and you can even have meat if you like. All right.
So what time should we be back?
12:30.
Okay.
No, the jury's been so good.
Yeah.
And I feel like such a traitor if I give you more time than I give them and have them sit up there in the dungeon. I probably won't lift my voice if you're here by 12:40. Okay?
Thank you, Honor.
Now, let me just ask this. Is there a medical reason why you longer? Oh, okay. No, you have to eat, but I just did.
I'm at a loss for words. So let's have this speak for me. That's what's going on in my head. Oh, I say all the time. It must be a Scandinavian thing. Oofda. It's a bad tick. I actually looked up like how to get rid of those. Filler words is what they're called. Alrighty then. Oh boy. Defend your client. Here, look, they wanted to go have lunch and the McJustice system sounds like they didn't even give them time to run through McDonald's. Stupid. I don't know. Like I said, if this doesn't make the hair on the back of your neck stand up, Lord help any of us if we are in the defense, sitting at the defense table in our McJustice system. Good Lord.
Pardon me?
If a judge believes there might not be enough evidence, but believes a reasonable jury could disagree, the proper thing is to give it to the jury to decide. What about if the judge has a serious head injury? Is it reasonable to think that maybe he doesn't know what he's doing? Yeah, it's a good thing I don't drink. Or seldom.
I did not. I didn't realize what.
I think that's what we are hoping to argue next.
Oh, well,
So-
give me a moment.
So it'd be this would be a good time, Judge, if you have the time.
They keep adding stuff to my pile.
So there's a
I
report
agree with you. I just wanted to
from
try to-
Badger State Investigative Services, and then there should be 2 copies of criminal complaints.
Yeah, the judge has the responsibility to properly gatekeep his court. This judge doesn't know what he's doing. In my opinion. But what do I know? I count beans for an occupation. Interesting. Now what is he doing? Oh, golly. I don't think this judge is competent to gatekeep a jar of jelly beans, let alone all of this. Count beans for a living. Looks like he's gonna fall asleep. I don't know, I'm gonna start skipping. I'm gonna skip until they start talking.
Washington, and
Was applied. What's up?
so Judge, those are our witnesses, and we're recalling Mr. Washington.
I hope he's retired.
And then we're going to confront him with some of the statements that Mr. McAtee stated in that investigative report that you just read. And what we want to do is then call Mr. McAtee. And I can anticipate the objections, but it's well founded that this is just bias evidence, and that it's very clear that, according to Mr. McAtee, that this was an invention of Mr. Washington's to help himself in his federal case, and we want to present that as exactly that.
C-Swep says, I am not speaking to the directed verdict. I'm saying the stalking charge against Rosalio was a joke, and the judge knew it. I mean, seriously, how many of you have dogs and you walk by, depending on where you live? I mean, I guess I don't know how far away your house is from the street, but, you know, does that mean someone's stalking you if they're walking their dog and it's like past your, you know, living room window and they overhear you? That's stalking? I don't know. That probably doesn't make any sense. He failed in his job and he knew it, and that's why there will be a new trial. Well, like I said, why in the world? This is one of, what, a handful in the grand scheme of things, trials that are, you know, televised, that those of you who like to watch trials get a chance to see. I mean, this is just a sampling out of the however many thousands, millions, I don't know, trials that go on every year in our country. And the more of these I watch, the more, I mean, you know, another thing I was thinking too, Gareth Pursehouse's trial for that beautiful Dr. Amy Harwick, the one that was engaged to Drew Carey, the guy on Price is Right, formerly on Whose Line Is It Anyway, and the Drew Carey show. The roommate, her roommate that was downstairs that heard the commotion, you should have seen how much he was put under the microscope in the very beginning. But yet they didn't put Sadie under the microscope or anything. I mean, it's just, I don't even know where to go. Yeah, mentally unfit. Well, I guess my point was, you know, this was one that was televised. Where's the outrage amongst, like, the attorneys in the community? You would think that, well, you know what happens when people start ruffling feathers, so to speak, peacefully. It's like, I don't know. I don't know.
Bias evidence. It's also, I mean, that's the overarching theme, legal theme anyways, which is...
Actually, she was a therapist. Naughty time therapist. So it wasn't, I don't know if you watched the trial or not, but she had in her home, things that you would put in a naughty time dungeon, if you will, because that was her thing. I don't think Drew Carey did have a dungeon. Did you watch the trial? Or maybe he does. I don't know. I like Drew Carey.
Just to say that encompasses inconsistent prior statements and also contradiction evidence, but it's all under a rubric of bias. And so I think that if you look at State versus Yang, U.S. versus Whitmore, this confirms that is the avenue that we can take. But mainly it's the constitutional right. State versus Barreau, 2002 WIS App 198 is probably the best case on this in terms of bias and self-interest and impeaching credibility. So we're impeaching the credibility of Mr. Washington, and of course they have the opportunity to do the same with Mr. McAtee because he's in a similar situation, facing the exact same things that that Mr. Washington is in terms of federal penalties. They're in different cases, but they're facing the exact same mandatory minimums that you quite often face in these drug conspiracies in federal court. So, so that's the essential elements of what we're trying to present here, and I think it's well founded. There was things with Mr. Washington that were not covered on direct or cross because at the time we didn't know because we hadn't interviewed Mr. McAtee. And so now that we have, with the permission of his lawyer, and his lawyer should be here for his testimony because I've been in contact with him, there won't be a privilege problem. And Mr. Graveley is also intending to potentially impeach him with some jail phone calls, which were produced to me yesterday. I reviewed those. I don't find much in there for impeachment. But in any event, I think one of the items that Mr. Graveley might have an objection to is some of the comments that Mr. McEntee made about the district attorney's office and Mr. Graveley in particular, and that is that he, and you read the report, but that he polishes witnesses. That is, they have one story, they go in to meet with somebody from the district attorney's office, suddenly they have a different story and they get a good deal. So that, to me, is his perception, his lay opinion about how he perceives the district attorney's office. And so that may or may not be a bone of contention for the court, but I don't think it should be because it's his perception. And then finally, I think that Mr. McAtee can testify about not only these, well, they're not going to be inconsistent statements anymore because, and they're certainly not going to be hearsay because we're going to confront Mr. Washington with them first, which is why we're calling him first. I guess after our next witness, but in that order. So, I don't know what other legal basis Mr. Graveley might have for excluding any of this, but I'll let him speak to it.
I didn't hear counsel say that he was going to ask to introduce any statements of Zachariah Anderson through McAtee. Was I correct that he does not intend to introduce?
I did not hear that.
What?
I didn't hear that.
You did
I did not hear him
make an offer of that.
Right.
Right. Okay. Because I believe those all would be hearsay, of course. Any statement from
they're going to be arguing
regarding McAtee hearing any communication, anything that would be considered a hearsay statement from the state's perspective is simply inadmissible under the definition of hearsay 90801 and its exceptions. But counsel did not
while they
represent that,
bicker,
so
I'm gonna
at
put
this
you in
point,
my
I
pocket
believe
and go
he is
downstairs
precluding
and
himself
throw
from
something in
asking
the
those
oven.
questions.
Well,
Oh, I'm sorry. I interrupted?
And I might bring myself.
Well, I was just
up
going to
some-
correct. I'm
Okay.
saying they're not hearsay because he's going to have a
Snap.
chance to confirm or deny them. Mr. Washington is. And so I'm going to ask him specifically what was attributed to him. He'll deny it, and then I'll ask Mr. McAtee.
No, I'm sorry, counsel.
No, he's talking about he's talking about a concern that you may attempt to introduce statements of the accused through Mr. McAtee. And you might want to know that Mr. O'Bear is behind you, wagging his head no.
No.
So that appears to be the consensus.
I will always take guidance from Mr. O'Bear, but no, but it's more of an absence of statements. In other words,
I don't know.
Mr. Washington says,
Somebody
here,
did.
no, what we're doing now is we're talking about something that isn't an issue right now, because while it's true, he did not exclude that possibility, which is what you said, he also did not advance it. So I'm not going to touch it. It's not on the floor right now. If he tries to do that, we'll have to look at the rules and apply them.
Okay, well,
that generally under State against Johnson, as you well know, the defendant's statements are gauged by the same hearsay standards as anybody else's when offered on his own behalf. So we'll leave it at that.
Okay, so then in terms of the absence of statements, I just want the court to have this so that we don't have, I'm hoping to avoid our long pauses that the court has, been concerned about, and that I think all parties are at this stage of the trial. So, I think this is a sincere effort from both sides to try to give the court our arguments ahead of time so that we do not end up in that situation each time. So, I have quoted multiple times with a little bit of relish a case State v. Tabor, Tabor, because of the wise circuit court judge who made decisions in that case. It is at 191 Wisconsin 2nd 492 Court of Appeals case.
Look at that
and
window.
it's a 94, I think 95
eat
opinion.
chicken
And the
wings
court,
ever
this is
again.
it's an analogous situation in terms of the absence of something, right? Criminal conduct, those kind of things. So in that case, in Tabor, the court ruled that in a sexual assault case, you could not bring on additional people to say, well, he didn't commit a sexual assault against me, and I was similarly situated, those kind of things, right? And the court said that's irrelevant. On the basis of relevancy, you said the fact that a person has not done some injurious conduct to one person is not relevant to whether they have done it to another, even if there's a similarity of situation. The Court of Appeals agreed with the court. The Court of Appeals felt that the Honorable Judge Bruce Schrader was completely correct on that matter. And to me, this is an analogous situation, right? You could have 50, 100 people in the jail, all of whom could say, yeah, he never confessed to me, never confessed to me. It's irrelevant. It's irrelevant for the reasons that you outlined in Tabor. That is my argument about the absence of something happening with people who have some similar situation. Judge, I think we have a moment of consensus in me indicating that I think that Marquand Washington, in light of this investigation, can be confronted. So I do not take issue with that, with whether he made these remarks to Mr. McAtee. If he denies that he made those remarks to Mr. McAtee, then I believe it would be admissible to have Mr. McAtee take the stand. Obviously, if he denied that, I apologize. I think I said admitted. At that point, I think I'm not disagreeing that anything Marquand Washington said regarding this issue can be asked of Marquand Washington, and then I think there's a hearsay exception that is appropriate. The one thing I do want to say is, if I read this investigative report correctly, he is prompted in what appears to be a decision based on his jail phone calls, which is a change of decision. He's prompted after hearing the testimony of Mr. Marquand Washington on the radio And so I am concerned that that may be a vehicle that the court, should at least pay attention to, in terms of whether, so that is the only piece there. In terms of the reputation, and it doesn't say DA's office, counsel said that he was talking about the DA's office, but according to the investigative report provided by defense counsels and the person in defense counsel's contract employee, he says the DA in this case is a master of polishing witnesses. This would be a pure speculation unless he's speaking about his own case. And he appears to have heard this from inmates, which would mean that, of course, his basis would be hearsay. He goes on to say that people who have had prior recanted or corrected witness statements then turn out in light most favorable to the state. And he goes on to conclude that this prosecutor that he is describing, he's heard about this mainly in domestic violence cases. And I think the court knows that in my last 15 years of employment, which would be during the time Mr. McAtee would have some basis of hearing rumors or gossip or statements from parties, that my assignment has not involved domestic violence. And so I don't know when I would have interviewed a domestic violence recanting witness in any case. Obviously, some homicides are domestic violence, but that would not involve a recanting witness because those individuals are deceased. So we would end up having to put on a witness, theoretically, who would describe what my duties have been over the last several years and who would describe whether I have handled any domestic violence cases.
Any deeper into this?
He just keeps going and going and going and going and going.
You're presupposing I would be receptive to this opinion evidence from Mr.
McAtee.
McAtee anyway. Are you intending to offer that? Reputational evidence about the prosecutor?
Yeah, it's not necessarily reputational. Well, I guess it is. Yeah, but it would be opinion testimony rationally based on his perception, having spent a lot of time at the jail and seen people come and go. And so he doesn't need to get into specific instances. But yeah, so that would be part.
Maybe he's just a Republican.
And I'm aware of places in the statute where sometimes you're allowed to bring up reputational evidence of witnesses and other parties, but I'm not aware of one.
That's for truth and veracity, not for.
Right, but I'm not aware of anything that says you can comment on prosecutors. Or defense attorneys, just so we're trying to be as even Steven as we can.
Yeah, and so that raises one last issue here, which might actually make Mr. Graveley a witness. So we were the defense team, were contacted by a number of people and were sent clips of Marquand Washington's direct testimony. And in particular, and this was people watching Fox 6, etc. And of course, I did not see this because I was up questioning him, but the clips were essentially, Judge, that you remember, I don't know if you remember the testimony about him describing Zach in his sleep, and he said, quote, die, 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 motherfucker, end quote.
I do.
So that exact testimony where he had the court TV cameras initially pointing towards Mr. Washington, but then as he was saying those words, those very words, the camera panned to Mr. Graveley, and one can see Mr. Graveley mouthing the words die, die, die. And so I had members of the court TV staff make a clip of that, so it's unaltered, directly from their feed, and I was going to confront Mr. Washington about that very subject, and also what, more in depth about what his conversations with Mr. Graveley was in terms of preparation, and whether or not that makes Mr. Graveley a witness, That's a question for the court. But I intend to mark that as an exhibit and show it to him and question him about it.
That when they panned, I repeated the same thing he had just said?
No, you did it simultaneously. It was simultaneous and it's very clear.
And so why would you have, why would either the video be evidence for the jury?
Oh boy,
and
here we go.
Why would I permit Mr. Washington to comment on it unless you're suggesting that you said simultaneously?
Simultaneously.
Unless you're suggesting that Mr. Graveley has been feeding the witness answers.
That's exactly what it looks like. I mean, that's why people contacted us. It's exactly what it looks like. And, you know, it's the same thing with, you know, this whole business about Mr. Anderson supposedly putting his lips when his daughter's on the stand or whatever, signals to a witness. So
well,
it seems fertile grounds for cross-examination of Mr. Washington. And if the court wants to review the clip that I'm talking about, I'm happy to provide it and mark it as an exhibit right now because it's compelling, and that's why people sent it to us. I wouldn't have seen it if people hadn't sent it to us.
We're 45 minutes late getting started. So finish up and then.
So the report provided by law enforcement regarding what was said by Marquand Washington includes that phrase. So this is not a phrase that was invented in the courtroom. It's not a phrase that is in any way something that the state provided to Mr. Washington in this court. And, you know, the judge, I've been exposed to a number of outrageous charges in this case.
Shut up.
The court has
kidding
patiently
me?
listened to those. There has been absolutely no feeding of any testimony to any witness. I have litigated for years and years and years and have no intention of jeopardizing my law license or my career by feeding an individual witness on what is just a case that's going on in a criminal trial here. And this kind of accusation, and I understand that counsel got it from somebody on the internet. But
really,
this kind of accusation
just like you got the clip of
poisonous to this
Zachariah?
proceeding. And I just want the court to know that I don't think it is an avenue that's an appropriate avenue of exploration.
This is what we call Graveley getting a little taste of his own medicine, if you will.
In front of this jury, it essentially accuses this prosecutor who they have had to listen to and have this go on throughout this case, and puts in the mind of a jury.
Okay, no. The first trial I covered was Letitia Stoke. That was through WebEx, I think it was. And there was a stationary camera on like the lectern and the defense and the prosecution. And then there was a stationary camera on the judge, and there was a stationary camera on the witness where applicable. And the microphones they were like voice activated. And in my opinion, that was the tightest run ship I've ever seen. I wonder how Judge Warner would have presided over this trial. It would have been a heck of a lot better. I think it should be that way for all of them. I mean, granted, it was kind of hard to see. And Letitia tried to like shrink into the wall and then cover her stupid ass face with her hair. But still, if that would have been the case in this courtroom versus the cameraman deciding where to go when, I bet you Graveley mouthed most of the testimony. Sure looked to me like he had a script he was working off of. Don't get me started. I'll just keep going.
The suggestion that I have fed some evidence, and it is, and I want the court to see that clip before it ever made a decision that such a question could be asked of Mr. Washington.
And
I'm not going to.
Half Irish Colorado has a different setup for sure. I'm just saying, I know a lot of people complained about it because, you didn't get those, tight shots of the defendant, sweating bullets, if you will. But I liked it, and I liked the sound. Like Lori Bello Daybell's trial, there was like a rodent clicker freaking keyboard warrior next to the microphone. Remember, it was audio only until like the end. I couldn't handle it. Oh, jeez.
To pre-screen what questions might be asked and give approval or non-approval in advance. You'll know. If there's an objection, I'll rule on the objection.
But the taint is out there then, Judge, is my concern.
Well, I don't, if he claims that you were feeding answers, I can't tell him. You can't do that. He's entitled to make that accusation if he wants to. And if it turns out badly for his case, they'll...
Oh, here we go.
Not... I don't know how I would preclude him from something that he claims.
You know what they say about people who lie, their mouths get very dry.
I suppose if I have ultimately to make a rule on this subject, then I will look at this video. But that in and of itself is not going to be determinative.
And with those WebEx ones,
I will tell you, well, I'm not going to say.
Half Irish, I think Valhalla's most recent trial was in Colorado with the same setup. Once you get into WebEx, you can actually, like, it took me a little while to figure it out, but like you can make the witness, I think that's what I did for most of it, was like you could make the witness screen bigger and then the judge and then like the defense, because you really couldn't see Letitia very much. Although that trial was interesting watching her defense attorney. He's like, by the end of the day, every day his hair was such a train wreck because he'd just sit and pull it. There's parts of the trial where he's like banging his head on the desk. It was just interesting. But those, I really liked it. And I liked how the audio, I mean, it took some getting used to, but you don't have all the like crinkle paper sounds and mucus sounds that we've seen in some of these. Just butthurt because a million people are watching you finally, and you got caught for once in 30 years. I'd really like to see what his record is for, like, if he's had any, violations, if you will, complaints.
Let's just begin.
Judge, if I could have we're starting with an officer before we get into the inmates. So it'll be a quick...
Okay, I want to know who in the true crime community subscribes to Pinata Farms, because we could really have fun with Pinata Farms. That's the one where you have, like, music, and then you just have to, like, put people's heads on it. That would be kind of fun. I saw CapCut yesterday had an update. I'm still skeptical.
Witness, so then we can get...
Well, where is the officer?
He's outside because we were discussing other witnesses' testimony.
Can I ask did the court sign a court order as we were required to do to get some sort of a clip of this interaction between myself and Mr. Washington?
He's that guy that like lives next door to you.
I did not sign any order.
I used this analogy the other day.
I issued a subpoena to Law and Crime, and they provided.
He's the kind of neighbor that, like, if you mow your grass and you just, maybe you're not paying attention, maybe a bird, like a bee or a fly, goes into your face as you're mowing the grass when you're on, like, your property line, and you just happen to sway a little bit more. He's the guy that'll probably come out and measure it and say, knock on your door and say, you mowed a little bit of my grass over here. You know that guy. The taint is out there. Joseph dancing. Or, oh, here, let's go. And for those of you in Fraser Crane mode and you heard that and like Pavlov's dog, you ran over to see it, let's do it again. Isn't fun. How about this one? We haven't done this one for a while. Let's just do it just for fun. See, what I'll do is I'll just like share those with you. So next time when you go, for those of you who do live streams of trials, just put those on for entertainment. Even if it's, you know, it's just for fun. We haven't seen Bitch Face today either, have we? Sadie, Susbus. That one's really funny too. Just think what I can do once I finally get used to that cap cut, if ever.
Edit it for me, and so if there's some foundational question, I have somebody available.
Thanks.
You guys with the orange and the dancing
Law
lady, that's
and
funny. I love it.
And Madam Court reporter is going to be James Kendall.
Can I bring the jury in?
Yeah.
I want to do something with that clip of Eddie Murphy with Aunt Bunny. She's got a mustache. I hate her. Do you remember that from Delirious? When he's told by his mother he needs to go give Aunt Bunny a hug and a kiss. Oh, another thing I was thinking too. So for those of you who remember back in the day when we were discussing immigration through Ellis Island, and some people, like I know my great-great-grandparents that came over, their name was Americanized to something more plain. But they would change the person's last name that kind of, matched maybe their occupation. Like Taylor. Maybe they were a tailor. Their name was like, they Americanized the names as they came through Ellis Island, is my point. Or at least that's what I was taught. Graveley, kind of wondering the origin of his name. Maybe his family were like gravediggers. Or undertakers. And he just went rogue and went into the legal system. I don't know. Maybe you don't remember that.
Okay, good afternoon, and let's continue with the defense. Would you raise your right hand, please? Do you solemnly swear
the
testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
That's a dent in his head, isn't it?
Now, before you start,
or is it a big giant
I did also, in a moment here, start to read the original complaint in the that you had supplied to me. And I remembered it immediately because at one point I think the case was assigned to me, so I'm familiar with it. And it would appear to meet the requirement of the prerequisites under 90608 of recency and nature of the conduct described to qualify as impeaching material. Just so you know, and it had nothing to do with this particular witness. So go ahead.
Thank you. Good afternoon, Detective. Could you please state and spell your name?
Yes, James Kendall, Kendall.
And Detective Kendall, where are you currently employed?
City of Kenosha Police Department.
And for how long have you been employed with Kenosha Police Department?
This is my 28th year.
And in those 28 years, how many years have you been a detective?
Since 2005.
And are you currently assigned to any specific division or role, or is it just generally where you're needed, you'll go?
I'm a financial crimes detective.
And back in 2020, was that your assignment?
Yes, ma'am.
I'm going to jump to May of 2020. Do you remember being involved in an investigation regarding Rosalio Gutierrez?
Yes, I do.
And what was your role in that investigation?
On a specific date in May 2020, I was requested by the Detective Bureau Supervisor to follow a vehicle from one evidence storage location to another.
And do you remember the details about that, or would you need to see a report to refresh your recollection?
I remember.
Okay. And so do you remember the vehicle that you were watching being transported?
Yes, it was a 2004 white Ford Explorer four-door.
Okay. And could we pull up?
You need it? Is there a picture of it? Okay.
That's fine.
What do you need?
I think it's exhibit 1. I think it's. Okay, if you could just look on the screen, I've pulled up States Exhibit 1, Photo 1. Do you see the vehicle you were just referring to in that photo?
Yes, ma'am, I do.
Could you just describe where it is for the jury?
It looks like it's in an apartment building complex in the parking lot.
Okay, it's that truck in between the squad car and the four-door vehicle?
Yes, ma'am.
Thank you, counsel. So you followed that truck and to, was it Jensen's tow yard or a different tow yard? Do you remember?
Jensen's tow yard.
Okay, and when you followed the truck and it arrived there, what did you do next as it relates to the vehicle?
I had the tow truck driver raise the vehicle. It was on a flatbed. Raise the vehicle.
And why did you ask the driver to do that?
Another request from Detective Bureau Supervision was that I would look for any GPS devices that might be attached to the vehicle.
And why did you want to look, well, strike that. Why did you want it raised to be able to complete that?
Just to be able to look at the undercarriage.
So did you do a complete examination of the undercarriage?
Well, I guess I would define what you would define as a complete examination.
What type of examination did you do in your search pursuant to the other officer detective's request?
Look for anything that was obvious. It's a 2004 Ford vehicle that has Wisconsin winters underneath it. So it's pretty rusty. So I was just looking for anything that might be obvious that would stick out.
And did you find anything?
No, ma'am.
Did you search any other areas of that vehicle?
The inside cabin, I recall that the vehicle had a bunch of tools in the rear of it, as well as in the interior. So it was just a couple of locations in the council that I looked for.
Did you remove any interior portions of the vehicle to search anywhere?
In my report, I refer to removing the consoles, but that was the glove compartment, just to see if there was anything that had been installed behind that. And then the fuse panel for the vehicle to see if there was anything installed there.
Did you find anything?
No, ma'am.
I have no further questions for this witness.
Detective Kendall, this was an activity that you conducted on May 20th, 2020?
Yes, sir.
So in the evening hours of May 17th, 2020, do you have any idea whether any kind of GPS device might have been mounted on that vehicle in any fashion? So
I'm going to object to speculation.
Well, the question itself requires whether he has any idea. That in and itself is not speculation, but the next question would probably be loaded with it. So you can have that answer, though.
I'm sorry, can you repeat?
Sure. Well, I'm going to ask you a hypothetical question instead. If someone had removed a GPS device that they had placed on this vehicle 2 or 3 days earlier, let's say on the 17th of May.
Judge, I'm going to, no, because at this.
My hypothetical, counsel. If
Well,
I could finish.
Your hypothetical is argumentative.
Quiet. Finish your question.
Thank you. If someone had removed some GPS device that they had placed on this vehicle, say in the evening of May 17th, 2020, would you have seen any signs of that removal in the inspection you conducted on May 20th?
I'm going to object as it's argumentative in the form of a hypothetical question.
No, he's actually, it's somewhat argumentative, but it is specific information that he's seeking from the witness. The objections overruled.
It would be unlikely.
Okay. And so, based on your inspection, do you have any means to have knowledge of whether a GPS device was on this vehicle 3 days earlier?
No, sir.
Nothing else.
Nothing, Judge.
Mr. Counselor.
At this time, Your Honor, the defense will recall, Marquand Washington.
Continue to be.
From his prior testimony, Judge?
Yes.
Okay. Thank you.
All right, this is. Can you see me okay, Mr. Washington?
Yes.
All right. Kind of problematic here, but we'll do the best we can. Yeah. I'm just going to move over here a little bit. All right. Mr. Washington, you testified a few days ago. You remember that?
Correct.
Where Mr. Graveley asked you some questions and I asked you some questions, right?
Correct.
All right. So, but there's been some development, so I want to ask you some more. If you don't understand any of them, again, feel free to ask me to repeat them, okay?
Okay.
And if you want to take a break or confer with Mr. Graveley or with your lawyer, that's fine too, okay?
Okay.
So, I wanted to ask you a number of questions about, I just want to actually refresh your memory, first of all, about your time in the cell with Zach.
Okay.
So, if if I remember correctly, you had, and I'll just summarize these, but you had said that he was sleepless and
Objection. This is all leading. So this is a recalled witness. If this lead, I'm going to object leading.
Well, Judge, first of all, this is originally the state's witness, so I would ask for some leeway to treat him as a hostile witness. I think that's fair.
Well, it is somewhat leading. It is strictly cross-examination, but up to this point, I think I'm going to overrule the objection. Go ahead.
Okay. So, but you've been in custody on this federal case, well, starting when? What's your recollection?
Since October 19th of 2021, I believe.
Okay. And during that time, there was a period of time when you were sent to segregation or the hole, right?
At what point in time were you asking about?
January, February timeframe of 2022, so early last year.
I believe I put myself in a hole when they moved me off of the unit by Zach and them, because they moved me to the dorms and I didn't want to be in a dorm, so I placed myself in a hole, yes.
Okay, so you did that voluntarily?
Correct, to get moved back to the cells.
Okay. And so your nickname, is it Munch?
Correct.
And do you know an individual by the name of Maine?
Maine?
Maine.
No.
Do you know a Nicholas McAtee?
McAtee? No.
McAtee?
No.
Okay. So when you were in segregation in early 2022, well, first of all, can you just confirm that segregation is a situation where you're in a cell by yourself, right?
Correct.
And you're in your cells 24 hours a day, right?
Correct.
And you only get out to shower?
Correct.
And you can't see people in the other cells, right?
Correct.
But you can talk to them, right?
If you know somebody or want to yell through doors, yes, you can.
Okay. So while you were in there during this time frame, you were in on a federal case, right?
I am federal MA, yes.
Right. And in KCDC, there's that's one of the facilities that the federal government uses to hold federal prisoners, right?
Objection leading.
Um,
Hold on. Hold on for just a minute. What the purpose of these facilities are is where it's a yes or no question, leading.
What he knows, and again, this is...
I guess what is there a dispute about particular issue?
There isn't. I'm hoping we will get to something as opposed to...
Your objection is overruled.
Thank you.
So that's a facility that's used by the federal government to house federal prisoners, right?
Yes.
Okay. And while you were in segregation, I'll call it, you would probably call it the hole, right?
Correct.
So while you were in segregation, there was another federal prisoner there that you were communicating with from your cell, right?
No.
Absolutely not.
Absolutely not.
Okay, so let me just make sure that is this the only time frame where you were in segregation?
Every time that my level has went up and I've been moved to the dorms, I would place myself back into the hole to get moved back to privacy. So probably 2 or 3 times.
2 or 3 times. And in those 2 or 3 times, you didn't meet an individual by the name of Maine?
No.
Also known as Nicholas McAtee?
Never.
And so you weren't talking about, you didn't have a conversation with him about, quote, jumping on other people's cases?
He already testified he doesn't know the person. So by definition...
Well, I will say that when he was asked the question, he was asked about McAtee And I believe that the answer was, I think you said McElty.
But I was trying to pronounce whatever name he
Well,
said.
I understand, but
Correct.
so it's not entirely clear to me that he really understood who the information was desired about. So the objections overruled.
Okay. You made a statement talking about how easy it is to, quote, jump on other people's cases, right?
No.
You made a statement that says, quote, you have to find a way to put yourself on someone's case to get time cut off your sentence, end quote.
Absolutely not.
You made a statement after someone inquired about how you do that. You said, quote, you have to get a person to talk and find out about their case and make yourself part of their case, right?
No. Wow.
You made a statement that says, quote, what if you, well, you were asked, what if you don't know anything about the case? You said, quote, then you lie about it. You said that, right?
No. What are the dates on this?
Well, you tell us. When did you say those?
I never said that.
Okay, well, then the dates don't matter, do they?
Objection. That's it. Hold on.
Okay,
That's
all right. I withdraw. I withdraw that.
Stop it. From now on, you state your objection and you're done. All right? That was kind of an argumentative question.
It was. I withdrew it.
Okay.
So you also stated, when asked if you would lie about somebody's case, quote, absolutely, I do what I need to do. It's either them or me. I would just go and tell a detective that I know some information about a case. If I have to make it up, I would do it because it's either my life or their life, end quote.
That is a lie.
Okay. But you agree that in KCDC or any other jail, there's a lot of people, quote, jumping on cases. In other words, getting to know somebody and then calling up detectives to try and get time off of their sentence, right?
Objection.
I haven't seen it.
Just hold on. If there's an objection, you wait until I rule on it. Now, I didn't hear your objection.
I think it's irrelevant and would call for hearsay.
Overruled.
You can answer.
I haven't seen that done or talked to nobody who's done that. No.
Okay. Well, how much time in your adult life have you spent in jail?
I've been to prison twice before this, state prison.
Okay. For how long?
The first time I did maybe 4 years, I think, and then I got revocated after that for about 3 or so.
So during, before those prison stays, you spent time in county jails, right?
Yes.
And that's where, and so you're saying, how much time in county jails?
So
just in round figures.
Again, objection, Judge. This is just irrelevant, and it's being used to try to attack the character of this particular defendant under a particular avenue.
Well, actually, if it were clear that it was being used just for that purpose, I wouldn't admit it. But my impression is it's being used for a different purpose. The objection is overruled.
So about how much time would you say you spent in county jails?
Months, maybe. I'm not sure.
Okay. So in your time in county jails, you've heard of people learning about a case and then calling their lawyer or calling a detective and saying, hey, I got information about, Mr. Jones's case.
Irrelevant if he's ever heard of it.
Rephrase your question.
Okay. You're familiar with the concept of somebody jumping on a case?
I'm familiar with informants.
Okay. Well, like jailhouse informants, right? Is that what you're referring to?
If that's what you call it, I guess. But I know about informants, yes.
Well, I mean, there's informants that might be on the street, right?
They could be locked up as well.
Right. Like you.
Right.
for example, right?
I'm locked up, yes.
And you're an informant, right?
That's what you labeled it as, I guess so.
Well, I'm not labeling it. What would you call yourself?
Objection, again, irrelevant what he would call himself.
Okay. So you have heard of the concept of people jumping on cases, right?
I'm not sure about the jumping on cases part, but I heard about informants getting whatever, being an informant and telling on people, yes.
Right. Like in jail, they would tell on maybe their cellmate or somebody they would see at meals or whatever that they had gotten to know, right?
Objection, irrelevant what other people do or what he's aware other people do. What?
The objections overruled.
You can answer.
What did you say again?
I said you're aware of these informants in jail, informing on or calling detectives or their lawyers about somebody else's cases, somebody that might have been their cellmate or somebody they know just from the general population, right?
I'm guessing people do it. If I've done it, you saying, that's what you're saying?
Yeah. So you're familiar with that concept, right?
I guess so.
And some of those people just flat out lie to try and help themselves, right?
Speculation, objection.
It would incorporate some speculation.
I'll rephrase. Those people that are doing it are out to help themselves, right?
Objection, again, speculation.
The objections overruled.
I'm not sure what other people do things for.
So when you were preparing to give your testimony last week, there was some preparation involved, I would imagine.
What do you mean?
I mean, you met with Mr. Graveley or you met with other police or other members of the prosecution team?
I met with them and told them about my statement and stuff before that.
Okay, I don't mean your original conversation with them about the statement you gave on January 18th of 2023. Was that the first time you had met with them?
In January, yes.
And so when you sat down with Mr. Graveley and the other people that were present that we already talked about, was that the only meeting you had with them?
No, I think I seen them before, another time after that before court.
Like one other time, two other times?
I believe it was once.
One other time? And where was that?
I don't know if it's this building or where it was at, but here in KCJ or whatever it is. I don't know. I don't know the name of the building. I'm not familiar with.
Well, was it in the jail?
It was here.
It was in this building or in their office?
I think it was their office.
Okay. And so how long was that meeting?
Not long as the first meeting.
What, that was their, okay, no. All right. That was the meeting where you first gave a statement?
No, this time when I met with them and I seen them, that was the second time I had seen them.
Okay. Because I thought you just said it was the first, but okay. So now we're clear. That was the second time. And it was just those two times?
That I'm aware of, yes.
Okay. You think there might have been another time you weren't aware of?
No.
Okay. So just those two?
Correct.
All right. So, and so in that second meeting, that was to prepare you for your testimony that you gave last week, right?
If that's what you call it, I guess. I don't know.
Well, that was the topic of the discussion, wasn't it?
It was, yes, to let me know everything that I had told them that they had went over and stuff like that, correct?
So they went over with you what sort of reviewed what you had already told them.
Pretty much, yes.
All the stuff about Zach's sleeping habits, right?
They just repeated what I had said to them, yes.
So they were repeating stuff to you from the reports they written from your first meeting?
Yeah, they read what I had said and let me know that they had made a statement about it, yes.
Did they show you that statement?
I didn't get to read it or no.
Okay, so they just told you what you had said?
Correct.
Okay, and was it Mr. Graveley was doing that?
Yes.
Okay, and was anybody else talking, or was it mainly him?
Mr. Graveley.
Okay, and
Can I
so
hear you, sir?
Mr. Graveley.
So he told you, this is what you said before, this is what you said before, this is...
Here's the point in the testimony where I'm really hoping that this attorney is like, and when did he tell you to say this? You know what I mean? Like one of those Matlock moments.
You just went right down the line, right?
Although I'm not going to hold my breath.
Pretty much, yes.
Okay. And was this the point where he was saying, well, if you stick to this, I'm gonna look out for you, and I'm gonna go to bat for you with the federals?
He never said that.
Okay. So, but that was your understanding, right?
What do you mean?
That was your understanding that if you said the things that he was saying in that meeting, if you said them on the stand, then he would go to bat for you. That was your understanding.
If you look at it, I guess so, yeah.
Okay. So when you actually testified, when you were in that seat last Thursday, I believe it was, you had made a comment about Zach saying, quote, die, 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 motherfucker. Do you remember that?
Correct.
And while you were speaking those words, you were looking directly at Mr. Graveley, weren't you?
I'm not sure who I was looking at the time.
Okay.
He asked me, I think he had asked me the question, so I may have been looking at him, but I'm not sure.
Okay. And as you were mouthing those words, he was mouthing them back at you, wasn't he?
I can't say I recall that. I don't remember that.
Okay. One moment, Judge. So you don't have a recollection of that?
Correct.
Would it refresh your recollection if I played you a clip from Court TV showing that very moment?
Objection, Judge. From the state's perspective, this is if this is something that's going to be shown in any fashion, it's not been disclosed.
Well, the
previously.
question was whether it would refresh his recollection, which would ordinarily not be, just be for the witness to observe.
Well,
whether it would refresh his recollection.
In the context of asking, they explained what it was. I assume the purpose of that was to let the jury know what the item was. So I would object to the phrasing of it. And again, we've had no notice of this. This is not an item that's ever been disclosed.
Well, yeah, I hate to do this. Please don't talk about the case during the break. All right. I think the district attorney's point is has some validity, that it wasn't necessary to get into what the source was. But I mean, what else would it be? The witness is fully aware there's a camera trained on him all the time. So obviously it's court TV. But the question actually is, would it refresh his recollection, which would ordinarily not be something that would be seen by the jury anyway. And I didn't know whether there had been an answer or not from the witness. Quiet. Huh? No answer. So he hasn't answered. As far as there being no notice, I mean, how much notice can you have had? It just has come up.
Has it just come up?
Well,
they haven't told us that. They have taken the time to do a subpoena.
Well, when would they have gotten the video?
Well, this was last Thursday, Judge. We are now that is 8 days ago.
Right.
So if this occurred last Thursday, counsel has not provided you any information about when that subpoena was done or what this is. We have a right to have notice of things that would ever be utilized as an exhibit or actually used for demonstrative purposes in court.
Well, we're not that point.
Well, okay.
Just for the record,
refresh his recollection.
For the record, the subpoena was yesterday, so I can.
Well, probably he would answer the question. I'm just proposing to add.
Well, the question is, if you saw a video of what he claims occurred, would that refresh your recollection on the question previous? Does that make any sense?
No.
I'm not sure how it would refresh. I don't remember.
I said it's not. He doesn't know if it would refresh it or not.
So let's try, because it might.
He ended his remark by saying, "I don't remember." He's already said, "I didn't see that." So how do you refresh? Counsel, just for a second. How do you refresh someone's memory when they have said, "I didn't see that and I don't remember"?
Well, actually, the law on refreshment of recollection is that anything can refresh your recollection, whether the witness is familiar with it or not. I don't see the harm. I am going to look on too, while he looks on it, and in case we get further into this.
Just so that the record is clear, I've just now been handed a copy of this. Rather than being handed a copy at some prior time, I've just at this moment been handed a copy of this item. Thank you.
It was subpoenaed yesterday. And when did you get it?
Somebody at our team got it. I just became aware of it earlier in this week, and then by the time I acted on it, so.
Well,
we weren't sure who the witnesses were going to be or what. So.
Well, we'll see. Let's take one thing at a time. The current inquiry is he doesn't know whether it would help him or not. So I'm going to let him look at it. And there's a separate issue in the event that the state desires to offer it.
What's the date today?
7th.
Just quick round of
I beg pardon?
The state desires to offer it in case.
Did I say state? Oh, Kevin, you're here. If in case the defense desires, well, if anybody wants to offer it. But all right, you can show it to him, and let's set it up so I can see too.
Did you want me to put it up here?
Yeah, if you know how.
I think so. I'm gonna need a.
What now?
Done.
Yep.
Sure, I have to have my sound on for this.
I have a quiz. Or a question. Or a puzzle. So I just looked up the specs for, because it sure seems like some of the people who think Zachariah Anderson is guilty are sticking with that piece of missing carpet in the back of the mini Dodge Caravan. All right. So, riddle me this. The width of, well, let's do it this way. How many inches would you say the rear view mirror, not the rear view mirrors, the side mirrors are? I got to get a piece of paper. Because the width of it includes the mirrors. So would you say those mirrors are, I don't know, 4 inches times 2, 8 maybe? Or is that generous? So get a pen and a piece of paper. So if you take the total width of the Dodge Caravan, the dimension that they give us includes the mirrors. So you're going to need to subtract off the mirrors. So I thought, well, maybe we'll just do like a guesstimate. The mirror, well, I mean, I could go in the garage and measure, I suppose, my truck. But so if you subtract out the mirrors, I mean, I would think those mirrors are 4 inches a piece across, wouldn't they? Or when they fold. And then also subtract off of that then like the exterior and the interior of the vehicle. I mean, I would think that would be 56 inches. Okay, so let me just do math here. Oh, I think that's definitely plausible. So 10 inches aside, let's just say. So it's 76, what did it say? 76 and a half. Width with mirrors, 78.6. Okay. And let's just say between the width of the mirrors and the width of the actual car itself, till you get into the interior, the wheel well, the wheel well comes up to that. I would say has to be 10, if not more inches. Let's just say 10. Let's be conservative and say 10 inches. Okay. So then that puts you at 58.6. Now, if he was 6 foot tall, there's been some people say 6 foot, some people say 6'2". That's what? 70 inches? 72 inches? 6 times 12? 72 inches? So you're telling me that a 72-inch tall man wrapped in a carpet can fit side by side in a 58.6 inch space? Question mark. You're telling me he laid in the back sideways? That's impossible. Plus, on top of it, I was looking actually for the dimension from the middle of the wheel well to the back of the minivan. I bet it's, what, 12 inches, 14 inches maybe? I should just go pop the hatch on the truck, but Explain to me that. Explain to me how a 72-inch man, dead, can fit in a 58.6-inch space. Question mark. Just saying. I'll wait patiently. And even if he was bent, let's say his legs are bent, still, then it would make the width of it from where the, the hatch comes down back even wider.
Yeah, I do the sound.
The question is trying to calculate the dimensions of a Dodge Caravan minivan, including the mirrors, is 78.6 inches. So we're trying to subtract off of that the mirror, the width of the mirror, plus the width of the outside of the minivan to the interior of the minivan. We conservatively said, John Gary, for F's sakes, 270 bodies in a minivan, we're talking about the area of the carpet that was clipped out. I mean, if you think he was width or lengthwise, which I would have thought, but then there'd be more carpet missing. So we figured if the vehicle is 78.6 and you subtract out the width of the mirror plus the width between the exterior metal to the interior of the back is like 10 inches, roughly. I mean, that's conservative, in my opinion. So then that gives you a width of 58.6 on the inside of the back of the minivan. And then you can see from the picture, the carpet is cut out from the middle of the wheel well to the back. And 72 inches is 6 feet. That's why I said, I mean,
If we can get it louder.
If that's where, that seems to be like such a sticking point for people, why in the hell didn't the defense people do a reenactment? I mean, you couldn't even fit a dog back there. I mean, maybe. Maybe. I know that probably wasn't a very good explanation.
So that's not a perfect representation, given that there's some lag.
Well, the pending question is whether it refreshes his recollection.
Right, right. So do you remember, as you were speaking those words, Mr. Graveley mouthing them towards you?
It seemed like as I said it, he got to repeating it, but it didn't seem like he said it first and repeated it to me or something, if that's what you're asking.
I'm asking if it looked like he was mouthing them towards you as you said them.
Right there,
No, I'm saying from your memory. Not from what you just thought.
Oh, from what I remember.
Yeah.
I didn't remember that, but.
Yeah. All right.
And the jurors come back in now?
Yes.
All right, yeah. Okay, go ahead, Mr.
Thank you. So to answer the question is you don't recall that happening while you were testifying last week?
Correct.
John Gary, honest to God, did you fall down and go boom and hit your head too? If you remove or fold the rear seats, you could fit any person. The seats were removed. People are, including yourself, are implying that he was sitting in the back of the frackin' minivan in the area where the carpet was removed. That area, in a conservative assessment, is 58-ish inches wide by probably, I don't know, 14, 16, let's even say 20 inches deep. And you're telling me a man that was 200 and some odd pounds and 72 inches tall fit in that little tiny space? You need therapy. I mean that in a nice way, because you did say you prayed for justice.
That's all I have, Judge.
And plus, on top of it,
Washington.
it was raining. You would think that that would have exasperated the blood, let's just say. And you just can't be helped.
I believe we've spoken twice.
I believe so.
First time was over in the facility with several officers present.
Correct.
Took a little more than an hour.
I believe so, yes.
And you outlined what you had heard from Zachariah Anderson in as much detail as you could provide to the several people who were present.
Objection. He's couching. He's flavoring the answer for the witness.
I'm allowed to lead.
It is cross-examination.
Is that the case?
Correct.
Okay. And the second time we met, it was it appeared to you that the purpose was to prepare you for the trial.
I believe so.
Okay. Did you understand the trial was already going on?
Yes.
Did we spend around a half hour together?
Give or take.
Okay. And did I ask you whether did you and I go through the items that you had previously told myself and law enforcement at that previous meeting in January?
Yes.
And were there multiple people present for that meeting as well?
Yes.
Okay. And during that time period, the second meeting, did I ever use any phrase like that I would go to bat for you? Did I ever say anything, any even approaching that?
No.
In fact, you are a person who has a federal prosecutor involved in your case, correct?
Correct.
Are you aware of
Yep.
any ability I would
Sarah,
have
ding, ding, ding.
to directly impact your case?
No.
Is it your understanding that the way this...
I mean, isn't that kind of common in a defense, is to kind of reenact things that don't make sense? You know, as a visual aid, if you will.
would work is if you are honest in your testimony that your attorney would let the federal prosecutor know and they would make a decision on your case.
Correct.
Do you think that I am in any way a decision maker on what happens next in your case?
No.
Now, you were asked if something refreshed your memory, correct?
Correct.
Okay. And what was your perception of what you saw?
Sound like you was repeating what you already knew I was pretty much gonna say after I had started saying it.
So you were saying something and I was saying those words after I heard you?
Correct.
Now, you were asked several questions about, time you've been in prison and in the jail. Have you ever been a person who informed on individuals previous to this time?
No.
And have you informed on anyone else in this federal prosecution case other than Mr. Anderson?
I object. What's the possible relevance of this? This is exactly what he was seeking to keep out.
And was, go ahead.
Shame on me for not interrupting sooner.
Yeah, he is.
Rephrase your question.
Because he knows it's another one of his big giant Swiss cheese
You
holes
testified
in
in
his case.
Racine on a case you were an eyewitness to, correct?
Correct.
And other than that, have you provided any information to law enforcement about any other cases?
No.
No?
No.
Were you housed with individuals charged with first-degree homicide named Renan Brownlee? Was he somebody you were housed with at some time?
Yes.
Did you ever inform on him?
No. Objection. Same objection, Judge.
That's,
How is this possibly relevant?
Sustained.
Well,
State versus Tabor.
let's talk about the security dorm for a second, okay?
Yes.
Is that, if you know, is that called HW?
Oh, I would just reminded
You
myself to
talking
play
about the
nice in
hole?
the sandbox.
I believe so, yeah.
Okay.
Hollywood.
And can you describe how that is put together? Like, are the cells like circular where they all face each other? Or are there multiple levels? What do you remember about it?
It's kind of like cells that's covered up with little bitty holes in them that you could barely see through because you can't really see through them. And there's an upstairs and a downstairs where we can't really see who we talking to or really talk to nobody. And the cell that I was in was far to the back under the stairs.
Okay, so if I told you you were in 09, does that sound familiar?
I believe so.
And is that in the first floor?
That's the first floor, correct?
Okay, there's a second tier as well.
Correct.
Can you, you were on the far end?
Correct.
Do you know where cell or bed 20 is?
I believe that's way on the other end.
Okay, and is it upstairs or downstairs, if you know?
Which means he doesn't know.
I think it's upstairs.
Okay, so is it your memory of the whole that somebody on the first floor in 9 would be able in any real way to communicate with somebody who was in the second floor in 20?
He would be yelling and talking to everybody, so I can't see no person really doing that.
And if I indicated to you, you were in the hole from March 2nd to March 22 to March 5th, 22. I'm sorry, I apologize. February 2nd, 22 to February 5th, 22 in bed 9. Does that sound familiar?
Yes.
Okay. And while you were in during that period of time, from February 2nd, 22 to February 5th, 22, were there any other inmates in the hole during that period of time?
I believe there was, but I didn't know nobody.
Have you ever been in the hole where only one or maybe 2 beds were the only ones taken, or is it always occupied with more people in your belief?
Every time that I went, it was always occupied.
By
multiple different individuals.
Now, Mr. Washington, do you perceive there being a physical danger in being a person who would be a federal inmate who would become known as a person who had jumped cases or informed on people?
Yes, I do.
Okay. Would you ever be a person who would yell out loud?
No.
In a jail, well, let me finish. In a jail setting, recommendations or details about how to be an informant?
No.
Why not?
Because that's not something you want to be in here and for everybody to know that you're an informant. So let's just put it out there for everybody to know. Because you could be all type of, you could be beat up, you could be ridiculed, you could be everything. It's not safe to do nothing like that, and I wouldn't do nothing like that.
I got a quick sidebar.
Sidebar. I'm going to take this opportunity John Gary. Here's the website. If you want to litter the chat with arguments, I've had just about enough. It's right here on the website. Frequently asked questions. Evidence. Timeline. Cast of characters. Evidence. Unseen. We're trying to watch this trial, and you continue to litter your nonsense. Although I do appreciate the prayer for Zach and justice. Now, I will post it in the chat again. It's in the description box. I would encourage all of you to stop entertaining him.
The afternoon break, 10 to 15 minutes. Please don't talk about the case during the break. Read watch.
Because he's just going to keep going with the same garbage. There. I said it. Now you've seen my dark side. Yes, debating is okay here, but you know what?
Now,
When we're on day 13 of a regurgitation of things that we just can't agree on, it just gets to be a little bit out of the box. I don't know. I'm getting tired.
Play the video again.
While he's setting that up, I wanted to indicate to the court that the defense counsel specifically represented when the court asked the question that they had done a subpoena yesterday for this
Jamie, just,
item.
If I were you.
We have now been provided a copy, and it
Hi,
indicates that it was modified, meaning that this item was manipulated on March 15th, which would be 2 days ago at 10:14 a.m. So the idea that a subpoena was done yesterday, from the perspective of the electronics we've been given, appears to be demonstrably false. So
I want to, well, go ahead, finish.
Well, I just want to express to the court that the court asked that specific question when I complained about lack of notice, and counsel chose to make a representation to this court about this item, which is a surprise, and in which they sought a subpoena without any knowledge of either, certainly without the state, and it doesn't appear the court was directly involved. So to have misrepresented something so clear and fundamental from the state's perspective is something the court should take stock on in this case. You know, and this is not the first time we've had episodes where there have been specific representations made which were then demonstrably able to be proven false. And so here we are again. And so I just want to be sure the court is taking that into account when it thinks about presentation of this evidence in any fashion.
So if I made a mistake about a date, then that's one small error. But what's clear is Mr. Graveley always raises this after he's on the hot seat.
You know, why don't you just tell me what you want to say without commenting on Mr. Graveley?
So I think there's also no sound. Will help? This is on the Mac side.
So I just want to let the court know why I believe there's a lag that is clear. I believe that that Mr. Washington says, die, 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 motherfucker. Apologize for the language. That you can see me say die 2 times, which implies, from the state's perspective, clearly that I am behind and repeating what is something that is being said to me and to everyone in the courtroom.
No more questions for John Gary. If he hasn't gotten it by now, episode, what is this, 11 or 12? He never will.
This machine,
Disengage.
just show it
Alert.
To the court. I can't seem to play it.
Play it. Can you play it on the
Honest to
screen and
God.
take the audio off directly off the computer?
Okay. So
I don't know. If you can't, you can't.
try here.
What does that person say the other,
Oh, no, we got it.
earlier?
All
A
right.
series of unfortunate events. How much time did the defense waste with Mr. Snitch here
And
when he
what do you
testified the
remember about
first
that?
time?
I remember I was
When he testified the first time about if he understood what his sentence was? Honest to goodness, I'm even annoyed. I can't imagine what the jury would be like. Bring in a freaking demonstration of the back of the freaking minivan, or how 100 and some odd pound or 200 and some odd pound man can manage to cart out a man of equal, if not greater size, deceased, dead weight. Show me how that's possible. I haven't overstepped what I can only I'm a triplet mother. For Pete's sakes. You know, it's one thing. Day 2, day 3, week 1, week 2. We're on episode 11 or 12 here. FFS.
I was laying here the night before. I thought about the next day, but I was laying
It's a good
there,
thing I do this
and I
basically
was
as a
my foot,
as a
and I
hobby.
heard him shouting at sleep before he woke himself up.
Don't feed the
What did he
troll.
shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting, in fact,
Rerun it.
remember?
Yes.
All right.
All right, let's hear it again. We need some more language.
Judge, from what you would see on this screen, whatever it has to do with this feed.
Take it back about 2 minutes, 3 minutes.
Well, the whole thing's only 38 seconds, but I'll just take it to the beginning.
What did the poll say? Don't ask me
Last
for
count.
time.
Now my hat's
That's
going
the
to
one
be
thing
all
I can't give
wrong.
you.
See what you've done.
And what do you remember about that?
I remember I was laying there the night before. I told him about the next day, but I was laying there and I was reading my book, and I heard him shouting at sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
You're quoting, in fact, remember?
All right, I don't know what the exact timing is, but on the video, as I'm seeing it, it appears that Mr. Graveley, his lips are moving shortly after the witness testifies.
Oh, are you going to say it's like a timing video
Okay.
thing? It's just...
Not on the actual item.
Not on the what?
Not on the actual item. If you just plug it into your computer, it would not do that. It's very much simultaneous.
I've lost count.
Well, give it to the district attorney to view.
I did. His copy.
We believe we've reviewed our copy. We hear the defendant, I'm sorry, Mr. Washington say die, die, die. And I repeat die 2 times, which is
that's what I saw. Really?
Yeah. So I don't know what how I can simultaneously be mouthing the words when I'm not saying the same.
He claims that
he actually says
shows
that
up
on
differently
national television.
But just read my lips.
Pardon me?
But just read my lips. I only do it twice.
No new taxes.
Oh, only twice. Maybe the camp.
what?
I mean, for
No
real.
new taxes. It's a famous line from President Bush the Elder.
Oh.
Well, I'm not supposed to put those into state equipment.
One of the 2 Bushes.
But I have a personal computer here, and I'm gonna take a chance with it. Well, the record will reflect that I'm going to break the tape.
Speaking of the Bushes, did you guys ever see that clip from Saturday Night Live with Justin Timberlake? The Target lady? Target? Welcome to Target. Welcome to Target. And Justin Timberlake is dressed as, what was her name?
All right. I actually
Peg.
cut the tape.
Classic Peg. He needed to wax his Barbara Bush, he said. Because it was, I forget, something about photographs so much in the 90s. It's very funny. Look that up. SNL Classic Pig. Here, I'll drop the link. I could use a little laughter right now. Classic Pig at Target. SNL. Pig. Classic Pig. Okay, in his washing machine. Let's see.
But do this hypothetically. How can one code witness by saying something simultaneously with witness?
Oh,
Well, he says it's not simultaneous.
The representation is that I've said it first?
No.
Well, so what would we have rehearsed some?
I don't want to talk about it right now. I want to look at it.
Okay, so
Now where did it go?
when I first started live streaming on YouTube, I mean, I knew I had heard that it was very, I don't know, you could get thrown in jail. So I pushed the envelope one time and I played The Lonely Island. Remember when SNL used to do Lonely Island? And there was Justin Timberlake. I forget what the guy's name is, and Lady Gaga. I call her Lady Gaga. And they did the song 3-Way. It's okay if it's a 3-way. It's not gay if it's a 3-way. And I played that. And I got thrown in jail for a week. I can add that one too, if you've never seen it. Classic Peg is really funny. Target. Welcome to Target. Actually, it was funny over here. There's a Target like half a mile. And the R was out. So it was Target. So ever since then, when the kids are little, they're like, Mom, look, the R is missing. It's Target. So we still call it Target or Target. Or how about I'm on a boat with my flippy floppies? That one is good too. They're all good. They're funny. Oops. Oops. SNL three-way
I
song.
remember I was laying there at night. I told
Yeah,
him
so I
about
can
the next
say,
day, but I was laying there
oops.
and I was reading my book and I heard him shout in his sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die,
You're
die,
oh, it's called the
die,
Golden Rule.
motherfucker."
I forgot.
You're quoting as best you remember?
Yes.
Oops, pause.
And so, what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And what did he shout that you heard?
He said, "Die, die, die, motherfucker." So,
And what did he shout that you heard?
he said,
Oh, for
"Die,
Pete's
die,
sake.
die, motherfucker."
You're quoting as best you remember?
Yes.
All right. And so, did you ever have a discussion with the defendant about this?
He woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
Okay.
You're quoting?
To me,
yes.
All right. And so,
Okay, that one I just
it
posted is
appears
the Golden Rule.
that
The one I got thrown in
Mr.
YouTube jail for a
Graveley
week for playing.
said, "Die, die, die," and also that he did so simultaneously with the witness. That's my impression.
So Jamie Mother
that was
Lover
our,
is basically the prequel to the
exact
Golden Rule
assertion,
one. You
Judge.
gotta watch it. It's funny.
And therefore, that was the basis of my question, which I wouldn't have asked if the state hadn't followed up on it. But
our copy, they died twice. So I don't know if the court has a different copy or how that is working.
they're the same. You're right. He only says it twice on camera.
What did he shout?
Die, die, die.
What did he shout?
Die, 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 motherfucker.
Well, now that I look at it again, the camera actually
How long are we gonna talk about this?
takes you out of the picture at the point where I say I saw the third one. So
Die, 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 motherfucker.
maybe it doesn't show it three times.
No, it
I am
shows
getting-
it twice. Yeah.
Yeah.
Did you ever have a discussion with the defendant about this nightmare that you heard him have or that you heard him dead?
Yes, I did.
Okay.
Oh, I did not know that. Okay, adding it to the list.
I'm gonna keep this. You can get a copy from the district attorney, okay? And this is all one exhibit. Well, I guess it's already marked, so.
And I would move for its admission, just so it's part of the record.
It's received for record purposes.
Okay.
All right. So what's next?
Well, my next question will be, well, I don't want to preview it for the witness, but it'll be about this subject.
Okay. Did you ask the jurors to come in? Oh, I guess they're upstairs, huh?
Well, so far I'm not
Would you come down,
surprised
please?
that he was found guilty. From what I've seen, this was a train wreck from start to finish. Everyone failed. Everyone. Investigators. Freaking judge. Both Graveley and his sidekick always hold their mouths closed as if to stop the lies from coming out.
Judge says fair game.
Oh, no.
The fireworks are not done.
The fireworks are not done? What does that mean?
Now we're getting commentary on the case.
I'm surprised they haven't asked for the
Oh, is
dates
this
of
that
the-
recovery addict part? Everybody failed this man. The investigators failed this man.
All right.
Everybody failed. His own attorneys, in my
Mr.
opinion,
Purcell.
Thank
failed
you,
this
Judge.
man.
So,
Hey,
Mr.
Mira M.
Washington, when we broke, I think we were talking
Everyone
about
failed this man.
the statement you made about your
You've
time with
seen my dark
Zach
side.
and what he said in his sleep.
Correct.
The internet is
So
forever.
isn't it true that when you testified on direct, you were taking direct cues in your testimony from Mr. Graveley as he sat here at council table?
No, I don't believe so.
He was mouthing the words at you, wasn't he?
After I said it, he did say it. He repeated
He was mouthing the words at you?
Jamie, I see
Yes,
this
he
as
said
a
it
train
after I
wreck,
said it.
And that's where you took your cue?
as a cluster.
No.
Fluke,
Okay.
if you will. As a miscarriage of justice. As a clown show. As a true testament of how far off the rails our judicial system has gone. Yes. That too. Well, and if you watch the subcommittee hearings, the
That's all I have at
congressional
this time for this
subcommittee
witness. Thank you.
hearings,
Mr. Graveley.
it won't be any surprise to you
Originally in
that the
January,
judicial system is
who
the only
brought up
one that's
this
as
idea
cluster
that in a nightmare that the
fooked,
defendant
if you
had
will,
said,
as
die, 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 motherfucker.
what we're seeing here.
I told you
You
about
should
it.
see those clowns go
And,
in Congress,
when we
except for MFH.
and so when you
Clay
testified
Higgins.
on direct, when I was asking you questions, did you have an independent memory of that being what Zach Anderson, the defendant, told you or said in the nightmare that you heard?
Yes.
Yep.
And did you get any
Injustice
assistance
system,
from
the
me in
McJustice
either
system.
remembering that or testifying about that at all?
No.
Nothing else.
I have nothing, Judge.
You may step down, sir. Go ahead.
Defense would call Nicholas Bakati. Actually, I would like to have one moment before that, before we bring him out, if that would be okay.
I mean, for you to talk to him, you go ahead.
Well, those two lip glosses don't go together.
Why do we need a moment? This is not his attorney. This is his witness. My objection is let's keep going.
I hate this
Well,
man.
I agree with about half of what you said. But as I told the jury, I think it was just yesterday, that it's customary for the attorneys to speak with the witnesses for a moment in an ethical manner. And I'm
See,
not going
Swept,
to
I don't
deny
blame
him
you.
that.
Can I join you? Where are you going?
I beg your pardon?
Well, I'm going to ask we take a break if that's happening. Just a short
We
one.
just took a break.
Well, I know, but
If you want to leave for a moment, you're welcome to do so.
Thank you.
But come right back.
Thank you.
You know what's really hurtful is the Anderson family, in order for them to get their message out, has to repeatedly watch this disaster. Repeatedly, over and over and
I beg
over
pardon?
again.
Oh, it is.
Going to drink. Have one for me.
Well,
Or
there is
two.
a transport issue with the officers. I suppose because this will take
I wouldn't doubt that. He is a little on the
hopefully less than 10
hyperactive
minutes,
side.
another short break.
If I had a dartboard,
Please don't talk about the case.
my neighbors have dartboards in their garage. You know, because we have to entertain ourselves in the wintertime. Playing darts, if you will. All right, break time. And I don't have a dartboard, but I'm going to ask my neighbor next time I go over there if I can put up a picture of Dingleberry, and we can all take a shot at it. All right, here. Let's do a little entertainment. And for those of you in the back. And just because I feel like it, the goat. Goat's not loud enough. But I was on the conservative side with that because I didn't want to scare people. Holy shit show. All right. With the little lady. We need some maracas. You know, maracas. To shake around. I bet somewhere in the garage where all the old toys are, I could probably find some. All right, let's continue. Remember that Susan lady? Stop the insanity.
Okay. Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Okay, thank you.
Would you state your full name and spell your first and last names for the record, please?
My name is Nicholas Ryan McAtee, NICHOLASMCATEE.
Mr. McAtee, you appear to be in custody.
Yes, I am.
No, he just likes to wear orange.
Go ahead.
Let me guess, he's probably in for like something.
Object to this exhibit, Judge. Why
over
this
eager freaking
individual's in
Graveley put him
custody
in
is
there
irrelevant
for.
because there's no cooperation agreement, so this is not relevant. I don't have any difficulty with being in custody, but it's irrelevant.
My immediate reaction is it doesn't appear relevant.
Okay. I thought that Dave would be inquiring about it, but if they aren't, then that's fine.
Oh, perhaps they will. I don't know.
Okay.
Mr. McAtee.
Yes.
So you are in custody at tell us where you're in custody.
I'm in custody at the Kenosha County Detention Center.
Okay. And do you have a state case?
No.
You have a federal case?
Yes, I do.
Oh, dear.
And just, you don't have to get into all the details, but what's the nature of the charge?
Objection. Why?
What the objection sustained?
Okay. So
Didn't we get into that with
are here as
snitch?
a witness for the defense, right?
Yes.
And had you been, for your testimony, had you been promised any benefits for that testimony by anybody?
Yes.
Who?
The prosecution.
Well,
and
objection.
There he goes. Look at him. Stupid smart person.
You say
Pipe down, sir.
Prosecution meaning the U.S. government?
No. The state.
The state?
Yes.
Mr. Ami, to your knowledge, is there any kind of an agreement of any kind at any level, state or federal? Okay.
There's no completed agreement. There was discussions.
Well, so the answer, if there is an agreement, there isn't as of this point. Is that what I'm hearing?
That's correct.
Yeah, there's not.
You think the facts are otherwise?
No. There's not an agreement of any kind.
Okay.
Flap that wing harder,
Any
sir.
dispute as to that being the fact?
As of we sit here today, yes. Historically, that's not the case.
Now, don't testify.
Okay, but yes.
Testify. No.
Look at
You can ask a
Graveley.
question.
I will.
I know you won't disappoint.
Oh my God. You know who he reminds me of? In a weird way? Mayor Jacob, what's his name? Jacob Fry. We call him McFry. I call him McFry. Have you ever seen that video of Jacob Fry, the Minneapolis mayor, dancing? He's the same as this guy. He's got the same shit going on. Idiocity, if you will.
Thanks for the confidence. Mr. McAtee, the court just spoke with your counsel Mr. Ahmad. Is that right?
Yes.
So he's here in the courtroom. So as I ask you questions, or as Mr. Gravely asks you questions, if there's a time that you feel that you want to confer with him, feel free to ask, okay?
Yes.
Now,
How long is this
have you
guy
had
in prison
time
for?
to talk to Mr.
Question
Ahmad
mark.
about your testimony here today?
Yes, I have.
I mean, he looks like a normal, Wisconsin guy. Probably played, football. Lived on a farm. Doesn't look like a thug.
And do you feel like you've covered everything in terms of how this relates to your current legal situation?
Yes.
And do you have any questions for him at this moment in time?
No, I do not.
So getting back to what we were talking about before in terms of there's no agreement right now, but at some point there was some sort of offer?
Objection. This is irrelevant, and there is absolutely no way that there's relevance in this situation, Judge. Calls for hearsay.
I don't agree with you. The objection is overruled.
Was there a point where your understanding, without saying who said what, but your understanding about whether or not there potentially would be a situation where you would testify for the prosecution?
Yes.
And what was your
You can see it
understanding?
in his face.
My understanding was that.
Okay. Sorry, sir, I apologize.
I'm sorry, but could he finish his answer? Wait.
He wants to make an objection, I assume.
Why don't you tell Graveley to be quiet like you
Sounds like
told
he calls
Nicole?
for what his attorney
Agent
has informed
Orange.
him, since I'm not aware of any other basis, and that would be hearsay and would be
Speaking of the microphone, Gravely,
improper area
Dingleberry.
You want his attorney to testify?
Well, I would suggest to the court that Mr. McAtee is not the person who should be able to report that, because it is hearsay and is not appropriate for him to talk about that.
Well, then Mr. Gravely is going to be a witness because.
Please.
Well, no, because.
Please.
The bias in here is unbelievable. Granted, I almost said I am an attorney. I'm an accountant. I know nothing of this.
It's not hearsay because it's not being offered, I assume. Well.
Oh dear.
Well, it is hearsay, but I think it's an exception under the, what is it, subsection 4 plan.
Lynn says Gravely is freaking out because he was rejected and speaks the truth and has no deal. I was kind of thinking Gravely, is doing one of his tells. One of his many tells. Because he's afraid his methods are going to be exposed.
Intent, plan. Take a look at the statute.
Oh my God, I almost spilled coffee on the carpet. That's not good. His methods and sources, if you will, are going to be exposed. Should be exposed. Oh my God, I just had an idea. I'm going to clip that thing of of Jacob Fry dancing in the street. He's such a he's Dingleberry 2.0. And every time I'm going to do that.
Sub.
Let me find it.
90801.
3. 908. 908.03 sub 3.
Oops. Look
Are
at that nice young man
not
in
excluded
prison
by the
because of a
hearsay
dingleberry.
rule. Sub 3. A statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, such as intent, plan, motive, design, mental, feeling, pain, and bodily health.
Here it is. Okay.
So the question is really...
I'm sure I'm not going to get zipped for this. This is one of two. There's another one. You know the Cupid's Shuffle song? This is the Minneapolis mayor dancing the Cupid Shuffle. Look at him. Look at the dingleberry dancing. Oh, great. Not playing against. Okay, so in your head, just pretend you're hearing. This is not a very good video. I'll find a better one. Look at the dingleberry dance. Dingleberry 2.0. I'll send it to you. I'm getting some drag. Look at the dingleberry. This. Can you see the idiot? There's another one too. The guy in the white shirt with the jeans rolled up on the bottom is the mayor of Minneapolis. Dingleberry 2.0. Jacob Fry, ladies and gentlemen. Oh my God, he's such a clown. I'll try to find a video that doesn't skip. Oh my God, I can't stand him. There's another one that's even... God, it's just so bad. Okay, continue.
Really inquiring into whether he's been asked about whether there had been a deal discussed. And of course, he would gain awareness of that through his attorney, but it's not being offered to prove that there was a deal, but rather what his intent was. So the objection is overruled.
You can answer if you remember the question.
Yes, I was offered consideration on my federal case or testifying for the prosecution if I were to.
Did you consider it?
Yes, I did. Very seriously.
So I'm going to back up and come back to this. There was a time when you were housed with Zachariah Anderson, right?
Yes.
Do you remember when you were, was there more than one occasion when you two were cellmates?
Yes, on 2 different occasions.
So when, do you remember when the first one started?
Yes, it was in August of 2021, roughly October of 2021.
Okay, August to October 2021?
Yes.
And so when you're, was this in just general population?
Yes.
So when you're in general population, how much of your time is spent together? Some regulation about that?
Lockdown in the cell is roughly 12 to 14 hours on a general population dorm.
And so, needless to say, you spend a lot of time together?
Yes.
So, did you get along with him?
For the most part, yes.
Did you, was he forthcoming about his cases or his case?
Objection, state be taper.
I don't know how that applies here.
I'm not sure it does either, but I do think the objection is well stated.
Okay.
This is irrelevant based on state be taper.
So
I'm not sure I agree with what the case you're citing, but I do agree with your legal principle.
Thank you.
So, so you got to know him though over that time period?
Yes.
And can you tell us what you observed about his sleeping habits?
He slept roughly 4 hours a night. 5 hours a night. Not anything abnormal.
Was there ever a time when he would have nightmares or wake up screaming?
Objection, same thing.
Oh, see?
Irrelevant based on case law.
Dingleberry knows it's one of the giant Swiss cheese holes in his case,
now.
and he just continues.
It's a Tabor type incident. Pardon me? Well, why don't you do the citation? Okay.
Lynn Dalton has entered Fraser Crane mode. She's listening.
The number of cases that deal with.
I gotta add that to the list. Fraser emoji.
But are we making legal argument too, or are you just being asked
Nope.
for the
case?
Just asking for the case.
Why don't you just shut up, Dingleberry?
The most recent is a 2019 case. It is unpublished, but the facts are so remarkably similar that I'll give it to the court, at least for support. At State versus Yost, Y-O-S-T, 2019, Wisconsin Appeal, APP, 58. Again, that's from 2019. And that
At
talks
least we
about
haven't had our eyeballs
inmates.
burned today looking
I thought we
at
weren't going to
Sadie.
argue about
I'm not
the case.
arguing.
We were
I'm
just gonna
pointing
cite
out.
it.
Just give me the site.
Gotcha.
I suppose we'll have to save our eye bleach for tomorrow. It is Friday night, isn't it? Oh, party up in here. I'm not going to lie. I thought today was Thursday. I get so confused with the holidays.
Paragraph 11.
Y-O-S-T.
Paragraph 11. Yeah, Y-O-S-T.
Well, I actually am searching by.
Oh, I'm sorry.
Hoping Joe
It says
Giacolone
2019
comes
was
in one of these
58.
days. Are you hiding?
58?
Yes.
At what paragraph?
11.
He did not respond to my earlier SOS. Oh no. Sometimes I have to actually clip out of my video
Came up with
my SOSs. I might have to do that.
published case.
Joe Giacolone.
Yes.
It is
If you have
published?
some
No,
time, can you
the one
please
I'm
stop by Crime
talking about right now,
Spies
only
and
point
take
it
a
out
look
because
at
the facts are
this
so similar. There's
train
reference
wreck
to a
of a
general
trial?
rule in, as you see
We
in
would
that paragraph,
appreciate it.
Osseth versus Farmers Mutual Insurance, going back to 1959, talking about the general rule, as you can see, is that when the absence of a statement.
No, stop.
Okay.
Stop.
Gotcha. I'm not trying to argue. I'm just.
A disaster. Like I said about that jacket that they keep showing the picture of, I've watched too many, let's just say, politicians. And as soon as they start waving something, oh, look at this. All that means is it's crap. And you think the opposite. In my opinion, the only reason they keep showing him with that selfie of that flannel shirt with the, fluff lining is
Actually,
because he probably left it at Sadie's house. And that's just another one of their stupid ruses.
actually,
Fake
I did find a
narratives
nice article about
that he burned
medicine.
it. She probably had it. Oh, here, let's use this picture. And here's what I'm
I
going to
might
do
have
with
had
this
that.
jacket.
But it is
Implication,
It does
yep.
seem to fit the
Implied.
pattern of cases that Tabor.
Like I said,
Tabor,
I've worn many a tinfoil
I think
hat
the
for
assertion,
last
Judge and Yost and
6
other
years.
cases is that, and that just was one we cited because it was so particularly on point, which is that the absence of a statement assertion is not a statement made to prove the truth of the matter asserted. So this is contradiction
Jacket
evidence.
missing. That's what they keep pointing at it over and over and over and over and over again. Feeding their bullshit narrative. Because they know full friggin' well where that jacket
Councils,
is.
I think that I've made a hearsay objection. I have not. State v. Tabor is about whether this is relevant evidence, Judge. The court
Hi, Solomon
the court ruled
Anderson.
in Tabor that this is irrelevant.
I'm not gonna
There's a whole
lie.
line of cases that talk about that.
Well,
Dingleberry is
we're
on
not-
my
it's
last
not a-
nerve.
We're not talking about the hearsay object.
Here.
But in Tabor, it dealt with, you know, the victim versus the defendant. This is two witnesses.
Let's pause for a moment. And Zachariah Anderson is in the chat. For those of you who are in Fraser Crane mode, come back and say hello. That could be our mantra. No, just kidding. Let's do it again. There. Now that I have all of your attention, because those of you who are in Fraser mode have run back to your computer or mobile device to say hello to Solomon Anderson. I hope you're having a wonderful new year, and I hope this is the year that your brother gets out of this nightmare he's stuck in. Hi, Chrissy, my sister from another mister. And Happy New Year to you as well. Solomon, I just said like an hour ago, maybe not even a half an hour ago, your poor family, in order to get the message out, has to relive this shit show over and over and over and over and over again. It is just horrible what has happened here. And those who can't see this injustice, I can't help you. Also, it's my understanding you went and saw your brother today. Please share if you have a moment. Strife breeds strength. That's for sure. I think there's a Sun Tzu quote, I think, about. I'll have to look back. Together we are strong. Divided we are weak. Oh. Yeah, so here we sit, listening to this disaster. Now we've got this nice young man who apparently he's in federal prison too, from my understanding. And Dingleberry here, flapping his wings and his gums.
So it's completely in opposite to Tabor.
I forgot to add my thing about your brother. Hopefully 2024 is the year he gets out of that hellhole he's living in right now, and Dingleberry here is disbarred, and preferably wearing stripes by the end of it. My grandmother once told me that the Lord does not give us a burden we cannot bear. That's very true. I think my dad told me that when I told him I was having triplets. God only gives you what you can handle. Well, thank you for the reminder, Solomon. Your grandmother was a wise woman. I'm assuming she was Scandinavian, ? Okay, here. We're almost finished with today.
Tabor's holding.
Look at his face. I will be with you always. Yep. Where will I go in 45 minutes when this shit show is over so I can hear some good news about your brother? Are you going to be on look at his face. Oh, and we haven't done this for a bit. Today is day 1327. That Zachariah Anderson has been incarcerated. 3 years, 7 months, 7.5 months. Last we looked, the GiveSendGo was at $47,000. It's only $3,000 away from the goal. If you are able to contribute financially, look at how tired. that would be fantastic. Otherwise, considering we're in the Bidenomics economy right now, and coffee is $11.49 for Folgers, like regular size, not even the Costco size. If you could share the link, it's in the description box underneath. This GiveSendGo / ZA Anderson. And prayers are helpful. Oh dear. Just when I said we hadn't seen her yet today. There she is. I'm adding her to the dartboard too. 2 points for her. Oh no.
The objection is.
So what you're saying is I have to stop making my egg coffee?
Because all right, the objection is sustained.
Who's that there leading out? Yeah, $11.49 for a regular can of Folgers Black Silk. All Folgers. Doesn't matter what kind it was. That's insane. Good thing I'm starting to like that Earl Grey tea. And peppermint's pretty good too.
Sorry, I'll state for the record that for once I agree with Mr. Graveley.
Oh, for once?
Then I object.
Yeah.
I'm objecting.
Yeah, I'm sorry. At this point, it's not even funny.
Mr. Mack.
I'm sorry. I've been surprised the jury hasn't made a run for us, Judge, much less people in the audience. But
Oh, good. 3,000. Yeah, that's what we looked at this
Mr.
morning.
Mack.
Was 3,000 left.
I believe you said your first time frame was with, Mr. Anderson was.
Solomon, did you see on my Twitter account? I ran through just the cross-examination of. My voice is going away. Cross-examination of that quote-unquote lead detective, Korea. The cross-examination of it. It's on my Twitter page. I just ran it through ChatGPT, and it said, explain here why, with his testimony, why why reasonable doubt can be asserted. And I shared it with people who were watching, and it was actually kind of interesting. I mean, it's kind of time consuming, but I don't know if something like that would be useful. Because like I mentioned earlier, sometimes when you look at things over and over and over and over and over again, sometimes you don't see things. I don't know. I'm grabbing at straws here, I understand.
August 21.
Too bad this isn't a financial crimes. I'd be good at that one. Okay, let's continue.
Well, August of 21 till October of 21.
Yes.
Right? And then what was do people just get moved around a lot? Is that why some of this happens?
Yes.
Okay. So what was the second time frame, if you remember?
Second time frame was
with Mr. Anderson.
Beginning of February 2022 until beginning of July or end of June of the same year, 2022.
Okay. And so when you spent time together, was there discussion about his case?
objection. Again, it's
Oh,
same
the
objection,
Dingleberry speaks
Tabor.
again.
So I have an ongoing objection to the point that the court will allow that, indicating that Any statements made by the defendant to him?
Well, I wasn't asking for the contents of the statements or anything else.
Was there a discussion about the case, which sometimes
Actually,
can
Zachariah,
be
or Solomon,
with hearsay, but I don't think in this
every time you
instance,
watch
it sounds
this,
like it,
every
so
time
you can have this
Dingleberry
discussion,
there
Okay.
objects,
Was there,
you know it's
was
a
there
hole
questions?
It's a hole
Was there discussions with him about
in the
his
case.
Yes, there was.
Everything he objects at.
Did you feel like you knew a lot about the case?
Yes, I did.
Same objection.
Okay. So,
the answer can stand. Go ahead.
all right. So, I want to go back.
So for those of you in Fraser Crane mode, Solomon said, so you are all aware this man is testifying because the DA was fishing for a jail snitch, a highly disrespectful or disreputable behavior by a prosecutor. And I had said when he first got up there, you know, Graveley's just, I mean, how many times has he objected? He's afraid that his sources and methods are going to be exposed. You know what I mean, Jelly Bean? Yeah. He looks like, you know, like a farm boy.
Back in time now to a time when you were in segregation. You call it the hole, right?
Yes.
Do you remember when that was?
Yes, it was January and February till the very beginning of February, most of January of 2022.
And now, can you tell us what the hole looks like just physically when you're in there?
Like a rectangular room, cells that have plexiglass fronts. They're extremely dirty, so you really can't see what's going on. It's
the plexiglass is dirty.
Yeah.
Okay.
But it's very loud. All you can do in there is really talk to one another. There's nothing else as far as books or anything to entertain yourself with.
How in the world did this guy get hung up in that?
And so, how long in a given day are you in your cells?
23 hours.
Okay. When you're in that situation, physically,
hell,
I couldn't tell. Is there just one level? Is there multiple levels? How does it work?
It's 2 floors.
Okay.
Ignore
are
him.
they just in a line, or is it some sort of rotunda?
I had enough of him.
More like a rotunda, yes.
We're on episode, 11 or 12? I'm a triplet mother.
Did there come a time when
I reached my maximum capacity of bullshit?
Found that there was another federal inmate in
Good
the
thing
hole
I
at
do
the same
this
time as you?
for hobby and not for
Who was that?
a living.
Name was Marquand Washington.
What did he go by? What was his name? Street name?
Called him Munch.
So when you were housed in the segregation unit, where was he in relation to you?
I was upstairs in the far corner in cell 22. He was directly across me, also upstairs, but in the opposite corner.
Okay. And were you able to communicate with him?
Yes.
And how is that possible?
Well, the noise carries in there. So it's, you talk at a whisper, you can hear it across the dorm.
And were you talking to him because you knew him before, or because he had a federal case, or what?
I had ran into him before in there, but only briefly. We didn't really know each other. We really just started talking because we both had federal cases, and there's not many people in KCDC with federal cases.
So did there come a time when the discussion between you two turned to him talking about jumping on other people's cases?
Yes.
What did he say when that subject came up?
Essentially, he was giving me advice Because one of the things that we talked about with our federal case is that we're facing so much time. And one of the ways he said that you want to get out of your case, the easy thing to do is to just jump on someone else's case.
Oh,
and I had heard the
that's
term
interesting.
before,
Didn't he
but
just testify he didn't know what that
clarified
meant?
and told me more about how to go about doing that.
And did you ask him about, like, to explain
Anything I
that
can do to
more
help,
to you?
sir?
About how he did
I
it, or
still
how
feel
his
like a
thinking
heel
process?
I
not
didn't
getting
ask
involved
him.
with
He
this
was
sooner.
volunteering his method, I guess you could call it. And he told me what he did. And, you know, he found out information about people's cases and whether it was going through their discovery or just asking them or seeing stuff in the news or newspaper and using that to put
Solomon,
himself into it by informing
pause.
detectives.
Pause. Solomon, your babe child is a boy? Question mark. I just found something that I had made, and it's for a boy. I put it aside. That might have to go in the mail.
That he had information.
Please confirm, somebody.
And did he
And I'll
say
go
what he would
grab
do
it.
if he didn't know something about the case?
He would make something up. He said, as far
Oh
as he
no, I
was
think I
concerned,
miscounted again.
it was his life or someone else's. And he said, you know, he would do that to save himself.
Yep.
So returning to the topic of you, there was some potential mention of you testifying for the prosecution.
Yes.
I mean, you knew something about Zach's case by talking to him, right?
Yes, and the newspapers and news.
Okay. Was that tempting for you?
Yes, it was.
What are you facing in federal prison?
Objection. That's irrelevant.
Nope.
Kind of
That
relevant
means it's
now.
relevant.
What?
It's relevant now.
Telling you. As soon as that Graveley pipes up, you know they're over the target of something.
Oh,
Answer.
I'm facing a 10-year mandatory minimum to a maximum of life prison.
And so the only way out of the mandatory minimum is to do what?
To inform or cooperate with the government.
Interesting.
What's your understanding
Of what
as to
cooperation
what that
means.
takes?
Doesn't take much.
Have you heard the term substantial assistance?
Yes, I have.
I have not.
What's your understanding about who has to make a motion for substantial assistance?
Objection. It's irrelevant.
That means it's relevant.
None of this is happening.
In this case, the state prosecutor, the district attorney.
Well, you have a federal case though, right?
Yes.
And so if you were to testify in a state case, the actual motion would come from the federal government, right?
Objection. That's leading.
It is leading.
Hold on. He's just indicated.
I agree with them. I didn't know how else to get there.
He's panicking. He's sweating bricks.
But it's your perception that if you come to testify for the prosecution in a state case, that is the district attorney that would have to make the motion.
That's leading as well.
Motion?
Or make some sort of assertion.
I'm telling you, make a list of every single time Gravely objects. And that's
I can rephrase.
where you go.
So what is your understanding about, like, which level
Okay.
of government would need
Solomon,
to act on
in
your
my
behalf in order to
opinion-
get under the mandatory minimum?
In my opinion, there's no way that the aforementioned person who was in here dribbling his nonsense for 12 episodes has read that whole entire website. So, in my opinion, don't sweat it. Don't waste your time. It's a diversion. Ignore, if you will. Move on with what's important. Spend your time on getting your brother out of prison. You know, people do that. They divert your attention.
He's asked, that's been asked and answered. He's already said that the state prosecutor filed the motion.
Well, is that really true?
No.
No,
No, it's not, but that's what he's offered the court.
for some,
No, that's it. He has a false understanding.
I don't know the answer, but it would be my impression.
He looks like he,
that the United
you know,
States Attorney
grew up on a
filed
nice
motion
farm.
on
Probably
the
played some football.
recommendations made
That's
by
correct.
the local district
Maybe
attorney.
9-man.
That's correct.
That's not what you asked.
I was trying not to be leading as much as possible. So I can certainly ask that question as a leading question.
Go ahead.
Okay. So it's actually the United States Attorney's Office that files the motion based on its discussions with the district attorney in the case you testified, right?
Yes, it is.
Okay. And you decided to forego that and testify on behalf of the defense.
Yes.
What benefits would the defense, testifying for the defense, offer you?
None. Nothing.
Are there any negative consequences to your testimony here today?
Jack,
Potentially.
purely speculative.
There's another hole.
In this
Noted.
context, I think it's a reasonable.
Honest to
question.
God, every time he
It
objects,
is,
write it down, and you know that's where you go dig.
Obviously, he can't predict the future, but I think he can testify as to what apprehensions, if any, he has. So the objection is overruled.
Yes, I felt very scared about what would come of me testifying for the defense. I realize that the district attorney has a lot of power, and that could be bad for me in a lot of ways.
So you obviously knew Zach for quite a long time, and you've been in KCDC. Did you know him to have any nicknames?
No.
Yeah, he probably did. I hate to surmise what that is. We should add him to the right. Add him to the mail list. Well, I did think John was turning a corner. But like I said, I can only handle so much. I'm not here to make friends. I'm here to find justice. And discuss with my friends. Yeah. I think we should add him to the let's write him list. He probably doesn't have very many friends. I'd like to know how a nice young man like this gets involved in a federal drug.
Did you ever hear anybody call him Houdini?
No.
Did you ever hear anybody call Zach Superman?
No.
Wait.
Have you ever been convicted of a crime?
Yes, I have.
You've been convicted 11 times, right?
Yes, I have.
Oh, how's that possible?
That's all I have.
Cross-examine?
So, Ms. McAtee, I just wanted to be sure I had the details right about what you said on direct. So, if I understood you correctly.
Soloman, I have a question. Have they ever considered doing like a not really a reenactment, but like a visual demonstration of how absolutely insane it is that Rosalio's body was, number one, dragged out or carted out or teleported out of that apartment by one person, number one. Number two, that piddly little square rectangle of carpet that was cut out. Have they ever demonstrated that there's no effing way that a bloodied man rolled up into a small rug would fit in that little teeny tiny little spot? Not to mention all the dirt and dust underneath it? Question mark. Visual aid, if you will. We tried to tell our skeptic about that. We had concluded that perhaps widthwise 58.6 inches, roughly, a 72-inch man would fit in. I mean, there's no way. No way. Demonstrate to me how in the world someone of equal size, if not smaller, with a bad back, don't even factor in the bad back, could lift out of the apartment without drag marks, even if he had a dolly, which we know that that's not true, but I'm just saying. There's no way he got out there of that apartment by one person. And into that little tiny space in the back of that cargo van where everybody says he was while Zach went into Walmart with his clean white shirt on. Yeah, Rosalio was 270. Although I noticed during testimony, both his mother and I believe it was Sadie also mentioned the fact that he lost a significant amount of weight. And it brought him down to approximately, what was it, 230, 225. I call bullshit. I'm just saying. I thought Celia said he lost weight. My point is, we know that that didn't happen. We know there had to have been two people. And I'm pretty sure somebody said earlier, even the mother at one point had said she thought there was two people involved. I think that would be effective. But what do I know? I count beans. I'm an accountant.
Should we call it the hole? Is that the easiest way for you to think about it? But it's actually a dorm. It's called HW, right?
Yes.
Okay. And so you were in it for, sounds like, an extended period of time, like several weeks?
Yes.
Okay. And other people were
There
coming
was no weight by medical
right.
examiner. He was never found.
So if I indicated to you that that jail records indicate that you were in the hole, I'm going to use your phrase, the hole.
I'm going to object if he's basing this question off of jail records. He needs to have some sort of basis for that. He can't just make that assertion.
That's not true. On cross, I'm allowed to describe things, and then he's allowed to adopt.
He has to have factual basis for his inquiry.
Well, he needs to have some sort of basis in the evidence.
No,
not factual.
Okay.
May I go on? So if I indicated to you that the jail records indicate that you and this individual, Mr. Washington, were in that security hole on dates of February 2nd, 2022 through February 5th, 2022. So you indicated you were there until sometime in early February, correct? All right. Would you have any reason to dispute my discussion with you that it looks like you guys had in common 3 days from February 2nd, 22 to February 5th, 22?
That may have been so, yes.
Okay. You're not suggesting that it was a longer period of time that you were with Mr. Washington, are you?
No.
Okay. So this would have been 3 days, about about 15 months ago now? Wait,
yes.
Is that 13 months? I apologize. My bad math by me. Okay. You indicated that your memory was, if I get this correct, you were on the second floor at the far end.
Yes.
Does that sound right? If I told you that was, and you thought it was cell 22, that's what felt familiar to you?
Yes.
Okay. Farthest down you can be on that second floor?
Yeah. Yes.
Okay. And do you remember the numbers that are in the 20s upstairs, or do you remember anything about the numbering system?
I believe so. Most of the 20s, and then on down. Yes.
Okay. And so, if I understood you correctly, this person, Marquand Washington, was also upstairs and was directly across from you. Did I get that right?
I believe so, yes.
Okay. So these discussions would be, I just want to be sure I have this right. So I'm going to approach you, but I don't want to get any closer. Just tell me how far away the cells are when you two are having a discussion. You're on the same floor. Is that right?
Yes.
You have to say yes or no. Okay.
Yes.
So if it's a cell directly across from you, am I right about the right distance that you remember these conversations?
No.
Should I go way farther or closer?
Farther.
Okay. So how about now? Am I about right?
A little further.
Okay. Now you got me paid here, so I'm not going to go quite that far. How am I now?
A little further.
Okay. Now?
A little further.
All right.
Roughly there.
Okay. Judge, can you just give an estimate for the court about what our distance is right now?
From the front of the witness stand. Oh, that is.
You want to pause for another moment? Soloman says, I found it strange that people in Rosalio's circle were willing to change their testimony and their view of the facts of his disappearance in order to make their memories fit Zach as the culprit. You know what else I find is strange? The fact that Sadie and Rosalio were talking about going over, or Rosalio was waffling, going over to break your brother's legs. And Sadie was, laughing it up with them. Really. That to me shows premeditation of, I don't know, some type of bodily harm against your brother. Or what about Brandon and Michael showing up? I'm sure there was no type of, weapon in their possession showing up. And I'm sure they nicely said, hey, man, do you happen to know where my friend Rosalio is? I call bullshit. This could have easily gone the other direction, in my opinion. And there's plenty of evidence to show premeditation towards the bodily harm of your brother. Yeah.
The entire length of the courtroom.
Anyone who can't see that
to the wall behind you
cannot
is
be
53
helped,
feet.
in my opinion.
From the front of the witness stand to the bar, to the bar railing, is 19 feet.
So if I suggested to the court, it's maybe another 8 feet from there.
Mm-hmm.
Does that look around about fair? That I'm about 8 feet from the bar?
Yep.
Okay.
It's probably right.
So 19
And
plus
Solomon,
8
it's
feet,
proof of a crime. It's in a text
27.
message.
So
You get an 8.
What? Rough estimate of
Get
about
an 8.
So Mr. McEntee, this is about right.
Yes.
Okay. And during the time period you were with Marquand Washington, were there other inmates in the hole?
Yes.
Okay.
Solomon, you must have been listening earlier because I purposely used that word colluding, if you will. To commit an act of violence is a chargeable crime. That's like, if you rewind a little while ago on one of my rants, that's exactly the word I used. It's right there in black and white.
So what about on the second floor? Were there other inmates on the second floor?
Yes.
And then about how...
Plus on top of it, like I said earlier, I can see why you people watch this over and over again. There's that text message conversation between Sadie and her bestie. What was her name? Becky. She asks a question about Rosalio, and then there's like a blank, or there's nothing. And the next one was, and what about Zach? So clearly Sadie deleted that message. You're telling me they couldn't have figured out what the deleted message was? Or I don't know. I don't know where I'm going with that.
How many beds or cells are on that second floor? So you guys were 2 of how many, based on your memory of this?
Yeah, that's a good point. Sandra said, I'm sorry, sometimes in my rage, I can't see things very well. Let's see. If I was his mom, I'd still be looking for him. And honest to God, both the judge and Dingleberry here have called him missing.
Somewhere between 3 other people, maybe.
On the top floor?
Yes.
Okay. So it's you, Mr. Washington, and maybe 3 more on that top level?
Yes.
Okay. And so far you're feeling like your memory is Washington is on that second floor, and is he the closest of those 5 to you in proximity?
No.
Okay. So he's across from you, but there'd be people closer away because there'd be cells on both sides of you?
Yes.
Okay. But he's much closer than anybody who would be downstairs, I assume.
Yes, roughly. I mean, someone downstairs
Poppy,
in
I
the
forgot you were in
downstairs
here. I
corner
thought you were a
would be
big giant rat.
almost just as close.
I thought you were a Dingleberry crawling across my floor.
What about the far corner? So in other words, the whole course of the dorm across from you and on the bottom side. Would that be the farthest away from you of the cells?
Yes.
Okay. And you don't know what any of those cells down on the down part are numbered, do you?
1 through 10.
1 through 10. And do you remember? Maybe you do, maybe you don't. Are the numbers in terms of them? Is 1 the ones that would be closest to you? So order.
Yes,
and then
they would be closest to me, below me.
10 would be the farthest.
Yes.
Okay.
Too bad Mr.
If there
Pitbull
are
didn't
10,
have one of
you know,
his
not holding you
schools
to
in the
that, but
neighborhood that
okay.
this young man grew up in. Maybe he wouldn't be in prison.
So from
For those of you that think Mr. Worldwide is just a famous musician, you should watch the interview on YouTube of him with Kevin Hart. It's like 45 minutes from like 4 months ago. Mr. Worldwide has his own set of like STEM schools, kind of, and he puts them in different neighborhoods where there's like a lot of gang activity, because Mr. Pitbull didn't really have the greatest like upbringing with respect to like the neighborhood he lived in. It will warm your heart. Also, you will find out that Mr. Pitbull has F it written on his wrist. It's kind of funny.
that location, and this is where you and Washington are having any conversations you're having about jumping cases, right? You're not having those any other place other than this particular part of the facility.
Well, occasionally when he comes out for rec at night, they have a 1 hour rec where they go in and shower. We have had conversations then too while he was out in the day room.
Okay.
And what he needed.
And that would actually be a rule violation, right? He's not, when you're out in the day room, you're not supposed to be having contact with any other inmates, correct?
Oh, that's not correct.
Oh, you're allowed when you have that hour?
Sorry to interrupt again. I still have on my list somewhere to find that part in the beginning of the trial where the judge mentioned something about sabotage. Like it's a technique. Also, for those of you that watched the Kaylee Anthony 3-part documentary that we watched last night on Rumble and Kick, something I'd heard last night was the prosecution, in that case, the prosecution didn't hand over all the evidence, because as soon as the prosecutor hands the evidence over to the defense, it's eligible to be like FOIA'd. So my question earlier, and it's been kind of a long day, I forget what the answer was. Nick, the Swedish guy with Mr. Jingles that tries to unalive him, and David MLS had answered my question, and I don't remember what their answer was. But I was like, aren't they supposed to hand it all over? I mean, at whose discretion? Oh, I think they said it's at the judge's discretion. Yeah, Nicholas. At the judge's discretion as to what. Well, I'm sorry, but, it's not like everybody's on the up and up here. And who's to decide? It should be a room with 3 people, with somebody from the defense, somebody from the prosecutor, and somebody from the judge looking at the information and saying, okay, well, this is what we have, and this is what we're going to allow you, defense, to take. So at least they're aware of it. I don't know. How is that fair? Are you telling me that Dingleberry here is going to be fair? Sort of, because of the pending appeal, they do not release it all. Okay, what? So you're basically letting this guy here determine what is relevant and what isn't. That is also a gigantic problem, in my opinion. How is that fair?
Or to wander around and talk to people in the cell?
Yes.
Oh, okay. And that was a rule back in 2020? I'm sorry, apologize. In 2022?
I can't say that it was a rule, but
it was permitted.
The guards allowed it.
Okay. So you and Mr. Washington were never cellmates.
Farrell. Hello,
No.
Farrell.
Okay. So, but you talked over this stuff, and it sounded like you bonded on just sort of discussions about stuff, right?
About our cases.
Okay. So, where do you recall where, for instance, where Mr. Washington grew up or where he's from?
No.
Okay. Do you know what do you know about his family? Whether he has kids, those kind of things?
I don't know any of that.
Oh, okay. So your test.
Christy says the criminal justice system is anything but fair, and it's corrupt, and people get rewarded for convictions. That's how prosecutors and judges get reelected. Okay, I'm going to refer back to Dan Bongino. He's been saying now for at least over a year. Is it bad enough yet? Is it bad enough yet? Question mark. Because until it gets to the point where it's bad enough, people are not going to change their voting habits. I try to keep my political stuff out of these trials. I usually do that over on the Rumble side, but in this particular case, unless it gets bad enough, people are not going to change their voting habits. And dingleberries like this guy up here, not this gentleman. You know who I'm talking about, the dingleberry. Get reelected, basically out of default, because people don't pay attention. I didn't pay attention, to be honest with you. I just would, vote the top of the ticket and off I'd go. Give me my I voted sticker and I'm out of here. Not now. Actually, until I got 86th from Twitter with my politics thing. Like, we were back and forth going, all right, for the judges, it's this one here.
Testimony is that
no wonder they banned
Mr.
us.
Washington, not even revealing where he was from or any circumstances about his family, is talking about how you would lie to about other inmates and make a case, correct?
About how to save myself.
Okay. And other inmates are present and would hear those conversations?
Yes.
And Mr. Washington appeared to not be in any way concerned about the idea that other inmates would hear that he was giving you this advice or talking about what he himself would do?
No.
Did he tell you about other cases that he had cooperated on? He must have told you some stories about here's what I did on this case.
No, he didn't get into that much detail.
Well, did he tell you about any times he had cooperated against other people?
No.
You have previously expressed fear that a federal inmate who tells on people, snitches, is in danger. You've expressed that fear before, haven't you?
Absolutely.
Okay. So Mr. Washington would knew the same thing, right?
There's no way he would objection. There's no way that he would know what Mr. Washington would know.
Yeah, he would be. Well, it's speculative as to what Mr. Washington would know or not.
Oh, FFS. Oh, no.
Burst, and I've never communicated to you in any fashion. Is that right?
Not directly.
The DA's office has never met with you, called you, emailed you, sent you anything, correct?
Not directly.
So,
Ooh, tan. Do you do kettlebells, Feral Housewife? Those are my favorite.
and while you have been a federal inmate, back in August of 2021, I'm speaking specifically about August 4th, 2021, you caused fraudulent legal mail to be delivered to you in our jail, didn't you?
I did not.
So did you have an occasion where you had a legal mail sent to you? Your name is Nicholas McAtee, correct?
Yes, it is.
And the sender was a law firm in Sheboygan called Hawley, Kaufman, and Kautzer. Did you have a
I'm going to
legal...
object. I think he's misstating that there's two cases, and I think you're talking about the wrong one.
I'm talking about August 4th, 2021. And I'm literally reading from a document about August 4th, 2021.
I hate this man.
Did you cause to
There it goes
have
with his wing.
sent to you in the mail a legal envelope where the sender was supposedly the law firm of Hawley,
Or the
Kaufman, and
stairway to
Kautzer in
hell?
Sheboygan, Wisconsin?
The stair
I did not
stepper?
cause it,
Okay,
no.
so for those of you who go to the gym, you know what I'm talking about. The stair stepper machine thing. Stairway to hell is what we used to call it. I'm pretty sure everybody has had this experience where you get on it and you know, press the start button and and then you know, hit the speed button and I had one that went rogue on me. And I hit power up and it went jacked up to super fast and I had to jump off of it. I hate this. I always like the elliptical.
Were you the
To get my cardio
person
in.
responsible for
Kettlebells to
devising
get
the
cardio
scheme
too, but
where that legal envelope was sent to you in the jail?
I was not, no.
Well, when confronted with this particular piece of fraudulent legal mail by a Deputy Nicla, N-I-C-L-A, on August 6th, so a couple of days later, when they asked you, were you bringing narcotics into the detention facility, did you smile and shake the deputy's hand and say you've been waiting for this day to come?
Yes.
Okay? And then did you go on to say...
What's nefarious about that?
That you had been having narcotics sent to you in custody in the jail for approximately 10 months.
Someone else was sending me the narcotics, yeah.
Well, obviously you can't send narcotics to yourself when you're in the jail.
Yes.
So I'm sorry, I didn't mean to get you caught up on that.
Oh,
You were arranging to have those narcotics sent to you in the jail, and that had been going on for 10 months, correct?
Yes, I was receiving them, yes.
Okay. And when you were asked how you received these packages, you said they came every 2 weeks, and you would receive a package from and then you indicated lawyer, and they would have narcotics inside.
Yes.
Okay. And you had been previously represented by this Sheboygan law firm that was on this envelope, but they no longer represented you. Isn't that right?
Yes.
And so there was literally a lawyer's name on it that I'm not going to say out loud.
Are they just trying to discredit him now and make him...
who, in terms of this document, was essentially being represented as the person who was mailing you an item that was illegal drugs. Isn't that right?
Yes.
Well, who were you having do this? Who is this individual?
I'm going to object at this point. You did say there was a limit to this inquiry. Normally,
are you kidding me? Dingleberry doesn't have any limits.
Just number of convictions. And so he's asked a question that the court allowed him to.
It's allowed under 90608.
He was getting methadone to get off. Oh my goodness.
And, there's been a variety of
which I
pieces of
suppose
evidence along this line.
Prison healthcare system wouldn't assist him in doing.
You originally asked him if he had orchestrated this scheme, and the witness answered no. So, and I'm not suggesting there haven't been other statements that have been made.
Oh my God, did the defense attorney just lick the pen?
But as a lead up to this question, I think he's actually denied that. Maybe I'm wrong.
Yeah, well, I'm going to ask him about the person who is on the other end of this, so that because I don't want to be left with his answer based on my cross-examination about his involvement in this.
He's already made some admissions about what he said to the deputy, and what the state wants to do now
Drink some more water there,
basically
Dingleberry.
read through the entire criminal complaint and then do it again with the other case. So, I mean, there's a limit to how much probative value there is here, Judge.
I'd like to inquire about all the areas where I believe he's dishonest in this incident, and I'd like to do that on the 2 incidences that I have previewed for the court. And I understand that counsel finds this objectionable, but at this point, I've done nothing that's in violation of the statute, and I'd like to conclude by talking about other ways that I believe he's dishonest in this particular case.
That's another Dingleberry towel.
I will tell you, I don't want you to go through each specification of each complaint. That you can hit the high points.
Yeah.
And you should be able to do that within 2 to 3 minutes.
Well, who is Joshua House who was sending you these items?
That's the person who was creating the packages and putting drugs in there and sending them to me.
What's your connection to him? How do you know him such that he would send you drugs?
I know he does.
He's
it just
a person that I met in prison.
And why would he randomly send you drugs unless you were indicating that this should occur?
Objection. How could he possibly answer that speculative question?
Here's what the problem is. The specific rule that we're working under requires you to take his answer.
Chrissy says, it's disgusting that Graveley can continue down this line of questioning to impeach the witness, but Zach's attorneys were not allowed to ask questions to impeach Sadie and Marquand. Okay, if we did an analysis, just like ballpark, down here, like they just started their defense 30 or so minutes into this day. Look at all the time. I like ballpark. There's like 50 hours up until here. I think I might have actually excluded this. I'm pretty sure I excluded this and part of this. And in comparison, they've got let's just say 4.5 plus 3. 7.5 hours, half of which Dingleberry is sucking up with his bullshittery. Let's just say. I don't know. I'm not going to lie. This defense, when you play with the dirty, what's that thing about like pigs in a pig pen? You got to get dirty if you something along that line. This guy here dwells in a pig pen. You got to get a little dirty to deal with this one. And also, I'm telling you, he's got tells, just like with poker. This guy does.
I am.
If you watch the trial again,
you're not really, because
every
you're
time he starts
challenging him
squawking,
on his
that's
former
where you dig
answers.
the hole.
And we're getting into the mini trial, which is the reason that the rule limits the inquiry to just what is
And this judge's bias is
contained in the
unbelievable.
statute.
Not to
So
mention his mental
asking
nincompoopery.
about specific instances of conduct
It's not a word
is
I
permitted,
understand.
but you're included when he answers. You're not going to be allowed to offer contradictory evidence.
But can I ask questions that probes his answers? I understand I can't talk about contradictory evidence.
That's exactly what the rule is designed to.
Well, well, you know what? It's another one where you're both kind of right. So I'll resolve it by saying you can ask 2 or 3 more minutes of questions. Hitting the high points.
You said that a minute and a half ago, just for the record.
Or you want me to cut it to
A minute and a half. A minute and a half, maybe less.
After having been confronted in August regarding
Can you
the
imagine being
item
married
that
to
I spoke
Dingleberry
about,
here?
did you again? Were you again involved in drugs coming into our jail in December of 2021 by use of legal mail again?
As a party to a
Oh,
crime.
so
I
mail
was, yes.
fraud got
Okay.
involved,
And
maybe?
did you go to the
Or mail?
computer in the area where inmates can do legal work and put together some legal documents and a legal envelope that was created so that it could be sent back to the jail for a local Kenosha attorney to be the individual who sent the drugs?
Yes, I did.
Okay. And so you created what you knew was not a...
I wonder if Dingleberry here had this guy surveilled. Like how soon before this trial did this man here do what Dingleberry is alleging? Poor the hoe. He's trying to hang him on additional charges. You bet he is, 'cause he's a rat. Did you see Lawkong Express's comment? Imagine that poor hoe that had to deal with Graveley. Oh my goodness. He was facing the charges for it. I don't know. That doesn't look like the man that they're portraying him to be, but maybe I don't know.
Truthful piece of mail, right?
Yes.
And there was an actual lawyer's name on it, correct?
Yes.
And the idea was to utilize that document, that legal document, to bring additional drugs into the jail.
Yes.
Okay. And did you recruit a individual who...
For those of you in Fraser Crane mode, Chrissy says, plus saying what Gravely is saying is going to cause problems for him with other inmates, put him at greater risk for being assaulted. Yep. Let's just hope Gravely gets a nice, gigantic cup of the McJustice system that he's so serving out here. I'm sure Satan has a nice toasty warm spot.
who
Waiting.
was a cellmate of yours to be a part of that.
Karma does come and get you,
Yes.
Gravely.
And did that, and then,
Sometimes it takes a little bit of time.
and so were you detected in doing that after the other incident had already occurred?
Yes.
For the records, that was 3 minutes.
Okay, then maybe you
Let's
should have
wrap it up.
spoke up when it was a minute and
And
a
that's-
half.
Let me.
That's
30
directed
years.
to
Yeah, he's
all
rogue.
five of you. If you have a
All right, because I live in the underbelly of the internet world, Solomon just said, Gravely has been operating like this for 30 years. Huh. I wonder what would happen if, sleuthing, those who are good at it. He has not seen comeuppance yet. He will. In my opinion, somehow.
said a word. Nor have
I don't know, it'd be interesting to see. I also want to find out if there's a connection between him, Rosalia's mother, the Facebook girl, Rosalio, prior to all this. I don't know. Just saying, there's some really good diggers around.
wrap it up.
Wrap up cross-examination total? Is that what you mean?
No, I mean, let's
Goes
move
around
on.
Okay, yeah, I'm finished with the complaints. But
Bless you.
have I been lengthy? And okay, I can continue.
No more so than usual.
Thank you.
That's why I was been meaning to look and see how the judge phrased it with that whole sabotage. Solomon says, operating like this for 30 years, the judge mentioned something like sabotage. Like that's a tactic that they use.
I have nothing else for the witness. Thank you, Your Honor.
Let's wrap it up.
Thank you. The incidents that Mr. Gravely just asked you about, what was the drug that was being brought in?
It was Suboxone.
Is that a drug that's used to treat people that are withdrawing from heroin?
Objection, Judge. That appears to be
Oh.
irrelevant.
No, it's not.
What drug was being brought in the jail?
See, I told you that's his tell.
That not to be
As
relevant,
soon as
but
they're over
okay.
the target,
Please.
Okay.
as soon as they're over the target, Gravely pipes up because he knows
It's
he's
the
about to be
objection is sustained.
exposed.
Why did you do that?
Because I'm a drug addict.
So this was feeding your addiction.
Yes, it was. Prior to being locked up, I was addicted to heroin. And so Suboxone assisted me in
Absolutely is
not
relevant.
going through withdrawals. And I had been on it since I was incarcerated.
Those two cases that
And-
were referenced, those were
Sorry to pause. I know we're almost at the end and you're itching to go. But considering what I've heard regarding Zachariah's treatment from the guards, I'm sure the prison probably withholds any type of detox treatment on purpose to further inflict suffering.
were both from,
Boy, that's troubling too.
one was from August of 21 and the other one was from February of 22.
Yes.
I'm going to guess from the dates that the one from February was directly tied to why you were put into SEG.
Objection, Judge. This all is leading.
Over the target, Gravely.
Why were
I
you put
mean,
into segregation in January of 22?
Because I was having drugs sent into the institution.
Okay. So, we covered before about your choice between testifying for the prosecution and testifying for the defense. What would have been required of you if you had testified to your understanding, if you had chosen to testify for the prosecution?
Judge, I didn't ask any questions along this line. It's irrelevant.
That means it's relevant.
I'm
It's
going
the
to sustain the
opposite.
objection.
So why did you chose to testify for the defense?
Same objection.
Different question.
I didn't ask the
Different
question.
question.
I'm telling you.
As I've said before during the trial, I
That's a clue.
do not adhere strictly to that rule.
It's a clue.
Some
That's a
judges do, I
spot.
don't. He can
knows
ask
he's
about
wrong.
it, but it should be a
Enough-
brief
a
examination.
1,000.
Okay. Why did you choose to testify for the defense?
Because I felt like it was the right thing to do, bring the truth out and not do something just to try to gain some freedom.
So after you first learned that both parties wanted you to testify, did you talk to your family about it? Don't tell me what they said, but did you talk to your family about it?
Same objection, Judge.
I don't see where it
Idiot
pertains
Dingleberry.
to the subject of the reason for which I permitted the witness to talk about the whole general subject.
All right. Is everything you testify here true to the best of your knowledge?
Objection, Judge, to ask you to
Not a
affirm.
permissible question.
Do you listen to him?
That's all.
Any question?
Nope.
Those are the
Mr.
most credible
Step
witnesses,
Counsel?
the ones that do it out of the goodness of their heart, because it's the truth.
Did I hear that that was
Versus,
the
shall I
last
say, a
witness for
quid
today?
pro quo?
I believe that's accurate, Judge.
Okay. Anything for the state?
What?
Anything for the state? I know it's not your case right now, but if you told me you have someone who came here from
A witness during their case? Is that what you're
well,
asking?
yeah, if you had brought a police officer in from
Talk about it.
Arizona.
Talk about a nightmare for the jury.
You know what? Everything else happened in this trial, Judge. Why not?
Yeah, no, Judge, we don't have anything now.
All right. All right. So we're done for the third week of the 2-week trial. They're just wonderful. You really are. Not just named it. I hope you have a wonderful weekend. And the end is in sight.
See, there again. The
And,
defense just started today with their
and don't wag
defense,
your head or you'll
and
come up
he's like,
here.
"Oh, the end is in sight."
Please don't
Rush
talk about
much?
previous rewatch or testimony, any account of the trial.
Justice.
And there have been some incidents today in particular that have had aspects that were drawing a lot of laughs. Of course, I don't need to remind you the
Look at the
awesome
big giant dent in
issues
his
that you have
head.
to determine in this case. And bless you so much for your
Yeah.
service to our country. And,
Farrell, him
bless
doing
all
this
each and every one of us as
during the
citizens.
defense
And
case is
everyone,
BS.
You don't rewatch
Yep.
your list when you go on the trial.
And Dingleberry said it the other day while the jury was present. God. Sigh. Well, here we are. Episode, what did I say, 12? Is today episode 12 of the injustice that is the Zachariah Anderson trial. I'll do it again because I didn't smile the first time. What a shit show. All right, so here's your reminder. Oops. It's not on the screen. Hi, June. Yes, you are. We're all done now for today. Actually, that worked out perfect. It's 6 hours, 58 minutes, 34 seconds. Where are we going now? This is live, June, for another 1 minute and 15 seconds. Where are we going now? Who's doing what? Home. If I was a drinker, I'd be pouring a nice tall glass of something right about now. Let's see. Grizzly's on. What does she have on? Oops. Oh. Here, let's switch back to this. I was just saying the other day, I don't know how that happens. Gazella, she... Oh no, I thought it said she was live. Oh, it's over. Oh, Teresa. You know, she's one of those very rare gems who, and she, you know, she lives in the Netherlands. She's so smart. And she's kind. She's, you know, very victim focused, if you will. Huh. I wonder how come. Just bring back the, oh, the art of debate. Play nice in the sandbox. I'm going to delete that one for now because play nice in the sandbox and the art of debate is good for like 10 days. But if you're continuing to litter the same shit over and over again, I reserve the right to say enough. Okay. Alrighty. Well, I don't know where we're going. Soloman, are you going to be interviewed this weekend and tell everybody how your visit with your brother was today? Because I would go there. Don't forget, people, the GiveSendGo fund, the link is in the description. They're only $3,000 away from their $50,000 goal. If you, like me, are having not very much fun in the economic situation right now, you can always share the link and post a prayer. You can also get some stamps and send Zachariah a letter. Pixie said she got a picture. She got a drawing of a snowman from Zach in the mail. EU was redirected to you. Oh, and I'm almost finished. Thank you, EU. All right. Well, I'm not sure where you're going. Yes, thank you, Solomon. I'm going to be on MLS on the 11th. What's today? The 5th. Oh, 6 more days. Hello, hella. We are almost done. We were looking to see where we were supposed to go next. Oh, look at all of your faces. You missed all my swearing. And my anger. Rewind. Rewind 7 hours. You can see me in full rage mode. Now you know all my dark secrets. Okay, since you're here, let's do the orange. Oh, Gosney is streaming. And for those of you who missed it, let's try it again. There. Gosney is... Oh, Steve Gosney is streaming. Okay, so why do I not... I know he's on Rumble. 30 people are watching right now? No. Really? That's why I never look to see. Usually it's just me. Me, myself, and I. 3 people. Let's see here. Oh, dear. I don't know what his channel name is. Benjamin Gray. That's a new name. Welcome. I hope you liked the orange. Oh, and Bobby is here. Hello, Bobby, and happy Friday. Yes, you saw my rage, or those who were here earlier saw my rage make an appearance many times, in fact. A person can only take so much. Am I right? Can I get an amen? All right. Ben is from EU's crew. Oh, oranges confuse you. Orange, you glad you stopped by? I have a small one too, but I can't reach it. Timestamp it. Oh, I don't know where the timestamp is. It's been 7 hours. My back hurts, but my back doesn't hurt near as bad as I'm sure Mr. Anderson's back hurts, sitting in that prison cell. So, here. Soloman. Copy. Paste. Actually, yesterday when I was finished, there he is. Oh, he's like a celebrity to me. Yes, that's where I will be. Yesterday, I noticed right before we were done, I dropped a link for Excited Utterance was doing the, not Natalia Grace, Gypsy Rose. They were interrogating the boyfriend. And I noticed as soon as I hit end and then I grabbed my phone, because you know you come to the kitchen with me, it said, check out this. And it was that link. So even though I can't like redirect you, for me on my phone, it redirected yesterday. Hopefully it'll do it again. Oh my God, he's like a celebrity to me. Steve Gosney. I will be there. Gypsy Rose trial is wild. One thing, there is a HBO documentary called Mommy Dead and Dearest. I've seen it twice. That's the one, actually, when Gazella was live the other day, I posted a comment in her chat that she read aloud. And that one is the one where the dad and the stepmom of Dee Dee said, yep, she got what she deserved. And I think her cousin did too. Apparently there was some suspicion around the death of Dee Dee's actual real mom in Dee Dee's care. So for those of you who haven't seen Mommy Dead and Dearest, I was half thinking of live streaming it on my other computer tomorrow. Well, I was thinking maybe to do it today, but it didn't happen. But if I put it on, it'll go on Rumble and Kick. I thought it was really good. I've seen it twice, so I don't want to watch it, but I could live stream it on there over the weekend if you wanted. I make 10 cents per 1,000 views, so it's a real moneymaker, let me tell you. Alrighty, so I don't have an outro for you. So you get the Zachariah Anderson intro because the outro I think was too loud. And then one more time, let's just pop this in your link. Dun dun. We will continue with the shit show tomorrow. I think I have it for Gypsy Rose content all the time. Yeah, I actually thought I had maybe already done it, but I've done that before. Like if I'm doing a subcommittee hearing and there's a trial going on, I'll put one of the live streams on my computer and one on the MacBook, and I can stream 2 live streams at a time. I just have to set it up. All right, everyone. Have a beautiful day. Hopefully I'll see you in Steve's chat. I really want to get his autograph one of these days. And we will see you for another episode of The Injustice, the troubling trial of Zachariah Anderson. Goodbye for now.